Justice Sales Court. Thereafter, it has gone down to the department.
We are not.
Well, may I permit to mention a matter?
May be permitted to mention, this matter was heard by my lord on 6th of November.
Appeal hearing we are not adding now.
No. It was heard and judgment is reserved. I am led by Mr. Bhaskar Ghosh and
Yes, we have prepared our judgment already.
For my lord's kind consideration, this point has not been included in our law notes. It is Monohar versus Bhupendra. We are
No new point now. No, sorry. Judgment hearing has been concluded. Sorry.
May I have your lordship's kind leave to mention one inclusion of an appeal for admission, your lordship?
Admission, yes. Admission and application. Before the other matters, please hand over. Then we'll clear off this
application.
If order of 41, admission hearing, application, yes.
The application in connection with Group 1 matter.
We have determination.
Group 1.
Yes, all applications.
It's a contempt petition against.
It's an application. Hand over. Contempt application is an application. Please hand over contempt. No, order 41 applications first hand over, then we'll take up the other matters.
Your lordship.
Order for.
এগুলো হয়ে যাক, ফাঁকা হয়ে যাক, all order 41 and applications you have handed over.
Yeah.
My lord.
Make a rocket and throw it. Otherwise you cannot reach.
My lord, may I permit it?
Order 41 applications are over now.
Application.
Lordship, may I have your lordship kindly to mention one?
Applications and order 41.
Application in
Don't
connection
mention.
with the
Don't
in
mention.
connection with the writ appeal, your lordship.
I have a lordship.
Hand over.
Leave, my lord. This matter was due to appear today. My lord is not appearing in the list, my lord.
Other matters will take up later. Order 41 applications over. No further order 41 and applications will be taken up today. Yes.
My lord, I am praying.
As he much more senior to you. Yes.
My lord, may I permit to mention a matter? My lord, before Justice Subhash Bhattacharya, my lord, are taking leave from Justice Subhash Bhattacharya, my lord. The review petition, my lord, is pending, my lord. My lord,
It's before which bench?
Not it, my lord. It is, my lord. Your lordship, when sitting with Proceedings, this is my lord. This, my lord, in Jalpaiguri Circuit bench, my lord. The matter was, my lord, hard and.
This is a contempt application.
One is a review petition, my lord. Review petition.
Review.
Filed by the state.
Whenever we sit together, we will take.
Yes, I mentioned earlier.
There are other matters also.
Yes, I don't.
We are not getting time together.
Yes, so that.
No, we'll start from that side because he was senior. Yes.
Inclusion for Lojima, my lord. One second.
Tribunal application will be listed, my lord.
Applications, yes.
My lord, this matter was due to appear today, my lord. This matter is not appearing, my lord. So, my lord, this. And my lord, another application I have handed over the slip, my lord. My lord, that matter is some urgent, my lord. I have mentioned on
No,
the
applications will appear in the list, then we'll see. Yes.
May I be permitted to mention a matter for restoration, your lordship?
That's an application. Why don't you give the slip?
My lord, it's FAT matter 700.
Yes.
My lord, there are 15 matters, all of which are covered by my lord's judgment in connection with enhancement of the compensation given under section 18 reference. My lord, they can all be disposed of. The state had taken time on the previous occasion, citing that they will.
This will appear as to be mentioned first. This will appear as to be mentioned first. Just give a write in the slip to be mentioned. Write somewhere to be mentioned. Yes.
My lord, pursuant to your lordship's direction earlier, my lord, I have filed and given notice to the other side. My lord, urgency is that.
What is this?
My lord,
under which heading?
My lord, Group 1 appeal.
Appeal hearing.
My lord, I have filed appeal. He not hearing, my lord. My lord, motion stage, my lord. My lord, application.
Hand over.
My lord, urgency is this, my lord.
No urgency. First, it will appear in the list. Then we will consider. Yes.
Leave without certified copy of.
Yes. Granted.
One section 5 application.
My lord, may I be permitted to mention one assigned matter? The matter was assigned before your lordship.
Bench headed by me.
Yes, your lordship.
Hand over. Yes, sir. Please give the heading. Application.
May I be permitted to mention one hearing matter?
Yes.
Hearing matter, my lord.
No. Yes. Call on the list.
Lordship, maybe. Lordship.
To be mentioned.
Permitted to one
Application, yes.
Lordship,
Mention one matter for
Application.
inclusion hearing.
No, hearing.
may be permitted to mention a matter for withdrawal.
Yes. To be mentioned. Right. To be mentioned for withdrawal. To be mentioned within bracket for withdrawal. To be mentioned withdrawal. Call on this. No further mentioning. Yes. Accordingly, FMA 1484 of 2025 is dismissed on contest, thereby affirming order number 2 dated May 17, 2025, passed by the details. Learned Civil Judge. The other appeal is also dismissed on contest. The learned trial judge shall return the plaint to the plaintiff's appellants to be presented before the appropriate commercial court having jurisdiction to take up the suit in compliance with the procedure prescribed in Order 7 Rule 10 of the Code of Civil Procedure within a fortnight of communication of this order to the learned trial court. Can 1 of 2025 in connection with both the appeals are also dismissed accordingly. No order is to cost urgent certificate copies.
Deeply obliged.
Yes, Mr. What is it?
Item number 3, I am not a party to this. What has happened? I am representing the group of persons who were given this land by the government, dealing government.
What is the stage of the matter? Hearing?
My lord, this is a contempt application, Lordship.
Lordship, this is the appeal preferred by the state respondent. Lordship, it is an order of 7th March 2014, wherein the Honorable Court directed that the occupants or the encroachers who were allowed.
2014.
2014 order, 7th March.
Now you have filed a contempt, they're coming up with it.
Lordship, contempt was filed long back. Lordship, they have preferred an appeal. This is, Lordship, he is not a party to the petition. First of all, he is not a party to the petition. That's the first.
Party to the writ petition.
Party, not even to the appeal. Not even, he is appearing for the first time.
Individual party has
First
petition
time.
against the government.
So what are you mentioning then?
Now, Lordship, now, because of the citing this, Lordship, without giving any rehabilitation package, they were trying to dispossess us.
So what is your locus
After
standi?
initiate of this, Lordship, I have no locus standi, but Lordship, I have to apprise it because if your Lordship
What can we
today
do?
passes the order, they will dispossess us without giving me the rehabilitation because we are given this as a part of the when there was the construction of the
What
road.
can we do in a? It's a dispose of appeal.
No, Lordship, this is Lordship.
Direction
Mr.
was
Dhor
given,
is the
appeal is pending.
Lordship. He is the appellant, your Lordship.
What is your locus standi and what can we do at this stage?
No, what is happening?
Apprising
Lordship,
us. This is not a chit chat store.
No, Lordship, what is happening, Lordship, today, because citing this, now DM is telling that there is an order of.
They claim so far. How are you
to dispose
interested?
it. We have filed a separate independent writ petition, my lord,
So
where
move that.
they have been directed to give us the scheme. Now, that is also part of this.
Mr. Chatterjee, there is no scope of passing any order.
No, Lordship,
Order has
this
been passed.
order has this thing. When the order was passed by the Honorable Justice Dashodikari,
You
there
don't
was a
have any locus
specific
standi.
recording.
However, you may be affected, but you have filed a different writ petition. Move that.
I have moved it and there is an order passed, Lordship. Kindly protect that it should not be misused against us.
Can there be such an order? It should not be misused means anything.
Lordship, kindly
What is the
ask them
definition of
what is the
misuse?
rehabilitation package.
What is
It's
the
a part
definition of
the order.
misuse, Mr. Chatterjee?
No, Lordship, in the order, there is a specific
So we
direction.
shall not pass any such vague order. Sorry.
No, it is there in the order.
You know us sufficiently that we won't pass any such vague order.
May I only say?
It may not be misused.
In the order itself, Lordship, kindly see the order. There is a direction that
Lordship.
everything has to be, they will be compensated after
If somebody
giving us
does
the
not comply,
rehabilitation.
there is always the contempt jurisdiction. There is always some other recourse we won't advise you on. So you can do that.
I
But
have
right
tried.
now you have no locus standi. You are not a party to the matter. And what is this?
This is the action taken.
Don't prompt us to go into the merits of the matter. That will
Lordship,
be difficult. Then we have to enter into it and entertain it. We are not entertaining because he does not have locus standi.
Lordship, may I only indicate, your Lordship,
So
where it
this
is
is anger for the state also.
No,
for the
I
Jilla
am
Parishad.
but Jilla Parishad.
Jalapaks. Yes.
Lordship, what the it is the writ petitioner's case where, your Lordship, it was
We
only,
won't go into the merits, Ms. Ghosh. That applies to you also.
No,
Because
Lordship, may I only indicate one thing?
Lordship, it only the
Lordship,
then only
not a party.
I'm not a
And
party.
you have a remedy by you have several applications of different sorts. If that order is being misused, you are saying.
Lordship, what has happened?
You say this order, the order of this court passed in this appeal is being misused in some manner by which you are affected adversely. So you have a cause of action for something else, not in ordering this appeal at this
If
stage.
they
When you
say that order is complied, that would be a wrong understanding, Lordship. They have
say that
promised
before the
that they are
contempt
going
court,
to give us the
go before the
rehabilitation.
contempt court, you move your own writ petition.
Even this order protects me, Lordship. Kindly take this order.
So what can
Original
we
order.
do if the order protects you? We cannot pass any further order in an
Agency
appeal.
of this contempt application may give us some space.
I
So
we
they
don't
are,
understand.
if this contempt application is pending before your Lordship, taking this pendency, that time they were considering some of our appeals that we should be rehabilitated.
So what is your prayer to us?
Lordship, this
What shall you do? What
if
shall we
today, if it is this the if your Lordship today directs this, there is nothing remains, then they will forcefully dispossess us. That is the problem.
No, sorry. You are for which? What is your party's name?
Lordship, we were, there are recording that we were on the land, which was directed to be handed over to the party.
Learned Counsel,
Lordship, in
at whose behest the matter has been mentioned, submits. Learned Counsel, Mr. Chatterjee, comma, at whose behest the matter has been listed under the heading.
No, my lord, I have not mentioned it, my lord.
Then
I have not mentioned
has
it.
mentioned
Since
it.
matter is coming, Lordship,
appearing.
that's why I came. That's why I have not
Coming
mentioned
means
it.
at whose
Lordship,
behest?
it
You
was
have mentioned it.
No, Lordship, it was taken up serially.
Why appearing is to be mentioned today?
Lordship, on the last date, your Lordship directed, since the appellants were not appearing, the state is the appellant.
And appears to argue the appeal.
Lordship may very kindly takes the last order.
Wait.
Lordship. Lordship, Mr. Chatterjee is appearing for the first time today. He is not
I
a
am
party to
appearing
the
for
writ
the first
petition.
time because
He is not a party to the writ petition, not even to this appeal. This is a state appeal.
But I was
and
in that
state
plan.
and the state was directed to
Without
comply
making me
the
the
order.
party, this entire
Outside the
thing
court,
has
both of you fight out. When you're
No,
exhausted,
not
come
fighting.
back. In the meantime, we'll see the order. So, Ms. Ghosh appearing for the respondent, you had said that it has been substantially complied with.
Lordship.
That's why this might have become infructuous in view of the dispute being only regarding costs now.
No,
That was the
Lordship. No,
assumption.
Lordship. That was not my Lordship. The main matter, your Lordship.
You have
2000
recorded, we make it.
Lordship,
clear
Lordship, I'm making my submission on that. Your Lordship, the order was with regard to two parts. One was to rehabilitate, which the state was to take the initiative along with the Zilla Parishad. This is the compliance report which is also filed
You
today.
had the writ petitioners there.
Lordship, it is my land. I'm the writ petitioner. And the
You
encroachers,
prayed for rehabilitation.
No.
Lordship, it was the Honorable Court's direction
Okay.
that those who were forcefully made to stay on my land, upon hearing, upon considering the reports of the BLLRO, the Howrah Zilla Parishad and state, it was found that it is a Rayati land which belongs to me. Thereafter, the Honorable Court directed that they must be removed in 2014 within 6 months. This was the order. Now, your Lordship, thereafter, there was no endeavor taken by the state or the Zilla Parishad to remove them. The removal is not remove, it is to rehabilitate them. Lordship, at that point of time, I had filed one contempt petition. Lordship, thereafter, state has filed this present appeal. Now, unfortunately, state's appeal was dismissed. They had taken no steps to get it restored. Only in the year 2025, they have taken endeavor to restore the instant appeal. And in the meantime, while the matter was appearing before Honorable Justice Boshak, your Lordship, the division bench of Honorable Justice Boshak, they have specifically stated that we were only aggrieved by the cost because a wrong statement was made by the BLRO in our own affidavit. Thereafter, the cost was waived and it was made a submission by the
So
state.
that is recorded and the appeal is disposed of, then
No, Lordship, appeal is still there. And they, on the 17th July, one order is
the
passed.
scope of appeal is, according to them, that this order has been, the writ court's order has been complied with.
Not complied. But
they don't have any grievance regarding that.
They have their grievances only not with the merits,
Costs.
only with cost. So cost was set aside.
Do you agree with that? That your grievance now is with you or the state?
Yes.
Is your the magistrate? You have preferred the appeal.
Yes.
So is your
Challenging only the cost part.
Achha.
Regarding the merit, that encroaches
Cost was
being
imposed
settled-
because there were certain misstatements made by the district magistrate in her.
that
in the appeal?
I need to show from the affidavits The BLLRO has made a statement in the affidavit filed before the writ court that the
We'll put the appeal on the hearing list.
Yes, kindly do
Mr.
that.
Chatterjee will say that you have no locus standi, you pursue your remedies in law.
Lordship, I have
My
filed,
Malad,
Lordship,
in
can
the
I record?
meantime-
I have filed one writ petition, Lordship, which is pending before
That
the
you have said,
single
yes.
bench because divisions bench.
In the
obstruction
meantime, my lord, on several occasions, there was a stay of the contempt proceedings by
So the direction of the writ
division
court was to remove the encroachment.
Lordship.
and also to rehabilitate those encroachers. That is the problem.
Somewhere else.
Somewhere else.
Lordship.
So
So
we
they are
have
the
given them three
those
options.
so-called encroachers.
Yes.
Now discussion is going on, Lordship. Meeting is going on. Meeting was held between the district magistrate.
So how can the
and-
state's appeal be affected on that? If they are now aggrieved with only the costs, we'll hear them on the costs and decide the appeal. And the order then remains in your favor.
Yes, my lord, kindly protect. I am here to apprise
Well,
your
we'll
lordship.
protect them.
In the meantime, my lord,
We'll
kindly
wear armor and go there and
No, I have filed an
in the
independent.
meantime,
your
kindly
physical stature, Mr. Chatterjee, you are more entitled
contempt
to
proceedings.
protect them
I
than
have
us.
filed a writ petition before the honorable single bench. Now, today, if today anything happens before the division bench, that
We
will have
won't
the-
pass any observation which will help you in the writ petition or go against you in the writ petition.
Yes, yes.
My lord, kindly
We
hear
can do
out.
either. Whatever observation you are seeking, that you are fishing out for that observation, Mr. Chatterjee, which we don't accede to.
No, I will not.
My lord, kindly, my lord.
So we'll put the appeal
Yes.
fairly at the top of the list because it's only on costs now.
Yes.
Lordship.
My lord can fix the appeal, and my lord, in the meantime, my lord, they should not proceed with the contempt proceedings.
Lordship, no, no, no.
My lord, kindly hear me. My lord, Mrs. Ghosh has, my lord,
We
perhaps
have a right to proceed with the contempt proceedings.
Kindly.
How can we interdict the
Well,
contempt proceedings?
on last 3 occasions or 2 occasions, the honorable division bench has stayed the concept.
Regarding the
Yes.
costs only.
Yes, my lord, in this appeal.
So
kindly.
that was for a limited period.
No, my lord, yes, initially for a limited period, then thereafter
Lordship,
it was
kindly
time
takes
to
the
time
orders.
extended. My lord, kindly come to
Kindly
the,
takes the orders.
kindly come to the order of my lord, the honorable division bench. Justice Prapubroto Chakraborty, my lord, sitting with Justice Ritobroto Mitra.
It was stayed
My lord,
till
the
a certain
division bench
period.
has, my lord,
Thereafter not
categorically held
extended.
on several occasions. It was extended.
Your contempt is only on the non-payment of costs
No,
or the
no,
entire
no,
thing.
no.
We won't say that.
For relocating and for handing over my land.
You tell the contempt court that we have fixed it on
Lordship,
a,
this-
as a specially fixed matter. We can admit.
My lord, kindly-
They have
for my
filed their
satisfaction,
compliance
kindly-
report
We won't
there.
satisfy. We won't
They
satisfy.
have already
Kindly
filed
have a
their
look.
We won't
compliance
satisfy
report.
you.
The coordinate bench
We
has.
do not intend to satisfy you.
Yes. Lordship, may only say one thing.
Not neither you. Yes.
5 seconds.
Learned. আচ্ছা যেটা বললাম ছেড়ে দিন। Mr. Chatterjee, learned counsel appearing appearing for some of the alleged within double inverted encroachers on the disputed property, submits that any order passed disposing of the appeal on the finding that the order has been complied with would directly and adversely affect the interests of his clients. Full stop next para. As such, it is submitted that appropriate orders may be passed protecting the said so-called encroachers. Full stop next para. Ms. Ghosh, appearing for the respondents in the appeal submits that the tenor of the order of the learned single judge impugning the appeal was primarily to remove the encroachers on the disputed property, which belongs to the respondents herein, and to rehabilitate them, as well as imposing certain costs for purported misstatements made by the district magistrate.
No, by the concerned BLLR.
By the concerned BL and LRO. Full stop next para. Mr. Dhor, learned senior advocate appearing for the state submits that the appeal, the challenge in the appeal is primarily confined to the element of cost, since the appellants have certain submissions to make to the effect that the imposition of cost was not justified, since there was no deliberate misstatement on the part of the concerned BL and LRO. Full stop next para. At this stage, we find that the clients of Mr. Chatterjee, the alleged encroachers, have not preferred any appeal before us. Full stop. As such, we cannot pass any orders either way at the behest of his clients, since they are not even parties to the writ petition, comma, nor are the parties in the appeal. Full stop. Next para. Since Mr. Chatterjee further submits that his clients have taken out an independent writ petition, comma, we do not comment on the respective rights of the parties in the said writ petition, and the said so-called encroachers would be entitled to pursue their remedy there. Full stop. Next para. However, comma, insofar as the appeal is concerned, comma, since both sides submit that the bone of contention in the appeal has boiled down to the imposition of costs, comma, we find that the conspectus of the hearing would be brief and direct the matter to be listed tomorrow under the heading specially fixed matter in bracket hearing.
Lordship, tomorrow I'm in some.
Tomorrow it will appear, but we won't be able to reach.
Lordship, tomorrow I'm in some
It
difficulty.
will appear, but we might not be able to reach.
Lordship.
যা বললাম তাই স্পেশালি ফিক্স
Grateful.
গ্রেটফুল নেক্সট
Not I appeal for the respondent. This
did you had mentioned the matters? Yes.
Only for extension of the period of mediation, my lord. Justice Shane, my lord, the honorable division bench, my lord, directed the matter to go for
mediation. How long would be better? It has been already. It is.
Yes,
it has,
we have given a proposal also.
Who are the mediators?
One of Justice Madhumati Mitra, retired.
So how long do you require?
6 weeks.
6 months.
6 weeks. 6 weeks.
6 weeks.
I
Mediation,
think
there's a timeline also. 6 weeks.
Yes, because we have given a proposal also. It's up to them to revert. My lord, if they revert, my lord, it can be solved in one day itself. One sitting.
Learned counsel for the parties submit that the matter was sent to mediation by a coordinate bench. Full stop. Since talks of mediation are at an advanced stage but have not been concluded as yet, comma, an extension of time to conclude the mediation is sought. Full stop. Next para. Accordingly, comma, keeping in view the circumstances of the case, comma, we extend the period for conclusion of the mediation for a period of 6 weeks from date. Full stop. It is expected that the mediation would be concluded within that period and culminate either way. Full stop. In the event the mediation fails, comma, liberty to the parties to mention the appeal for inclusion in the list for hearing. Grateful. Thank you.
Let's hope it's settled now.
Yes, absolutely. Mr. Mitru, whoever is appearing with you, please just ask to please give the appearance. And you also. Yes.
Number 5.
5.
5, my lord, this is my appearance.
Yes, Mr. Meena. Seeing you after a long time. Yes. Yes. No, Mr. Shamul, I have seen regularly. Yes. What is the matter? Second appeal, yes.
But,
both courts?
Yes, madam.
Yes.
For declaration, injunction, and recovery position of 63 square feet, that is a 3 feet passage, my lord.
You are the plaintiff in the
I'm
court.
the defendant. My lord, plaintiff filed the suit.
What is the declaration granted?
Declaration that passage belongs to them
Exclusively.
exclusively.
You say it's a common passage.
Yes, on the basis of a Shalishi Sabha resolution. That was disbelieved by both the.
Does it have a
court.
binding effect?
My lord, I'm relying on a decision, my lord.
Cite it. Start with that. So that is the tenor of the judgments mostly. The Shalishi Sabha has been
Yes.
because Mediation Act, the relevant chapters have also not come into force.
I'm relying on section 2D of Indian Contract Act.
Not disbelieved means the veracity of the document has not been believed. Or it has been held that it is not, it does not have binding force.
Not have binding for it was disbelieved since, my lord.
Achha, let us see the law first, then we'll go there.
Yes.
Contract Act আছে দিয়ে দিন ওনাকে ওনাটা ফেরত দিন
My lord, another contract.
no we have to don't show us Contract Act yes 2 what is there in 2 yes sir
Section 2D এই দেখালাম এটা কোনটা এটা নয় এটা
yes place it
it is held by this honorable Supreme
no
Court.
section 2 you said Contract Act
Section 2D specifically.
Read it out for us, then place the judgment.
When at the desire of the promisor, the promisee or any other person has done or abstained from doing or does or abstain from doing or promise to do or to abstain from doing something, such act or abstain or promise is called consideration.
So in your case, what is the consideration and what is the main act?
The consideration is this, my lord. They have promised 11 years back.
1997.
That
11 years back, they have promised by way of that Shalishinama, and it has been acted upon, my lord.
that promise was that it will be permitted to be used as a common passage.
Yes, my lord.
It was restricted to you and them, or generally they would use it to be. You two were parties there in the Salishi.
Purchase the property, my lord. It's a chunk of land. We purchased the property. My passage was in between from their house. So there was a dispute prior to that.
So you did not seek a right of easement or something of that sort. Easement of necessity.
There was a counter claim for specific performance of contract. I have also paid a counter claim. That is also pending in the lower appellate court as of today, my lord.
Well, so the judgments?
My lord, judgment, my lord. This
Don't show too many.
Judgment is important. Promise to consideration.
It is reported in
consideration.
Principle basically covered. It's also governed by the principle of estoppel probably, Mr. Mina.
Yes, madam.
In a sense, promissory estoppel, right? Absolutely.
Lord,
Yes.
Para 18, my lord. Page.
Give the full citation to Mr. Shaul, Mr. Mina.
AIR 1966, Supreme Court 193.
Para 18.
Para 18, my lord.
Yes.
It's a three judgment decisions, my lord. It was held, my lord. The relying on this observation, the learned counsel commented that the learned judge held that a mere transfer or interest in favor of another was in itself a transfer for valuable consideration. To accept this argument is to ignore the elaborate discussion that preceded the said observation and the relevant extract from the judgment. We have extract earlier in this context the preceding discussion that the said observation can only mere the transfer in favor of a charity in discharge of the earlier obligation to the transfer for valuable consideration. Agreeing with the High Court, we hold that there was a transfer of mortgage interest under Exhibit A1 in a trust to a charity in disagree of an earlier observation undertaking by the family to set apart a sum of rupees such and such in favor of charity under para B of section 9 capital A 10 within Roman 2 within bracket of the Act. To attract the provision of transfer shall be a valuable consideration. The short question therefore is whether a transfer in a trust of a property in discharge of an earlier obligation was a valuable consideration within the meaning of para B of section 9 capital A such and such of the Act. To state there can only one answer. The classic definition of the valuable consideration, it is given in Carrier versus Michel, reported in R 1875 EX 162. Thus, a valuable consideration is the sense of law.
So what did you forego or give them? What do they get from the contract, Mr. Mina? You say they have promised to abstain from restraining you. But what do they get in return? What is the consideration you pay?
They have constructed the house.
The construction here, you cannot reverse you are reversing the concept, turning it on its head, in the sense that here you are getting the right of passage, right? If you get a right of passage, you have to pay the consideration to them either monetarily or otherwise promised.
I have paid by
you have paid money,
allowing him to construct in my land, my passage. Because their land is in front of us, my lord.
Achha, let us now see any other judgment.
Yes. 1996. And our deed is earlier, 1995. There will be subsequent 1996. My lord.
Same vendor. Same vendor.
Same vendor.
Same vendor gave you that exclusively, but subsequently
changing the master plan. That is also recorded.
But subsequently gave that to them also.
Them also.
Transferred that.
Yes.
Any other judgment?
Yes.
Quick, don't too many, not too many. Order for 10 stage, not too many judgments. How many more?
Right. It is reported in 1975 ILR 1 Calcutta 182.
Yes, this concept we get that it may not be in the form of money, but some promise or some forbearance or something something you give them something. Let us see that Salishinama.
Salishinama.
Should have annexed that to the application, Mr. Meena.
That is not.
That is the plinth of your submissions and you are not annexed. Both the courts will have looked into it. If you have to admit it on a concurrent finding, then you have to look at that document at least. Only one copy. We'll share it. We are supposed to share it, Mr. Meena. This is the only document of which you should have. What is the relevant portion here? Where is your concept? Where is your undertaking to do something? Who is Haldar Babu, them or you?
Haldar, Nihat Ranjan Haldar, they. Responding.
You are Chakravarti?
Yes.
Show us which portion, in which portion you give something. Where is the consideration?
Yeah.
Haldar Babu, ওর প্রস্তাব আমাদের যা বলতে পারেন নিজে যদি আমার জন্য প্ল্যানের জন্য এটা বলছে এটা ও পাচ্ছে মানে এটাও কনসেপ্ট করছে যে ওই পাকা বাড়িটা করতে দেবে was the judgment of the courts. Where do the courts deal with it? At least the appeal court.
Appeal court. Not appeal court basically page 12. No, moment. Page 19 of the appeal court decision.
Exhibit 6 was this document?
Exhibit yes.
No, that's a sanction plan. Exhibit A probably.
Yes. Exhibit F is the Salishinama.
F. Where is F dealt with?
The last paragraph, my lord.
F is not even mentioned somewhere. Oh, X in the previous.
Yes.
This is page 18 actually, yes. On page.
It is further seen on the basis of the observation made herein above regarding exhibit A being the master plan having no value in the eye of law and exhibit A being a photocopy of the chalices is also no support to this case. From overall perusal of the record and on the basis of the observation made by this court, as stated herein above, seen that impugn judgment and degree passed by the learned court does not suffer any illegality or infirmity. As such, the court holds the plaintiff before the learned trial court has to prove their case. Hence, the instant appeal fails.
Why photocopy?
Well, that photocopy was there. That was.
But it was marked as an exhibit.
And they did not.
Can you show us the declaration you sought? What is the exact declaration you sought?
Declaration.
They sought actually.
They sought. But we have short declaration in the counterclaim.
Achha, where is
that
the
counterclaim is still pending.
Ah.
Yeah. Here, short, my lord. We say that the A schedule property is the entire property which belongs to the plaintiff and also
You sought a recovery also regarding
recovery of B schedule property.
B schedule is this passage.
This passage which belongs to me. Your lordship, the trial court has.
Please, don't have a right of hearing. Yes. It is not that claim a question. Case suit,
ক্লেম করছে যে ওইটা পুরোটা হোক, তারপরে ডিক্লেয়ার করা এবং রিকভারি, যেটা আরো ইম্পর্টেন্ট। রিকভারিতে এক্সিবিট এফ দিয়ে করে বলবো যে দুজনের মধ্যে একটা এগ্রিমেন্ট হয়ে গেছে কনক্লুডেড, যাতে ওই প্যাসেজটাকে ইউজ করতে দিতে হবে। সেটা কোর্ট ডিসপ্লেস করছে এই গ্রাউন্ডে যে এক্সিবিট হয়েছে, তাও করবো না, এখন হচ্ছে স্যাংশন প্ল্যানটা এটা তো এখানে এক্সিবিট এটাই এখানে ছিল। It is seen from exhibit A, it is seen that master plan is made by hand. Master plan এগ্রি করছে, এটা এখান থেকে দেখা যাচ্ছে, এখান থেকে দেখা যাচ্ছে হালদারবাবুর প্রস্তাব, ওর প্রস্তাব রাস্তা রাজি করেন, তাহলে আমার জমি প্ল্যান পাস হবে না, জমির দাম ফেরত দিতে হবে, প্রস্তাব দেন। ছাড় এবং আরো 3 ফুট জমি সরকারি ছাড় 3 ফুট দিতে হবে, 3 ফুটটা ছেড়ে দেওয়া তখন মানতে পারেনি ও প্রথমে, কিন্তু এগ্রিমেন্ট হলো কোথায়, তো মানেনি।
Mr. Nina, there is one difficulty against you. They offered that they would give you 3 feet and some portion.
Yes.
You did not agree to that.
Yes, we agreed.
No,
It was
Rita
acted-
Chakraborty,
it was
Rita
acted
Chakraborty
upon.
ওনার ওই প্রস্তাব মানতে পারেননি। এই ক্ষেত্রে উনি বলেছেন রাস্তা পিছিয়ে গেল, ফ্রন্টে 8 ফুট, কমিটি প্রস্তাব দেন 4 ফুট। So it's a decision of the committee.
Committee
এটা ফেরত দিন।
it was a proposal of the committee and it was
You did not agree to their proposal.
agreed to, my lord. We have
Committee cannot make a promise on their behalf. If they had said we'll give you 3 feet. If you had agreed to that or some other thing, there was a further negotiation. You did not agree to anything they submitted. This Salishi committee or whatever, which does not have adjudicatory power, that decided that no, we decide. They have said 3 feet, you did not agree, you said more, 8 feet. They said 4 feet or something like that.
but subsequently
So it's a decision of the Salishi which does not have any evidentiary value.
accepted. Since we have also leave the space, our space, it was accepted for 11
Then it
years.
would go into the domain of estoppel, which is purely factual finding. Why should we disturb the concurrent finding?
My lord, in the both the courts below, my lord, they
That is
have
the
said-
question of consideration here. There was
Here
no
we
agreement between you at all.
we have leaved our space.
There was no agreement.
Here, my lord, my lord, the
Salishi committee decided for you and for him.
yes,
And you might have
For
agreed to
both the
that.
people.
It's a different. Your case is not of estoppel, Mr. Mina, in your plaint. Your argument is not on estoppel. That there was an estoppel, they gave this, they permitted you to use, permitted user. No. You rely on exhibit F and use exhibit A, sorry.
if
F. You say exhibit F is a contract, the consideration passed. The consideration is that they were permitted to build their house and you are permitted to use.
yes,
But we don't see any agreement. Read one portion where you agreed or they agreed. You did not agree.
Regards to, my lord, the
Chakraborty did not agree, Mr.
agreed with particularly 8 feet and 3 feet, my lord. That is the difficulty.
You
Subsequently,
agreed to nothing. When
we
you
agreed, my lord, and for the 11
subsequent agreement is not your case, not
years
reflected
in this, my lord, it was this proposal was
subsequent
accepted.
to this, whatever happened, that case has not been made out.
At that juncture, my lord, we did not agree, but this proposal was passed by.
It's a
the-
story you may concoct
No,
right now.
Lord,
It's
the-
not supported by any evidence, not your case.
My lord, this proposal was passed by the Salishi committee, my lord, and we have accepted that proposal.
That case has not been made out.
After 11 years, my lord, kindly see, my lord, this Salishi Sabha is when made, my lord, and when the case was filed. In 2008, the case was filed, my lord.
Your case is not of permissive user, not of estoppel. Your case is on exhibit F only.
My
Then exhibit A, F, even if there was a promise by them,
my lord,
that promise cannot create by itself a contract. A promise, when met by another promise, accepted, then only a concluded contract can happen. Even if they promised what? They promised to give you 3 feet passage so that you permit them to construct. You did not agree to that. Salishi Sabha took a decision.
Salishi Sabha made a resolution.
Therefore,
my lord,
if
which
your
absolutely
case is,
correct, my lord.
Mr. Mina, if your case is that Salishi Sabha, that resolution was accepted by both of you,
Yes.
that case is not discussed, not your written statement case even.
Yes, my lord. Salishi Sabha, in the written statement, we have accepted.
Where is that discussed? Show us this. You are only on this document.
My lord,
But
which document, my lord?
you are only, your arguments before us is only on Exhibit F.
My lord.
But now you are arguing on something which happened subsequent to Exhibit F that they have, for 11 years, they have accepted. Where is that case made out?
That is what I am saying. It has been acted upon, my lord. The proposal has been accepted and acted
That is
upon.
that case. On evidence, you have to prove by on facts, by evidence that it was acted upon for 11 years.
That, my lord,
Show us from the judgment.
we have filed a counterclaim, my lord. That counterclaim is still pending in the trial court, my lord.
Did you ask for stay of this suit till the counterclaim is decided?
Yes, my lord. Here, my lord, we have.
Not here, before the trial court. Suit was decreed and the counterclaim was still there.
Yes, my lord. Because my lord, counterclaim was dismissed for default, my lord. So we filed an application for restoration. It was in the meantime, this appeal was dismissed, my lord. In the my lord, subsequently that was restored, my lord. That copy of the judgment.
Maybe, Mr. Mina, no substitution. The defendant in a suit for declaration of title to land and property, as well as for recovery of possession, has preferred the present second appeal against the judgment of affirmance. Push up. Learned counsel appearing for the appellant submits that whereas the suit from which the present appeal arises was filed by the plaintiffs on the basis of the title in respect of the suit passage, comma, in defense, comma, the appellant took the plea that there was a salishi within bracket mediation bracket closed between the parties, and the salishi sabha within bracket the mediation committee bracket close came to a decision that certain portion of the property in question will be left for being used as a common passage by the appellant. Push up. Learned counsel submits that such position was accepted by both parties, and for over a period of 11 years, comma, the passage was being used by the appellants as well, without any demur on the part of the respondents. Push up. However, comma, subsequently the suit was filed. Push up. The defendant stroke appellant, comma, it is submitted, comma, also filed a count of claim for specific performance of the contract between the parties. You say that this is the contract F, comma, which is in the form of Exhibit F in the suit, comma, a copy of the minutes of the Salishi settlement. For sub next para, upon hearing learned counsel for the appellant, no, sorry, last learned counsel also relies on division bench judgment of this court in the matter of Namta Diyo, reported at 1975 within bracket ILR 1 Cal 182 bracketed Namta party there, where it was held that there need not be any cash consideration for an agreement to transfer property. First of the transfer would still be valid if the consideration was in the form of a promise by one of the parties. For sub next para, learned counsel also cites the judgment of such and such reported at AIN 1966 SC 193, where the concept was reiterated that a valuation consideration in the sense of law may consist either in some right, comma, interest, comma, profit or benefit accruing to one party, comma, or some forbearance, comma, detriment, comma, loss or responsibility given, comma, suffered or undertaken by the other. So during the course of the day, Mr. Mina, file a copy of that. We'll keep that on record. So next para, during arguments, comma, a copy of the purported Salishinama within bracket Exhibit F, comma, has been handed over to us. First of all, we find therefrom that although the plaintiff stroke respondents had offered to leave a 3 feet passage for user by the appellant, comma, in return of the respondents being permitted the appellant has given বললাম এই কি বললাম সেন্টেন্স whereby
we find therefore that although the plaintiff respondents are often to leave a 3 feet passage to the user of the appellant,
comma, the appellant did not agree to the same. The appellant did not agree to the same and wanted more. Full stop. Ultimately, a decision was taken by the Salishi Shobha that the passage in dispute would be permitted to be used by the appellant. Full stop. Next para. Thus, comma, we do not find any consensus ad idem on the part of the parties enumerated in the minutes of the Salishi, comma, to label the same as a concluded contract between the parties. Full stop. Next para. The learned appellate judge, first appellate judge, comma, while affirming the judgment and decree of the trial court, comma, came to the finding that on perusal of the plan annexed with the sale deed of the on perusal of the plan annexed with the sale deed of the plaintiff, comma, it is seen that the 8-feet passage on the western side of the land of the defendant was sold to the plaintiff by the said promoters on the pretext of change of master plan and on the basis of Salishi, which was marked Exhibit F. But on perusal of Exhibit F, it is seen that the same is a photocopy of the Salishi and the master plan was marked Exhibit A, indicating the position of land. But on perusal of Exhibit A, comma, it is seen that such master plan is made by hand, bracket, in a rough format manner, bracket closed, without scale and without indicating as to by whom it was prepared. And as such, it was also not signed by anyone. Full stop. Next para. Thus, comma, the courts, the trial court and the appellate court disbelieved the said document being Exhibit F. Full stop. Next para. Even if we proceed by accepting that Exhibit F exists, comma, the same does not crystallize a concluded contract between the parties, comma, since there was no agreement as such between the parties enumerated in the same, but only the decision of the Salishi members. Full stop. Next para. Thus, comma, the same does not have a binding effect as a contract. Full stop. In the event the offer of the respondents to leave a 3-feet passage was accepted by the appellant and recorded in the Salishi, comma, we could still apply the principles as enumerated in the cited judgments to the extent that such promise and counter promise by themselves comprised of mutual consideration to arrive at a contract. Full stop. However, comma, in the absence of the same, comma, we do not find any reason to interfere with the findings of both the courts below. Full stop. Next para. The arguments now sought to be made do not find place in the discussions before the courts below, to the effect that what transpired after the execution of Exhibit F tantamounted to an estoppel by on the part of the respondents by permitting user of the passage by the appellant for a period of 11 years. Full stop. Thus, comma, we cannot enter into such third case now being sought to be made out, comma, contrary to the findings recorded in the courts below, and the primary argument of the appellants that Exhibit F is the plinth of a contract between the parties. Full stop. In such view of the matter, comma, we do not find any substantial question of law involved. Full stop. As such, we do not, we shall not interfere with the concurrent findings of both the courts below on facts. Accordingly, SAT 140 of 2023 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Can 1 of 2023 stands dismissed consequentially, no orders to cost. Please give a copy of that agreement right now, as soon as possible.
Since it is pending,
It is made clear at the line. It is made clear that we have not entered into the merits of the counterclaim pending in the trial court at the behest of the appellant, and it will be decided on its own merits in accordance with law by the learned court before whom it is pending.
only the counterclaim is lower appellate court below, because counterclaim was also dismissed. Against that, an appeal was
You have said, not said trial court, you have said the court where it is pending.
But I am making a prayer before Lordship. It is appearing before your Lordship at my behest. But what has happened? I have, in the meantime, misplaced the file below. Your Lordship kindly.
You had
accommodate
mentioned
me
the
for
matter,
this
Ms. Maiti. You had mentioned the matter.
Yes. And today, last week, 2 weeks, I have not, as yet it is not tested out, for
So
this,
we'll put it out of the list for the timing.
your Lordship kindly accommodate me for this week.
For 2 weeks, you have not found the file.
No, your Lordship.
When you find the file, please mention.
Your Lordship.
Counsel for the
Your
appellate.
Lordship, kindly, my kindly.
No.
I shall.
No, we won't block
And
the
your
list.
Lordship,
We won't block the list.
I ask.
Won't block the list.
I requested my rather junior to take his brief, and I shall take it from today.
Why didn't you take it over 2 weeks? She didn't have a brief for 2 weeks.
No.
Could have prepared
He
yourself
was
on
not
her.
He was not here, Miller. He was not present in the Calcutta, Miller. So that is why.
We are adjourning for a day, Ms. Maiti. Prepare today.
Not today, your Lordship kindly make it not today. If it is, I am not prepared.
The prayer of learned counsel for the appellant. Let the matter stand adjourned for the week. Come back next week.
I'm grateful, deeply obliged to you, Lord. Kindly pardon me, Miller, for this, Miller.
No
I'm
question of
sorry, Miller.
pardoning you.
I'm sorry.
It's nothing personal. Seven. এগুলো কি মেনশন করে এসছে? কি দেখি আছে? Despite the matter having been listed on the mentioning of the appellant, comma, none appears at the time of call, full stop. Accordingly, let the matter go out of the list. Same order.
Right, 9 and 10 when I started from my client, I came to know that Mr. Manoj Das informed my client that he is appearing. And
I filed a caveat.
Not given a copy.
No, when the appeal was
Give a copy, come back tomorrow.
Well, kindly take it up Wednesday, tomorrow I will not.
On the prayer of the appellant, comma, let the matter.
I'm giving the copy to
Let the matter stand adjourned till November 12, 2025. Give your copy, take a receipt.
Yes, after filing the appeal, they lost copy.
Yes, that is.
Yes. But I'm giving the copy, Manoj, it is in, yeah?
Yes.
I am for the appellant, my lord.
Yes, Mr. Das, what is the matter?
For declaration of permanent injunction.
Is there any caveat? You are for the other side, he's for the other side?
Yes.
Yes, what is the matter?
Now, my lord, one Partition Haldar was the original owner of 95 shatak of land. After his death, the property was inherited by his two sons, Shufal and Rajbihari. Shufal inherited 40 decimal, Rajbihari 47. We purchased from the former vendor, who our vendor and his vendor. I mean, firstly, the Shufal transferred 33 shatak.
He transferred his entire share.
No, for 33 shatak. 33.
Shufal and the other son, what is his name?
Rajbihari Bhandari.
Rajbihari and Shufal inherited together.
Yes, 48 and 47. Then, my lord, Shufal transferred.
Why 48 and 47?
Yes.
Why unequal?
Unequal. It should be 47.5, but 48 and 47.
My lord, may I just kindly, my lord had passed an order on the last date. Kindly looks into it. My lord will get a hang of the matters. My lord had heard it on the last occasion.
Let us just see it and then come back, Mr.
Yes.
I mean, you stay here. Please take your seat, Mr. Das. You just call upon. Give us 2 minutes. Now, you are the plaintiffs.
Yes, my lord.
Yes. Are you ready with that order for 27?
Yes, my lord.
Filed it.
Yes, my lord. That is can 2.
We'll at least see why you could not produce it, whether there is any feasible explanation there.
My lord, at the relevant point of time, that documents are not with us. The petitioners.
How did you get it now?
They after, my lord, by applying for certified copy of the same. The petition.
You could have done that during pendency of the suit.
Yes.
That you relied on that.
The fact is that, my lord, at the initial time, the sale deed of the vendor of the petitioner, it has been categorically stated how the property has devolved upon the present plaintiff.
Your basis, the basis of your claim, Mr. Das, is that Shufal transferred the property in favor of your vendor.
Yes,
They are claiming by inheritance.
Yes.
Through Shufal and all. So that was the premise of your claim. You had to produce the deed of Shufal. That is the best evidence. Because it starts from there. Subsequent deeds do not mean anything. If Shufal had not given the property, you could not produce the document before the trial court. You can understand. Your suit was dismissed by both the courts below.
Lordship, on the same point.
Achha, if it was we could have understood if it was reversed by the appellate court for the first time. Then we can understand that you might not have had an inkling of why it was relevant. When trial court dismissed the suit on that point, why didn't you make this order for 27 in the first appellate court? Why should he say? Why should he relieve you of the liability under 27 AA?
Yes, my lord.
You are covered by AA.
View taken by the learned advocate that when it has been stated in a sale deed categorically recital portion how property has devolved, and that has not been challenged in a written statement by the defendant, according to learned advocate, it is not necessary.
That
has been
execution was not challenged.
No.
But plaintiff, you have to prove your own case. You stand out.
That's the reason, my lord.
Prove it.
That's the reason. Recital portion categorically stated in the sale deed how property has devolved, who purchased it thereafter, who purchased it after, etc. Now, the point is, my lord.
This is the only document which is relevant. We only both court files. It is undoubtedly relevant. The appellate court requires any documents so like double it over it. Yes, we'll admit the appeal on this one, on your order for 27. The plaintiffs in a suit for declaration and permanent injunction have preferred the present appeal against a judgment of affirmance, whereby both the courts below dismissed the suit on the ground that the purported deed executed by one Sufal Bhandari, the predecessor in interest, the grand predecessor in interest of the plaintiff's, the predecessor in interest of the plaintiff's vendor, in the year 1967, was not produced by the plaintiffs in either of the courts below. Next para. As the plaint case goes, the said Sufal Bhandari transferred his title in respect of the suit property in favor of the predecessor in interest of the vendor of the plaintiffs, and subsequently through the vendor of the plaintiff, the plaintiffs have acquired the property. Plaintiffs / appellants have acquired the property. On the other hand, the defense is that there is no such deed, and as such, the defendants / respondents became the owners of the property by way of inheritance through Sufal. Next para.
Why not inheritance? They have purchased the property. From
purchase,
the other respondent, defendant also purchased.
They have purchased from
Sufal. Subsequently,
from Sufal.
From Sufal Bhandari subsequently after we
from Sufal directly they have purchased.
Not directly. Sufal sold it to some Obud Kumar.
But by inheritance by purchase through the transferee of Sufal.
Lordship.
Next para. At this juncture, learned counsel for the appellants submits that the appellants have filed an application under order for 27 of the Code of Civil Procedure, being Can 2 of 2025. In the said application, the appellants have made out a case that they obtained the certified copy of the deed executed by Sufal only during pendency of the present appeal and are ready to produce the same by way of evidence. A photocopy thereof has also been annexed to the application. Full stop. Next para. A question has been raised by the appellants as to whether the said document should be permitted to be produced under Order 41 Rule 27 at this stage, since the same hits at the very roots of the case and was the ground of dismissal by both the courts below. Full stop. Next para. There are two competing claims which may be advanced by either of the parties on the applicability of Order 41 Rule 27 of the Code of Civil Procedure in the present matter. Full stop. While, on the one hand, the defendants stroke respondents may very well argue that the application is hit by Order 41 Rule 27 within bracket 1 within bracket small a, since there is utter lack of due diligence as a certified copy could be obtained before either of the courts below, particularly since the trial court dismissed the suit on such ground. Full stop. Next para. On the other hand, on the other hand, the appellants might argue that the appellants have argued that the learned advocate of the appellants in the courts below had advised that since the existence of the deed, pleaded in the plaint, has not been specifically refuted or denied in the written statement, there was no necessity to produce the deed, which would obviously be an erroneous advice. Full stop. Next para. That apart, it has to be considered whether the provisions of clause small b within bracket of Order 41 Rule 27 within bracket 1 of the code would apply, since the deed of 1967 is the very basis of the dispute between the parties, and it might be required by the appellate court for a proper and complete adjudication of the LIS between the parties. Full stop. In view of such competing claims, we admit the appeal on the following substantial question of law. 1. Whether the application under Order 41 Rule 27 of the Code of Civil Procedure ought to be allowed at this stage, thereby permitting production of the purported sale deed executed by Sufal Bhandari in the year 1967, by taking into consideration the provisions of Order 41 Rule 27 within bracket 1 within bracket small b of the Code of Civil Procedure. Next substantial question of law. Whether, in view of such document having brought on record, if permitted, the suit should have been decreed in favor of the plaintiff stroke appellants by both the courts below. Next para. Can 2 of 2025. We are not disposing of Can 2 of 2025 because you have a full right of hearing on that.
Absolutely.
At the admission stage, you don't have a right of hearing.
That kindly directs the service of that
Oh,
application.
yeah, definitely. We're doing that right now.
Great.
They'll serve everything. The appellant shall serve copies of the memorandum of the appeal, as well as copies of Can 1 of 2025 and Can 2 of 2025 on the respondents within the course of the day. Full stop. Do it properly. Not like this. You give a receipt for that. They'll give all copies.
Memo and Can 1 has
Memo
already
and
served.
if not already served. Full stop. Next para. Can 2 of 2025 shall, being in the nature of an application for production of additional documents, shall be heard finally along with the appeal. Full stop. In the meantime, affidavits shall be exchanged on Can 2 of 2025. Full stop. Can 1 of 2025 is for stay.
Injunction, my lord, not to disturb me and sell out the property by the respondents.
You are not disputing their possession in the property.
My lord, we are disputing that in whole because what they are claiming to be the
no, possession you are disputing that.
Absolutely, my lord. They do not have possession because
Yes, my lord. Recorded right stands in the
Can 1 of 2025 is an application for injunction. Full stop. Next para. Since a prima facie case has been made out, as well as the balance of convenience and inconvenience is in favor of grant of ad interim injunction, we pass an order of status quo in respect of nature, character, and possession of the suit property till disposal of the application. Full stop. The respondents shall file their affidavit in opposition to the application within. How soon can you file it?
Well, it kindly gives us 3 weeks.
Within a period of 3 weeks from date. Full stop. Reply, if any, shall be filed within 1 week thereafter. Full stop. Liberty to the parties to mention can 1 of 2025 for hearing before the appropriate learned single judge having determination after the above time frame for exchange of affidavits is over. Thank you. Perfect. It was single judge.
When the one defect is there, the trial court judgment degree is not there. I have brought it, may I allow me to file the same? And section 5 is there.
No, we'll permit you to file in the department. That will be tagged. If you have you annexed photocopies of that in the memo?
It was not there. I have the copy of the.
So hand over 2 copies for 2 judges.
Yes.
So these are originals, certified
This is
copy.
the original and this is the photocopy.
Achha. We'll take it on record. That is the only defect, Mr. Rai.
Section 5 is there. Though it is second appeal, my lord, there is practically there is no page. As on this day also.
You have to serve and come back.
Yes, yes, that is why precisely, my lord, I am praying before your lordship.
Learned counsel shall serve copies of Can 1 of 2025 on the respondents, indicating that the application shall be listed under the same heading, that the application along with the appeal shall be listed under the same heading, within bracket order 41 rule 11, bracket double inverted close bracket closed, on November 24, 2025, when an affidavit of service to that effect shall be filed by the appellant.
A revised report may be called for.
Achha, we are granting you liberty to file this. Copy
As your lordship, please.
Liberty is on the prayer of learned counsel for the appellant, liberty is granted to the learned advocate on record for the appellant to file the certified copy and the second judge's copy of the judgment and decree of the trial court in the department. As and when the same is filed, the department shall file the stamp reporter shall file a revised report in that regard. For the timing, serve only for obvious reasons. Yes.
There are 4 defects, my lord. But the 3 defects, I have.
Defendants are
third
occasion,
my lord,
your lordship granted them
yes,
leave, my lord, to correct it.
Yes, my lord. Last occasion, my lord, your lordship directed to correct the defects, my lord. The defect regarding a certified copy, my lord. In the certified copy in the trial court order, the name is correct, but in the appellate certified copy, the name is different, my lord. So until and unless that is
that you cannot do. That will send to the. But
yes, my lord. For that reason, my lord, if you lordship kindly pass an order, we can pay special messenger for.
In your memorandum, you have to correct the names.
My certified copy also the name is different, my lord.
Certified copy cannot be corrected by you.
No, for that reason, if
please listen to us. Yes. If you don't listen, you won't learn. So you have to listen. We directed you, permitted you to correct the memorandum of appeal by incorporating the correct names.
Yes.
Did we?
Yes, my lord.
Why didn't you do that? Insofar as the trial courts, who told you, who gave you, put this notion in your mind that even if the court permits you to correct the memorandum of appeal, you cannot unless the trial court's, appellate court's wrong decree is corrected. Who gave this notion in your head? We permitted you to correct the memorandum of appeal. You know the correct names. You correct the memorandum of appeal. And the trial court's correction, appeal court's correction will be done by that court. We'll do that after hearing whether there is any substantial question of law in your appeal. You cannot stall the appeal day in and day out by doing this.
But then, my lord, kindly.
Right now we are hearing it. It's appearing in the list.
Yes,
no. Have you made the necessary corrections in the memorandum of appeal?
Yes, that I done.
We are hearing the appeal. Move it.
But my lord, I'm not prepared for this today. My lord,
you have not prepared. Your problem will dismiss for default. Will dismiss for non-prosecution then.
Well, only for then tomorrow, man, at least. Because
no.
No. Because I'm in the wrong opinion also.
Or let us do this. Let it go out of the list. We'll direct it. We'll send it to the trial court. We'll direct the executing court to expedite the hearing.
No, man, kindly make it only not today, my lord, only.
These ploys are known to us. We have also practiced for some time, sir. Sorry. No, not before this court. Try it before some other court. Sorry.
Then only for one day, my lord. Tomorrow,
what do you mean by only not today? Why only not today?
Because
you have got several weeks time to correct and come prepared.
I had corrected those things, man. I have the wrong that it was not. Only one day, my lord. Tomorrow, my lord. Whatever tomorrow, my lord.
On the repeated prayers of learned counsel for the appellant, as a last chance to the appellant to move the appeal under order 14 rule 11 of the Code of Civil Procedure, the same is adjourned for the day. It is, however, made clear that in the event the appellant remains, if the appellant remains absent or unrepresented and or seeks adjournment on the next occasion when it is called up for hearing, appropriate orders may be passed in the absence of the appellant.
I beg to appear for the, my lord. plaintiff
Yes,
applicant.
Pratal, what is the matter?
My lord,
No caveat, you are for the respondent.
I am I'm appearing for the respondent number 1, my lord.
Got a copy?
My lord,
Yes, sir.
only the copy of the memorandum of appeal has been served. my lord.
Everything.
There are two
everything-
applications, my lord. It has not been served.
Applications are to be served.
No,
not
no,
the-
everything has been served, I believe.
Condonation injunction, you have not got copy.
Yes, yes. my
No,
lord, I have served.
Are you sure your client has
The
got
letter is saying, my lord, everything and
has
the
returned?
return for the different number 5.
You are appealing for all.
Respondent number 1, my lord.
He's the man.
One has already received. Give another copy.
Yes, I will. I will.
Learned
Every-
counsel for the respondent, file your affidavit of service.
Yes, ma'am.
Learned counsel for the appellant's files affidavit of service. What is the endorsement on that envelope?
Left.
Push up apart from the respondent number 5 contested.
For others, my lord, delivered. It has-
5 contested in the
Yes,
trial.
my lord. Before the trial court, they had
My lord,
contested.
they appeared.
Fresh service shall be effected on the respondent number 5. Push up learned counsel for the appellant shall take instructions from the appellant as to the correct address of the respondent number 5 in the meantime. Push up. However, since service have been effected on, we passed interim orders here.
Yes, my lord. We have.
We had passed.
No, no,
No,
no. no.
there's
Since the service has been effected substantially on the rest of the respondents, 5 contested along with the others in the court.
Others.
Yes, my lord.
Dependent number different. Dependent number 1 is standing, my lord, alone, and others.
However, since service has been substantially affected on respondent numbers 1 to 4 and respondent numbers 2 to 4 contested along with the respondent number 5 in the trial court, we are of the opinion that sufficient service has been effected insofar as consideration of ad interim prayers are concerned. Push up next para. Learned counsel, the respondent number 1 is represented through counsel and the affidavit of service indicates that service has been effected on the said respondent. Push up, however, learned counsel for the said respondent, that is respondent number 1, submits that he is not equipped with a copy of the applications. Full stop. For the ends of justice, the learned advocate on record for the appellant is requested to serve further copies of the applications on the learned advocate for the respondent during the course of the day. Full stop. The matter shall be taken up tomorrow. We have admitted the appeal, no?
No.
Taken up for hearing under the same heading. আচ্ছা, যেখানে বললাম না যে প্রথমেই সার্ভিস হ্যাজ নট বিন এফেক্টেড অন দি রেসপন্ডেন্ট নাম্বার 5
তো সবই রয়েছে।
Until আমি তো ব্যাংকের
সবই।
তারপর কি বললাম?
ওখানে যখন রয়েছে ওখানেও পাঠানো হয়েছে। সব জায়গায় একই পাঠানো। May I, my lord, get the affidavit of service once more? Affidavit service টা একবার দিন। May I take the weight of the, my lord, envelope?
However, since service has not affected on substantially on the rest of the respondents, however, since service has been substantially affected on
Thank you.
না, তার আগের সেন্টেন্সে বললাম যে ফ্রেশ সার্ভিস শ্যাল বি এফেক্টেড অন রেসপন্ডেন্ট নাম্বার 5 বলেছি। ফ্রেশ সার্ভিস শ্যাল বি এফেক্টেড কেটে দিই। এফিডেভিট অফ সার্ভিস থেকে দেখা যাচ্ছে যে রেসপন্ডেন্ট 1 to 4 করেছে। সব হচ্ছে। তারপর যেখানে বললাম হ্যাজ বিন সাবস্টেন্সিয়ালি এফেক্টেড অন দি রেস্ট অফ দি রেসপন্ডেন্টস, একটা জায়গায় বলেছি। তারপরে দেখো যে 2 to 4 contested along with 5, সেখানটা তারপর 2 to 5 contested along with respondent numbers 5, we deem that sufficient service has been effected on all the respondents and the interest of the respondent number 5 is sufficiently represented by the respondent numbers 2 to 4. Full stop. তারপর যা বলেছি। We'll take up the admission hearing along after section 5. If you allow this section 5 admission hearing, the understanding is we may dispose of the appeal altogether. If it's a short appeal.
The weight shows 630 gram. And
that service. No, we have not said. We have said further copy to be served. Yes.
I have served.
Grateful.
Grateful.
Give copies to the itself.
Yes, yes, I will subscribe.
You are IDBI, so you will pay for the photocopies.
My lord, shall do that.
Grateful,
Yes, next. Yes.
I am for the respondents.
Respondent.
Lordship, Mr. Dhutiman Banerjee is appearing in this matter.
Who?
Dhutiman Banerjee. Mr.
So what?
Lordship,
Remove the matter.
praying for a short. I am.
I'll dismiss for default for non-prosecution. There is a section 5 application also.
Lordship.
What is the what is the case in the section 5 application?
Lordship, the previous occasion, your Lordship has directed us to serve the note.
You are appearing.
Appearing, my
You are appearing for respondent number 1 to 3.
lord.
We directed service on 1
There
to
is
3.
a substitution application also.
Oh,
The original, the applicant has died, and
that
for
died.
that,
Very will consider that, but what about this? We directed service on all the respondents. So what about the other respondents? Pro forma respondent have we served 4 and 5? Who are they? What does this arise from? This FMAT is against refusal of injunction.
He also, sir.
Against refusal of injunction. You tell us.
My lord, initially, my
What
lord,
your case? This is against refusal of injunction or not?
refusal, but they have come, my lord, pursuant to the order which has passed upon our application under order 22 rule 10.
So your order 22 rule 10 was allowed.
Allowed.
They are challenging that here.
Yes. But my lord, the thing is that, my lord, against it is a suit for partition originally initiated by my lord.
That is on the merit.
Now, my
We're
lord,
not asking that.
now, my lord, I'm saying, my lord, why it is necessary.
You won't say whatever you like. You will say whatever we ask you. Please wait. And when we hear you exhaustively without asking for that on topics which you have not asked you, rest assured that we are against you. That's why we are hearing you.
We also have filed an appeal, my lord. That is why.
Keep that in the cold storage till this is allowed. Yes. So respondent numbers. Who was the plaintiff in the suit?
Plaintiff,
You are
my
the
lord,
plaintiff.
They are the plaintiff. We are the respondent in lower court.
Defendant in the trial court.
Defendant in the trial court. Sorry.
Very well. So suit is for
Partition.
partition suit. In that suit, who died? Or you purchased from somebody?
Yes. I am the also legal heir, and they are also the legal heirs of the original owner. Not owner, litigant.
No, you claim by inheritance on the demise of somebody.
Yes. Demise of
whom?
my father.
Your
That is
father,
that is
obviously.
one of the co-sharer.
How was he arrayed in the suit? Defendant, one of the defendants.
Defendant.
He was a defendant in the suit.
Defendant in the suit.
He died during pendency of the suit.
During the pendency of the suit.
So why did you prefer Order 20 Rule 10 instead of Order 20 Rule 4?
Because, my lord, after the preliminary degree, we found a gift deed, which was, my lord, executed by my mother, who was also one of the co-sharer, gifting 1/4 share to me. So I bring that gift deed before the landed court, my lord.
Your father is not alive.
No.
Father died during pendency of the suit.
Yes.
So you couch it as Order 20 Rule 10 because you rely on both the mother's share by gift deed and the father's share also on his death, right?
Yes.
So that has been allowed. They are challenging that.
Yes.
Who are pro forma respondent numbers 4 and 5?
The legal heirs of Shekhar, legal heirs of Shankar Prasad Das,
They are
the
also
plaintiff, original plaintiff.
So these two persons are plaintiffs in the suit also.
Yes, my lord. Bharati Das is the, my lord, wife of Shankar Prasad Das.
No,
original
Shetosri and
plaintiff.
Saptarshi.
And
Shetosri.
pro forma respondents are, my lord, their son and daughter. Of my lord, original plaintiff.
Who has now died?
Now died.
No, they were also parties to the suit. How could they be parties to the suit then? If their father was alive? Mother was alive? Oh, acha. They inherited from Shankar Prasad Das.
আমার বাবার নাম কি ছিল? শঙ্কর
কি প্রশ্ন আমার বাবা?
Sukumar Das. He inherited from the Sukumar Das. Sukumar Das was the, my lord, owner of the property. After his demise,
no, Bharati, Shetosri and Saptarshi are all heirs of Shankar.
Shankar Prasad Das, the original plaintiff in the lower court.
So after demise of Shankar, the suit was filed, Bharati and these two people. So they are selling on the same boat as Bharati, in fact. They are all claiming to.
Yes.
So this is regarding service. We are dispensing with service on these two people. At least as regards the condonation application. You are appearing, we'll hear the condonation application is what is the delay? Go through your brief, tell us what is the delay.
In condonation delay, there is a name,
No, let them move their application.
mistake in name.
Mistake in name. What
Name.
is the mistake?
It should be, my lord, Shanti, not Swati Das. Shanti Das, wife of late Shekhar Das.
In the memo also same mistake. Let us see.
Yes, my lord. State আছে আর মেমোতে কি আছে?
Oh, 1 minute.
মেমো পেয়েছি।
The suit is for what? Declaration injunction.
Partition.
Partition, but valued at 100. Suit is valued at rupees 100. Have you got a copy of the plaint? लेकिन की report দেয় বলুন?
অর্ডারে দেখছি না।
দেখুন stamp report report.
You my lord kindly take the my lord page 30 of the stay application. Food value is 20 lakhs. 20 lakhs.
Yes, the
20
stamp
lakhs.
report is bad. Acha, what is the name of the learned presiding judge who passed the order? You have to put that. Yes, Mr. Banerjee. Well defended. The goalpost was well defended till you are there. Now we'll score the goal. Since you have come.
No,
Mr. Banerjee, two things. One is that obviously one of the office reports is incorrect. It says that valuation is wrong. Why have you valued it as 100? It's 20 lakh. If you had valued 100 to avoid court fees, unnecessary partition suit.
No, my lord.
So we'll permit you to correct the valuation of the memorandum to put in the name of the learned trial judge, and this section 5 will take up right now. And regarding this, your learned friend is saying that Swati Das should be Shanti Das.
Yes.
Swati Das, where is Swati Das? In the memo it's written Shetosri.
No, my lord. What I'll just, my lord, indicate here.
Shetosri is not Shetosri.
What happened, my lord, is Shekhar Das, my lord, that is inadvertently, my lord, Shekhar Das died, my lord, prior to my lord filing of this appeal. I'm, my lord, taken out.
No, the name of Shetosri is not Shetosri. They are saying that it's. You have mentioned Shetosri.
Shetosri is, my lord, kindly, my lord, takes up any application. Daughter. Any of the application, my lord. Shetosri is, my lord, the daughter of the plaintiff, my lord, Bharati.
Acha, Swati Das, respondent number 1.
Respondent number 1, my lord, in the memorandum, my lord, it is Shekhar Das. Now, my lord, Shekhar Das died, my lord, prior to filing of this appeal. Now, that is, my lord, inadvertently, as such, my lord, I've taken out an application, my lord, for addition.
Acha, very well. He says that Swati is also not Swati, it's Shanti Das.
Shanti. That is wife of late Shekhar Das.
Shekhar Das, my lord.
So Shanti, what about Shanti? Do you have instruction?
জানি সেটা I'll take instruction on this, my lord.
Shanti.
ওখানে তো সাবস্টিটিউশন হয়েছে তাই তো সেই অনুযায়ী তো my lord, it was, my lord, done, my lord, I my lord, drafted this, my lord, application, my lord, it was, my lord, done according to the substitution application file there.
If that is a substitution application, then that correction was made in the decree. Oh, this is at the interim stage. No, there is no decree as yet.
Yes, my lord, preliminary decree passed.
Preliminary passed. What is the name in the decree? Oh, then they were not there.
They were not there.
So check whether Swati or whatever, Shanti.
Certainly, I'll do it, my lord.
Come back day after tomorrow.
My lord.
Against that preliminary degree, appeal is preferred.
Affidavit of service filed to be kept on record. Full-stop learned counsel for the respondent numbers 1 to 3 are represented. Full-stop. Although no service has been effected on pro forma respondents, comma, we dispense with service on them insofar as the applications are concerned, in view of them being co-plaintiffs along with the present appellant in the trial court. Full-stop. Next para, learned insofar as the defect of maintainability before this court is concerned, comma, we find that the value of the appeal has been mentioned incorrectly in the memorandum, whereas the suit for partition has, from which the appeal emanates, has been valued at rupees 20 lakh. Rupees 20 lakh, comma, the valuation of the appeal has been shown to be rupees 100 only. Leave is granted to the learned advocate in record for the appellant to rectify the valuation of the memorandum of appeal during the course of the day. Similar leave is granted to the said learned advocate in record also to incorporate the name of the learned trial judge in the preamble of the memorandum. Next para, the matter shall be taken up tomorrow under the same heading. Come back
Grateful,
tomorrow.
grateful.
Ask your counterpart in the trial court the name of the learned judge and put it.
Yes,
He'll
yes,
put
yes.
in both things.
Yes.
Name of learned trial judge, valuation.
And
These
my
two.
lord, or Shati or Shanti.
Shati Shanti, yes.
Yes.
No, that leave we'll give you tomorrow and then
My lord.
immediately permit it.
My lord, sir, grateful.
Your friend is sure, so he has good instructions. So it should be
My lord,
Shanti.
Shanti, my lord, Shanti or Swati is his client, my lord. He must be knowing.
That's why he knows. Oh,
He
okay.
must be knowing.
Then just check and
Yes.
tomorrow we'll give you that leave and along with that here with the section 5 appeal.
Grateful, grateful.
Grateful, my lord.
You come prepared on the appeal also.
Appeal. This appeal to that appeal.
Misappeal. This appeal, that appeal means?
My lord, we prefer an appeal that is also pending against the preliminary decree.
This is against what? Remand order?
This is against the
Order 22 Rule 10.
Oh, yes, you say.
Order 22 Rule 10, my lord.
So
that
come
was
prepared on the appeal also. The merits of your case. You are prepared today even. Yes.
grateful, my lord.
Next. Call করেছেন 16 16 who is appearing?
Parthipatin is appearing.
Parthipatin Rai. Mr. Parthipatin. Honor him that much. You are his chamber junior.
Yes, my lord.
Move the matter.
My lord, last occasion it was detected some defect were there. My lord, I have carried out the necessary defect, my lord.
You have carried out.
Yes, my lord.
So move the application now. Move the appeal now under order for.
My lord, it was come as defective. That's why I'm.
Forget that. Move the. What defect was there in the appeal? You are Mr.
Devayan Roy.
Roy. Mr. Roy, what is the defect pointed out?
Yes, one defect was there.
Name of judge?
Value was not mentioned, my lord. That.
Appeal you have stated incapable of valuation.
Yes, my lord. Later I have mentioned, my lord. That is.
Later of?
Later I have corrected, my lord. That is 1,70,000. That is the applicable under High Court, my lord.
Not yet. Not yet. You have not corrected.
The memo, my lord, I have.
Classification of appeal you have corrected. What is the error in the classification mentioned in the Vakalatnama? Vakalatnama is also defective.
No, Vakalatnama, there was written as a FAT. Later I have corrected as FMAT, my lord.
You have done everything else. You have done.
Everything I have done.
See the memorandum still not correct.
Memorandum, my lord.
We have given you the leave.
Yes,
we have given you the leave. Very
well.
well. You are the advocate on record.
I am the advocate.
Do it right now before us. Both judges' copies. করে দিয়ে তারপর শুনবো. Do it as you did previously in the other thing. Put in the valuation, write, amended with the leave of court, sign. Give the date. Quickly. কোনো পার্থক্য চলে আসবে। দরকার নেই আমরা ওই জন্য ওটা পেন্ডিং রেখেছি দ্যাট আর্গুমেন্ট কোশ্চেন বেশ কিছু যদি আসে তাহলে কোর্টে ইয়ে হয়ে যাবে সো যখন দেবে তখন তো অরিজিনাল প্রডিউস করতে হবে যদি পারমিট করবে না পারমিট করবে ডেকে নিন করে
Second judge.
We'll come back in 10 minutes. You have made the corrections?
One I have done.
Both judges' copies?
No, second judge I have done.
Do it. We'll come back in 10 minutes. You have some time. Prepare yourself on the appeal also. We'll come and hear you.
Good.
Even if Mr. Rai comes.
Good.
Yes, Mr. Rai, there is no caveat in the matter.
No, my.
What is the matter?
I have come up against the order dated order number 101, my lord. That is the impugn order, my.
You are the plaintiff or defendant, or what is the suit?
I am the petitioner in the order 21 rule
Who filed the
58
suit
petition.
against which this? Oh, this is an execution case.
Yes, my lord. In execution case,
Who
I
got
as
the
an
decree? You
I
got
as
the
an-
decree.
No, my lord. Judgment data. That is a pro forma defendant.
You are the judgment debtor.
No, my lord. I am the third party. As an objector, I have filed the order 21 rule 58 application, my lord. From there, I have rejected against
Order
the
rule 97 to 101.
58, my lord. Order 21 rule 58.
What is the nature of the decree?
My lord, in execution case, the recovery of money, the property was attached. Well, my learned senior can lead it properly, my lord.
No, if you feel that, then we'll adjourn the matter. First, let us hear you.
My lord, kindly come to order number 101, my lord.
One minute, give us one.
That is the impugn order, my lord.
Yes. Yeah. What is the impugn order? By the impugn order, what was done?
The impugn order, my lord, kindly come to him. That I am the one of the co-owner, my lord.
No. What was done? You filed an application that was rejected, or what has
Yes,
happened
my
by the impugn order?
Well,
Yes, tell us.
well, it was rejected as that I.
What was rejected?
That, my lord, my application, that order 21 rule 58.
But the application itself was rejected.
Yes, my.
If the application itself was rejected, wouldn't it be have the effect of a decree? Oh, that's why you filed
That's
this
the
Miss Abha.
ground.
What is your ground?
The ground, my lord, that I am the one of the co-owner, my lord, without any demarcation. This is the undivided property, my lord. It was attached, my lord.
What is the nature of the money claim by the plaintiff in the suit?
My lord,
On what ground?
well, it will be better if my learned senior.
No. First, apprise us what is the nature of the claim by the plaintiff.
Nature of the claim is, my lord, recovery of money, my lord.
On the basis of what?
On the basis that the property that was attached, unable to pay, my lord, that's why the property was attached, my lord.
That is in the execution case.
Yes, my lord.
When I claim money, there has to be some basis. Either that a loan was taken from me,
Yes,
or
ma'am.
that how did the plaintiff claim entitlement to the money in the suit? What was the basis of the? What is the plaint case? Why do you owe him money?
I don't owe him money, my lord.
Why does the judgment debtor owe him money?
My,
Before answering, please read your papers.
my reading the impugn order, my lord.
No, don't do that. We are doing that already. You read your plaint. They are plaint.
Well, I don't have the plaint with me, my lord. The execution proceeding, I was not a party there, my lord. That's why.
Where is your application under Order 2258?
My lord, that my lord can find in the CAN application, my lord. The impugn order was ordered number 101, my lord.
What is the impugn order? Dated?
Dated 13/5/2025, my lord. Order number 101, my lord. What are the questions?
You are a witness in the suit of your husband.
Yes.
Now you take out order 2158.
Admittedly, the property belongs to two persons, me and my husband.
Co-sharers, no demand.
Co-sharer, no demarcation. Instrument was there.
What was the basis of the money claim?
Transfer. Agreement for sale, willing to transfer the property, person to which my husband took the money. This is a subject matter that was not.
Please repeat that.
Want to transfer the property.
Vendor wanted to now. He transferred actually the property.
No, intended to transfer person to which the money was paid. And when the transfer was not effected, suit was filed for recovery of that money.
The consideration amount.
Consideration.
By the vendor.
By the
Against your husband.
Yes,
because you are the third party wife. So that suit was decreed.
Suit decreed.
Saying that registered deed has been executed.
No, subject matter
To the
initially, my husband intended to transfer the property person to which he took the money from the buyer.
Oh.
And he did not transfer. That is why buyer filed a suit for recovery of that amount. Not for specific purposes of contract, but recovery of that amount. Suit decreed.
No challenge.
Not challenged. Now it is attachment order was passed.
Attachment in respect of his share.
Yes, that is now Mayor can consider whether that has been gone into by the learned executive court. He cannot attach more than this share.
No, cannot.
Here, Mayor, two
only
things.
done to the extent of the.
Yes, Mayor can turn to share that if he logically consider the learned executive court's order to that extent, my lord.
He has made it very clear in the impugned order.
Yes.
That is 101. If you come to the second page of that order.
Yes.
Object has failed to establish exclusive
independent.
That was not your case. Third last paragraph, a joint perusal. Please read from there.
Both sale deeds reveal that the husband and wife, the judgmentator and the objector, had each purchased 9 cheetahs of land from the same vendor to separate registered deeds executed on the same day, which is the same plot number and description. It should be.
So that is an admitted position, recorded position.
As such, the schedule and description of the property in both the sheets are identical because
the schedule is the same. It's only his share.
Accordingly, it is held that the property purchased and held in the name of the judgmentator under the is liable to be attached for satisfaction of the degree. That is precisely the if he is a joint person, I could have understand. Now, my lord, attachment presupposes the sale, whether it will be the share or the property, because my contention is that is why my lord can turn to the ordering portion once. In the light of the facts discussed above, the objective 309 resolution is rejected. The property in question stands in the name of the judgmentator, is held liable to attachment till execution of the deed. The miscase thus disposed of. Now pause there for a moment, and my lord, can you consider what is the schedule mentioned in the.
Let us see that.
Yes, that your lordship will find page 52 of my application, my lord. If your lordship can take up my application.
Page 50.
Page 54. Page 54, my lord, is.
Page 54, yes. This is a schedule of the property.
Yes, this is my application.
All the property. Now, but it says 9 chotas.
Yes, it is my application, my lord. That is why, my lord,
No, we want to see the decree.
Decree copy.
Or the plaint or whatever.
Yes, yes, yes. My lord. But tabular statement আছে? May I hand over a copy of the tabular statement?
Yes, yes, absolutely. That would...
I have only one copy, my lord. Forgive me, my lord.
It should tear it from the middle and share it.
No, my lord, it is my fault. It is my fault. I should have.
এখানে ডিক্রিটা হচ্ছে decree is in respect of B schedule only, not B 1 and 2.
1 and 2.
এখানে ডিক্রিতে রয়েছে 2 ছটাক 0 2 ছটাক বা ওই 19 such and such.
That is the entire 9 decimal.
ওটা এক কাটা 2 ছটাক is equivalent to 0.019.
Yes.
So it has been made clear that it will be only in respect, the execution will be only in respect of the decretal property. Because if you see the order, Mr. Rai,
Yes,
you will find that third paragraph which we are speaking about. Then the next paragraph, as such, the schedule and description of the properties in both these are identical. Accordingly, it is held that the property purchased and held in the name of the judgment debtor under such and such is liable to be attached, which is very clear. Only property held in name of your husband will be attached. Rightly rejected.
Only one that
no case under order to. This is not an independent case. You have a right. That has been concluded here also.
Yes, because the undivided share. That
Undivided share court holds that. But
yes.
since the description is identical out of that 0.9 whatever.
That is therefore, my lord, subject to question, my lord, may I submit before lordship.
Right?
So,
the dismissal. We are not
so for admission on that score, my lord.
We'll give the ground. The ground will be attributed by us will be that court has made it clear, executive court, that whatever property purchase are held.
In absence of partition, the sale of an undivided share can
share only, yes.
That we joint, then my lord, this is directed for joint position. My lord, can you consider in that way also?
But then these decrees will never be executed. I mean, if a money decree, if you have a
It's subject to question, my lord, if the Securitation Act also the provisions are there.
Share can be attached.
Yes, share can be attached.
That is what is being said here. The
Share,
property
but the
purchased and held in the name of.
Yeah, my lord, that is the precisely, my lord, the share can be attached, but it cannot be done without.
No, it's an attachment. Money decree, there is no question of any position.
Then, my lord, sale, then it comes.
Attachment and sale. That will be in respect of that share. Money decree is not executed by taking possession.
Yes, but it implies joint position because the co-shares, section 44 of the Transport Act, if you lordship.
His share will be attached and sold.
Yes.
Whatever is the decretal property, that will be attached and sold, which says such and such share or decimal.
A physical, well, that the
Physical person is, there is no question of physical person in money decree.
No, when it is sale, my lord, subject to question, my lord, if it is sale, then my lord, the position.
His share will be sold. Whatever rights he had, that.
Yes, that is why, my lord, there is a joint position.
No question of position. The rights of a co-sharer will be sold.
Yes.
If that was by itself position, then Mr. Rai, there would not be any section 44, would not be any section 4.
Section 40, that is precisely what I have said, my lord, the section 44 had granted
Rightly
that,
rejected. There is
co-sharer can transfer his share.
It has been clarified by the executive court. Whatever is purchased by you, your husband is.
No. Demarcated.
Yes, what is he saying?
So there is no demarcation. That is precisely.
No, he's right. He's right. There is no demarcation, but
that is what
has been held by the executive court also.
So it
is an admitted question. There is no demarcation.
Yes.
We'll make it clear that executive court has said that whatever property has been purchased by the judgment debtor, that will only be subject to this attachment.
And the
tantamount to a share in the property. We'll say that while dismissing.
And the positive portion, that is the only thing.
Position, there is no scope of any position. They have not sought for position. Do they ask for position in a money?
Sale, probably, the tabular statement
before us.
Subject to question, and
to recover by attachment of immovable property and to sell the same.
Yes, that is precisely what I have
recovered with, if necessary, with police help.
Yes, that is the portion. So unless this is demarcated, there is no question of that is the portion.
Money decree. Let us see whether there is a scope of that.
Yes, sir. Oh, recovery of position, will not find. Recovery, that is precisely, this is why, the objection was raised. Sell and recover.
That the executive court will consider while executing the decree, that whether position can be granted or not. Attachment of.
So the attachment, it can be. There is no dispute about the same order rule 50 is there, 55 is there, 58 is the objection. I am not on that. I am on the basic that whether this sale.
We'll leave it open to the executive court to
record that portion.
Leave it open to for you to take the objection at the time of execution regarding the position component.
Position. Well, may I have a lot going on?
No. Then share your fees with half to them.
Your Lordship.
Yes.
Grateful to your Lordship.
The present appeal has been preferred against an order within bracket deemed decree whereby the appellant's application under order 21 rule 58 of the code of civil procedure was dismissed. For sub next para, learned counsel for the appellant submits that the learned trial judge failed to take into consideration that the present appellant stroke judgment register RESISTOR register and her husband comma the judgment debtor comma purchased respective shares of the decretal property from the vendor. For sub next para, whereas the decree was passed in respect, whereas the money decree sought to be executed was passed in respect of the portion of the property stroke share purchased by the judgment debtor stroke husband, comma, in the tabular statement filed in the execution case, comma, the decree holder has also sought consequential possession, recovery of possession of the property. Push up, it is argued that in the absence of any demarcation between the shares of the present appellant and the judgment debtor stroke husband, comma, there is every possibility that in the garb of possession, comma, the share of the present appellant stroke judgment register would also be usurped by the decree holder by dint of the order of the executing court. Full stop. As such, comma, it is submitted that the appeal should be admitted, comma, as the executing court erred in law in dismissing the application under order 21 rule 58 of the code. For the next para, however, comma, we find from the papers before us that the entire plaintiff case was confined to the property purchased by the judgment debtor stroke husband of the present appellant. Push up, the premise of the plaintiff case was that despite such sale of the decretal portion of the property having been effected in favor of the judgment debtor, comma, the latter did not pay the consideration amount which was recovered by which was to be recovered by the plaintiff stroke decree holder by dint of the suit. Full sub next para. As such, comma, there has been no doubt or iota of hesitance in the mind of the court at any stage of the proceeding as to the exact extent of the decreted property, comma, which is confined to the extent of the share of the judgment debtor and does not extend to the rest of the share in the property belonging to the judgment registrar stroke appellant stroke wife. For some next para, even in the impugned order, the executing court has clarified that the property purchased and held in the name of the judgment debtor under deed number 2161 stroke 1997 is liable to be attached for satisfaction of the decree, comma, thus making it amply clear that there could not be any encroachment insofar as the execution of the decree is concerned, comma, into the share of the self-same physical property which is owned by the present appellant. For some next para, insofar as the apprehension as regards possession in the mind of the present appellant, comma, order 21 rule 54 onwards clearly provides that the mode of execution of a money decree would be by way of attachment and subsequent sale, and thereafter appropriating the sale proceeds to meet the money decree. Full stop. Possession, comma, as such, comma, is not one of the modes of execution of a money decree. Full stop. In any event, comma, the tabular statement seeking attachment and sale and further recovery of the decretal amount, comma, if necessary with police help, comma, does not have any special meaning, comma, indicating recovery of possession of the property. Full stop. In column 11 of the tabular statement made in connection with the execution case, comma, the mode in which assistance of the court is required has been specified to be recovery of the decretal amount with interest and till recovery of the amount, comma, by attachment of the immovable and movable properties and thereafter sale of the same to recover the decretal amount if necessary with police help. Full stop. Although the expression double inverted police help, double inverted clause has been used, comma, none of the statements in the execution case or the tabular statement filed therein indicate any prayer for recovery of physical possession of the property, comma, thus belying the premise of the arguments of the appellant. Full stop. Next para. As such, comma, we do not find any illegality in the impugned deemed decree passed by the executing court rejecting the application of the judgment registrar stroke appellant under Order 21 Rule 58 of the Code of Civil Procedure. Full stop. Accordingly, FMET 389 of 2025 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Civil Procedure. Full stop. Consequentially, one can. Consequently, can one of 2025 is also dismissed. Full stop. There will be no orders to cost. Thank you. Acha, please give a copy of the tabular statement immediately as soon as can we retain this?
Yes, my lord.
Then we'll keep this on the record. No. Order 41 dismiss. Order.
Number 17. In item number 17, as per instruction, I am appearing for on behalf of respondent ICICI Bank. My lord, I am praying for serving copy upon.
There was no caveat.
No, but I'll give a copy. Because
Instruction.
what had happened is ICICI was the owner of the property. Lord, they had entered into an agreement with me, suit for specific performance. They were not selling, so I filed a suit for specific performance, filed application for injunction, had interim order refused, matter was being heard. In the meantime, my lord, they have transferred to, my lord, a third party. Now, I filed an application for substitution, implement and
2210.
yes, 22 Rule 10 and injunction. No, interim order not granted. They are, my lord, they've started demolition. I'll serve, my lord, there are two defects. I'll cure the defects tomorrow, serve them and come back, my lord, if your lordship takes it up day after tomorrow, my lord.
Positive. Learned counsel having instruction to, what is your full name, ma'am?
Somprita B. Chatterjee.
Ms. Somprita B. Chatterjee, comma, learned advocate, appears and submits that she has instructions to appear on behalf of the respondent. So accordingly, the learned advocate on record for the appellant shall serve a copy serve copies of the application as well as the memorandum of appeal on the said learned advocate, Ms. Chatterjee, during the course of the day. The matter shall be listed under the same heading on November 12, 2025.
I think I need your lordship's liberty to
correct the defects. What are the defects?
Yes, I'm told, my lord, that statement is not there as to valuation, which to be inserted, we need leave.
Let us see whether all the defects can be cured by.
And my lord, the second is that the name of the learned judge is not there. That also, if your lordship.
Preamble, yes, that is one name. Second is memo of appeal is bereft of valuation statement.
Yes.
Needs to be classified in words at its head. So memorandum of appeal from original order.
Yes.
Liberties, ja bolam tar songe, liberty is also granted to the learned advocate for the appellant to carry out the necessary corrections to the memorandum of appeal during the course of the day.
Grateful.
Please ensure that both the judges' copies are correct. And your own copy also. And give the corrected copy to them. That corrected copy.
Yes.
Mr. Chaturvedi, you are there?
Lord, I appear on behalf.
No caveat?
No caveat.
Well, what is the matter?
Lord, the defendant number 1 is the appellant before my lord in a suit for partition. The subject matter of challenge is an order of injunction having been granted on the plaintiff respondent's application. Lord, the order says status quo, but I have been restrained. Both parties have been restrained from transferring or alienating the property, suit property. There are two suit properties, Core 1 and Core 1. The admitted case is, my lord, the plaintiff in his plaint says, I shall not indicate, my lord, the relevant portions, that the Core 1 was purchased, my lord, in my name in the year 2006. The only thing, my lord, where I join an issue with the plaintiff is, he says that it has been purchased from his funds.
Benami.
Yes. And he says this in 2020. After 15 years, he says that the suit property is purchased, my lord, from his sources in my name. Blood, we are Uterian brothers. Now, blood, Core 1. Core 1, blood, is a property purchased in the name of, blood, three brothers. Blood, the plaintiff, who is the respondent number 1, the respondent number 2, who is the pro forma respondent, and, blood, the appellant number 1, three brothers. Now, these three brothers purchase a property. He says that these properties, will not, there was an amicable settlement. Blood,
Verbal, oral.
No, written. Well, I have annexed the deeds. Blood, the other two brothers, they give the property in my favor. So I become, my lord, the owner in respect of the entire property, roughly measuring about 23.5 millar decimal. I transfer this property in favor of my wife, who is the appellant number 2. She has been implemented as a party in the partition suit.
So portion of the property you acquired and transferred to your wife, so she is a party.
My lord.
The other portion joint.
No, my lord, this is the entire portion came to me because my portion was with me. My portion was.
Now he says property is in the name of
the three brothers, the settlement. Now he's questioning the settlement, the propriety of the settlement.
All right.
Now, these properties, my lord, I am the recorded owner. I have, my lord, the record of rights in my name. My lord, all these documents, my lord, were produced. But the learned trial judge, my lord, I wonder, my lord, how could he come at a prima facie satisfaction, my lord, with regard to, my lord, the balance of convenience, inconvenience in favor of the plaintiff on the anvil of these given facts. But the rightful owner is being restrained from transferring.
The plaint case was that the amicable deed of settlement is what, unregistered? It's registered.
It's registered.
It was obtained by fraud, or what is the plaint case?
That is what he is trying to make out. And in respect of the other property, where he says that he has sourced the funds, he says it very clearly, and the deeds are here. Deeds.
Sorry. Yes. The completion. Sorry.
These deeds, were before the learned trial court, in my written objection.
No, but they have challenged the deed, saying that it's fraudulently obtained or something like that.
Kindly sees,
What is their allegation?
Yes, kindly, comes to page 12. I would be a little slow in reading. Kindly permit my learned junior, he would be a little fast. Judicial time would be saved.
Do that.
Paragraph 5. Page 12, paragraph 5.
Yes.
বাদী দীর্ঘদিন জমি কেনাবেচার ব্যবসায় যুক্ত থাকায় তিনি বিভিন্ন ব্যক্তির জমির সন্ধান করে তাদের সঙ্গে যোগাযোগ করেন ও জমি ক্রয়ের ব্যবস্থা করেন। খন্নান মৌজায় 3555 হাল 3415 দাগের মালিক শৈলেন্দ্রনাথ ব্যানার্জি জমি বিক্রয় করিতে ইচ্ছুক আছে জানিয়া বাদী 1995 সালে, 1996 সালে ও 2000 সালে দলিল মূলে শৈলেন্দ্রনাথ ব্যানার্জির নিকট হইতে 16.5 শতক সম্পত্তি খরিদ করেন। তৎপর শৈলেন্দ্রনাথ ব্যানার্জি বাবু ওই দাগে তার বক্তি 26 শতক সম্পত্তি বিক্রয় করিতে চাইলে বাদী যোগাযোগ করে 26 শতক সম্পত্তি 22,000 টাকা কাঠা দরে খরিদের জন্য বায়না করেন এবং বাদী দফে দফে ওই 2.5 লক্ষ টাকা বায়না বাবদ আদায় দেন। দফে দফে বায়নার টাকা আদায় দেওয়ায় কাল শেষে বা টাকা আদায় দেওয়ার সময় 2005 সালে শৈলেন্দ্রনাথ ব্যানার্জি প্রকাশ করেন যে তাহার ওই 3555 দাগে 26 শতক সম্পত্তি নহে 30 শতক সম্পত্তি জমি রইয়াছে। ওই অবশিষ্ট 4 শতক সম্পত্তি কিনিতে হবে এবং তার জন্য আরো 50,000 টাকা দিতে হবে। বাদী তাতে সম্মত হন এবং ওই দাবি টাকা আদায় দেন। ওই 30 শতক সম্পত্তি বাদী খরিদ করেন। ওই খরিদের সময় পূর্বের সিদ্ধান্ত অনুসারে দলিলটি 1 নম্বর বিবাদীর নামে। ওই 30 শতক সম্পত্তির সমগ্র মূল্য দফে দফে বাদী তার ব্যবসার আয় হইতে আদায় দেন। 1 নম্বর বিবাদী তাতে কোনো অর্থ থাকে না, শুধুমাত্র জমি কেনাবেচার ব্যবসায় যৌথ হওয়ায় ওই দলিল এবং 1 নম্বর বিবাদী হয়। শুধু তাহাই নয়, ওই 30 শতক সম্পত্তি খরিদের জন্য
3,96,000 টাকা শৈলনাথ ব্যানার্জিকে আদায় দেওয়া হলেও দলিলে লেখা হয় কেবলমাত্র 66,000 টাকা, তা শৈলেন্দ্রনাথ বাবুর কথা মতো। অপরদিকে 1995 সালে 3545 থেকে 6 শতক সম্পত্তি বাদে 1 ও 2 নম্বর নামে খরিদা করা হয়। পুনরায় 35
There's also an element of Benami probably. Benami also.
Yes.
In the plaintiff case, there's an element of Benami also. He says he also gave money, and with that it was purchased with that also.
But his case is that the entire money has been paid by him.
Entire money, or he says 1/3. That's why the partition suit.
No, Lord, in so far as kindly sees,
his plaintiff case in the first prayer is 1/3 share declaration that যথার্থ ঘোষণা করিয়া যথার্থ নহে ঘোষণা করিয়া বাদীর 1/3 অংশ রহিয়াছে. So he claims 1/3, claiming that it was purchased from the joint fund. That is the otherwise there would not be a partition suit.
Yes, I have followed. Yes.
He says 1/3 he is 1/3 owner because he provides some of the funds also.
Yes.
Then Benami can also be one of the, but Mr. Chaturvedi, at this stage, this is at interim stage.
No,
Injunction has temporary injunction. Serve copy and come back will indicate that the appeal and the application will be taken up together. Our prima facie case has been made out in as much as whether the learned trial judge was justified in passing the temporary order of injunction at the behest of the plaintiff stroke respondent number 1 on several grounds. Full stop. Apart from the fact that the claim of the plaintiff might be hit by the Benami Transaction Act, comma, what is the name of the act now? Please provide later on.
Yes, I indicate.
Just have a net search and just provide the.
I shall.
Because it changes occasionally.
Yes. I
Benami Transaction Act. So further, comma, it transpires that no basis has been provided by way of prima facie evidence as to the plaintiff claim that a portion of the consideration for purchase of the property was provided by the plaintiff. Full stop. Next para. Learned senior counsel appearing for the appellant submits that accordingly neither any prima facie case nor any balance of convenience or inconvenience was furnished by the plaintiff stroke respondent 1 for grant of the impugned order of injunction. So next para. The appeal is required to be heard on the above questions and the other grounds taken in the memorandum of appeal. However, comma, at this stage we are not mentioning that. We are not mentioning anything. In view of the questions involved in the interlocutory application being identical with the main appeal, comma, we direct the appellants to serve copies of the memorandum of the appeal as well as scan 1 of 2025 on the plaintiff stroke respondent number 1, indicating that the appeal and the application shall be taken up together on November 24, 2025, when the matter shall be listed under the heading applications. Full stop. The appellant shall file an affidavit of service on the next date of hearing. Stop. Service on the pro forma defendant stroke respondent is dispensed with in view of the pro forma defendant, in view of no relief having been sought against the said respondent. Appeal to admit hole application heading আছে.
Benami Transaction Prohibition Act 1988.
Just give the thank you. No, is that the current name also? There was some change. No, there was some change in the name.
Then, my lord, I shall, my lord, then verify.
You please check up and.
I shall.
If you can find something else, please send it to Mr. Haldar or his junior.
I shall.
Yes.
My lord,
It is item 19.
19.
Respondent, your
disposal.
Expeditious disposal of what? Way, your way. What is the way?
This is the last order by.
What is the way for? What is the relief sought there? In the original application, what is your relief?
My lord, next date only for expeditious hearing.
You have challenged what in the OA?
Annulment of parta is the issue in the order.
When was it filed? The OA was filed when?
2014.
Lordship may kindly recollect. Last order, Lordship, the date was on, kindly see the last annexure of
Oh,
it.
next date was fixed on 3rd November.
3rd November, that's why Lordship was pleased to
What
keep the
happened
matter
on
in
that date?
abeyance.
What happened?
And also personally directed me orally that you also look on that front. So I had to collect the order also. He took time.
Wow. Excellent.
I am paying for fixed date.
Why did you ask for time if you are wanting expeditious disposal?
Representing the petitioner proposes accommodation on the ground of his personal inconvenience.
Why? We will not grant you relief.
My lord, there are two courts. First court after is complete the second court. One judge is sitting. Then not only for.
Tribunal was taking up the matter. You asked for time. Why?
Then I found time for fixed for hearing day to day.
You are asking before this court for us to issue a direction that the tribunal will decide it expeditiously. The next date is fixed before the tribunal on November 3rd. We adjourn it till after that to ascertain whether the tribunal takes up the matter on that day. You go and pray for time on that date. Then your application is, tainted by malafidez. No, we won't grant you any relief. Sorry. Why should we grant direct expeditious hearing? You are asking for time yourself. Why is it pending for so long, Mr. Gali? Have you annexed the order sheet?
Yes, Lordship.
Let us see whether you took time or they took time.
49.4 is the.
Where are the previous orders? 2015 order is there. After that, directly this.
2015 is the order. There was status interim order was granted. Next is page 88, Lordship. Opposition.
No, the order sheet. Yes, opposition.
Yes. Let it be
2015, 20, what about the orders in the interregnum? Who took time? Must have been some challenge before this court against something interlocuted. Otherwise, generally, those are not pending for so long. We produce the entire order sheet.
Yes, order sheet not here.
Yes. Produce the entire order sheet.
But today I.
No, today you can. How can you produce today?
Next day,
29.
What does your client do?
29 July next day. Lordship may kindly.
What does his client do? Business. What sort of business?
This now present gold business coming.
Gold business. You can afford to produce the certificate copies. Produce a certificate. On October 27, 2025, when the application for expeditious hearing was taken up for hearing, we had recorded that since the next date was fixed on November 3, 2025, we would await the outcome of the said hearing and take up the matter today. Today, at the time of call, learned counsel appearing, the ASG.
No, yes.
Senior Government Counsel. Senior Government Counsel.
Advocate.
Learned Senior Government Advocate appearing for the state hands over a copy of the order dated November 3, 2025, from where we find that it is the present petitioners themselves who sought adjournment before the tribunal on the said date. It is unfortunate that the petitioners are blowing hot and cold in the same breath. While seeking an expeditious hearing order from this court, the petitioners themselves sought time despite the court awaiting the order of the tribunal, on November 3, 2025. Thus, apparently there is some suspicion as to the bona fides of the petitioners in filing the present expeditious hearing application. In order to satisfy its conscience, the court directs the petitioners to furnish certified copies of the entire order sheet of the proceeding before the tribunal to ascertain as to how far the petitioners themselves were responsible for the delay occasioned in moving the original application before the tribunal. On the next date, apart from furnishing the certified copies of the entire order sheet, the learned advocate for the petitioners shall also produce a chart to indicate as to the dates, the number of dates on which the petitioners sought adjournment, the number of dates on which the respondents sought adjournment, and the number of dates on which the matter was adjourned for some other reason. You'll form a tabular chart. First column, you sought adjournment on say 24 dates, they sought adjournment on 100 days. Third, for some third reason, strike at the bar or something, tribunal was not sitting, produce that chart. How soon can you produce these things? If you produce those, if you are satisfied that you did not take so much time, we'll pass necessary direction.
Take time, Kaliman.
Certified copy I apply.
4 months, 5 months. How much?
July 2026 date. July.
How long do you want?
1 month at least.
On the prayer of the petitioners, comma, in order to enable the petitioners to furnish the same, the matter is adjourned
At least 1 month. At least.
for a month from date and shall be listed next on December 15, 2025 under the same heading. ये 15 দরকার নেই আজকে তো 10 তারিখ তো ডিসেম্বর 10 2025 10 ডিসেম্বর
Minute 20 and 21, my lord. I beg to appear for the petition.
But I am for the respondents and the original applicants before the tribunal.
So there was a direction on the last date, my lord. Since respondent 14 has expired, so my lord, we are supposed to file one substitution application.
You have filed that.
My lord, we have filed, my lord. It is
no heirs of the respondent.
No, she died unmarried and intestate.
And the name
And
of
rest heirs are already on my lord record, in the area of
Very well.
files.
The original respondent number 14, Srimati Firdousi Khatun, has expired in the meantime, whose it is submitted by learned counsel for both parties that she has died intestate without leaving any heirs. Whose next para, accordingly, can 1 of 2025 is allowed, comma, thereby directing the deletion of the name of original respondent number 14, Firdousi Khatun, from the cause title of the writ petition, which of the necessary consequential corrections shall be effected by the learned advocate for the appellant, for the petitioner during the course of the day.
My lord, legal has already made party.
They are already on record.
No legal heirs এখানে বলেছি, died intestate, leaving heirs and legal representatives who are already parties to the present proceeding. ঠিক আছে? বাকিটা যা আছে তাই. Please make the necessary correction by deleting the name from the writ petition.
And on merit, can I start now?
Yes.
Yes, lordship. My lord, 160, there are two double.
You are ready in the matter, Mr. Yes.
I am for the petitioner, my lord. So 160, my lord, there are two WPLRT petitions. 160 is, my lord, the challenge is against the judgment which has been passed against the original application. And 161 is, my lord, there was a review application. Prior to that, there was a contempt application. So two orders were passed in the contempt application. That is a challenge in 161.
What orders were passed in the contempt? Review is pending.
You come, review dismissed. Review by the state.
Dismissed.
The state lost. Review was filed after contempt filed by the petitioner. Review dismissed. Contempt taken up. Thereafter, two orders. Final order is that you come with the corrected record of rights. No chance to show cause or rule whatever.
Yes. What is the
That is the
main
subject matter 161.
So 160, what is it?
160, my lord, is the order which has been passed in the original application. My lord, in my humble understanding, there are three scenarios, three aspects of the matter. One is there was a BR proceeding. The intermediary was Sadiq Hussain. He challenges in a suit that there was some anomalies in filing of Form B, suit filed by him, Sadiq Khan, the intermediary, Sadiq Hussain. He lost in the trial court, prefers title appeal.
The proceeding was under which provision? Estate
Section-
Acquisition Act.
Estate Acquisition Act. Estate Acquisition Act.
That's very please.
So on the issue of filing of Form B, he filed a suit. Sadiq Hussain, he's the intermediary. Lost in the trial court, preferred appeal. Lost in appeal court also. He comes before the second appeal. In second appeal, he gets a favorable order. What was the decree? Decree was that so far as non-agricultural land and fishery part is concerned, no more vested in the state. Regarding the agricultural part, he is here directed.
Regarding
agricultural land part, he is hereby directed to file a fresh Form B. If he files, you consider in accordance with law. If he does not file, then also you proceed in accordance with law. Now, my lord, not complied with by the state. So, my lord, what
Not
happened?
complied by the state.
Yes, that was not done. He did not file. He filed a defective petition, what lordship. Now, second part starts. So, this chapter of second appellate decree finished in 1970. Now, my lord, the son of the intermediary, one of the sons, Sadiq Hossain, in 1996, he prefers a writ petition that I want compliance of the decree. Now, my lord, in that particular, my lord, writ petition, he gives the wrong title suit number, wrong title appeal number, everything given wrong. Suit disposed of, writ petition disposed of, telling that direction was that you comply with the second appellate decree. But decree, means everything. Now comes the third chapter. In the 2013, another writ filed. This writ, my lord, comes up before this honorable court, single bench. Honorable single bench gives direction that, yes, not only that, he is also to file additional documents, and those documents will be considered by the state. So, simple direction for compliance or decree was, my lord, shunted out. Again, in addition to that, he will be allowed to file some document that will be taken consideration. In view thereof, my lord, compliance was made. He was not happy with the compliance. Contempt filed. The first contempt order says that since the writ petition is telling he is not happy with the compliance, I think some amicable, the honorable judge was of the opinion, I think some amicable exercise will have to be undertaken. So amicable exercise starts. Again, the ADMLR was directed that you give a new reconsideration on the issue. Reconsideration made, amicable exercise completed.
What was the contempt? They did not comply with what? What did they not? What did you not do rather?
According to him, that I filed this B form, but according to the state authority, it was a defective B form.
He filed originally, I mean, in first compliance.
Yes.
Which you said he did not.
Yes.
Achha. So court did not render any finding on that, whether it was defective or not.
No. Said that we said defective B form.
Sorry. Yes.
And that hence it is defective, hence we are dismissing.
What sort of amicable solution? We don't understand.
Thereafter, amicable exercise means you just, lordship, I will.
Must have failed.
Yes. Must have failed.
Then
the moment amicable exercise comes before the honorable single bench was of the opinion that you are not happy with the parent compliance, neither you are happy with that, nor you are happy with the amicable exercise. So what I do is that I am giving you liberty to challenge this particular compliance exercise before the learned tribunal.
what compliance exercise? But what is the scope of an exercise? I mean, there was a previous direction of the same.
That was passed. That pursuant to the liberty petition approaches the learned tribunal. Liberty granted by this honorable court in a contempt proceeding.
Was that liberty first?
That liberty first, lordship. Page, my lord, may I respectfully invite your lordship, my lord, to page, my lord, 48, my lord, of the writ petition. May I read out, lordship? Lordship may read out, lordship.
No, 1 minute.
ভিডিওটা ছিল না
So they were permitted to approach the tribunal against the DLLR order.
Lordship.
DLLR order was against in an appeal against the DLLR order.
DLLR's order was the compliance order. If I may place your lordship, my lord.
Civil court directed DLLR to comply.
No, lordship. The very
What was the occasion of the DLLR?
second writ court.
Second writ court directed whom to consider? DLLR directly.
Yes, lordship.
The civil court's decree
That
was
is the
what?
first
No,
order.
the second appellate court's decree, Mr. Galib, directed whom to comply?
May I place that, Lordship? Kindly seize, my lord, page, my lord. (27), Lordship. Page 27.
Yes.
Lordship, kindly seize, if I may read out the operative part, page 30 onward, at page 30. Kindly see the last paragraph.
Yes.
In the result, the appeal succeeds and is allowed. The judgments and decrees passed by the courts below are set aside. The suit is decreed. The plaintiff to get a decree for permanent injunction restricting the state of West Bengal and officers, servants from taking possession of Schedule B lands. It is also declared that the plaintiff's non-agricultural lands and tank fisheries have not vested in the state. As
B
regards
form is, we have seen it. B form is to be filed before the BLA, Lado.
Yes.
You say they did not file, they say they filed.
Lordship.
So ultimately,
now kindly see the
Banerjee-
first read.
First, it was Justice Banerjee's, it merged in Justice Banerjee's order lastly, which had original
No, first
order.
read was there was some anomalies.
Acha.
Kindly seize, my lord, if I may
Please come to page 48 once, Mr. Gali.
48.
48, 48.
48.
28th August 2015 is quoted there. The first
Lordship.
one order. The
Lordship.
first read.
Lordship.
So that culminates in to have at page 49 it is recorded, be that as it may, to avoid in further controversy, records of rights are to ensure that rights are corrected expeditiously. They are to communicate to the petitioners in clear terms any further documents that may be required. So that exercise was revived, that you would be permitted to they would be permitted to furnish further documents, and if so, you will correct the records of rights in terms of the civil court's decree, second appellate court's decree. This was the last position. Now, what remains after that for you to be done? There is no further exercise involved.
No, my lord,
because second appeal decree stands. They were permitted to file B form.
Lordship.
Initially, there was dispute whether they did actually file or did not file.
Lordship.
First round over.
Lordship.
Second round, they were permitted to file B form. Fresh B form was permitted to be filed.
Lordship.
And along with further documents if necessary.
By dint of the writ court's order.
Yes.
Lordship.
Now, they did file that fresh B form. There is no dispute on that. And may or may not have filed additional documents. We don't know that. They have filed. So now there is no option before you but to comply with the...
My lord, may I respectfully invite your lordship, my lord, subject to your lordship's correction, page 51. The final order in the contempt proceeding. Like kindly seize, my lord, the observation part. It starts 50. However, the fact remains that DL and LRO has passed an order pursuant to this court's order. The petitioner is not happy with such order. They have an efficacious remedy by way of applicant, so and so, so and so. Kindly see the next paragraph. Accordingly, liberty is granted to the petitioners.
Liberty does not create a new cause of action.
No, I'm not. And I'm not that. What was the
what the last position according to you? The second appellate decree was never.
No, my humble submission is that direction was that it will be for the tribunal to decide. Kindly see this particular part. I was trying to show your lordship, my lord. Accordingly, that paragraph starts with accordingly. The sentence starts with accordingly. Liberty
implemented second appellate decree.
Has implemented the second appellate decree of civil code.
Exactly. So second appellate decree is again reiterated. Only to see, tribunal is only to see whether that has been complied with.
That is B form part.
So therefore, there is no question. Yes, the entire thing.
So, my lord, second appellate decree, my lord, is with regard to B form part only, not with regard to correction of record of rights.
All right, yeah.
That is, my lord, my respectful submission is. But what, my lord, the tribunal holds in its original this judgment in the original application, kindly seize, my lord. May I respectfully invite your lordship to the impugned judgment.
But B form, second appellate decree has to be read in as a whole. The suit is decreed plaintiff to get a decree for permanent injunction restraining you from taking possession. It is also declared that the plaintiff's non-agricultural lands and tank fisheries have not vested.
May I show your lordship what was our compliance order?
As regards agricultural lands, they are allowed to file B form. If they file, you will decide that. Yes. Now, what is the DLRO decision? Let us see that.
Yes, lordship.
That is most important here.
That is most important, lordship.
So you have to consider that. And if you have done that, they are to file it before.
So lordship has already seen the writ court's order, first order.
Come to page 46 directly.
Page 44.
46 is the relevant portion.
44 is the relevant.
44 starts.
That is the amicable exercise. But the parent is at page 40, which comes which in compliance of the single bench order of this honorable court. The first complaint comes is at page 40.
Yes.
It starts from
7, order number
page
7.
38. This is final order 7, dated 8th
Order
January.
number 7 is the main.
Yes. Case is put up today. Petitioner did not submit any rectified B form. However, from the available office record, it has been found that 24.69 acres of agricultural land has already been retained by the Vikraya. But due to submission of defective B form, no relief is given to the petition in respect to agricultural land. Petitioner claimed 4.11 acres of non-agricultural land which is entitled to BR proceeding. Verified the office records. It has been found that out of 4.1 acres, 2.88 acres of non-agricultural has already been recorded in favor of petitioner. However, 0.662 acre of non-agriculture which is free from encumbrances will be retained by the petitioner. Petitioners have claimed 12.22 exercise of tank fishery for detention.
No, but it starts with, but due to submission of defective B form, no relief is given in respect of the agreement.
Lordship, kindly
That is
see
the
the
premise.
concluding part. Hence, in view of the above facts and circumstances at page 41, my lord, it is ordered that 0.6.
Compliant with this is a non-compliant compliance. What is this? B form is defective, therefore don't honor that, and no relief is given in respect of the. You start with that. Therefore, where is the question of the retention being considered?
But if the B form is defective, my lord, how, my lord, that can be.
Should have given them another liberty. You should have told them B form is defective. File another B form. You have
Chance
to
was
comply with
given.
the second appellate court
My lord,
order.
my lord, that is why my chance was given. Kindly see, my lord, at the very first.
This is the last question. After this, no B form was filed.
No, the chance was given. Kindly.
This is the non-adjudication, Mr. Gali. Only because B form is defective, we don't honor that, and therefore no relief regarding the agricultural land. Specifically, second appellate court directed you to give relief to them regarding retention. Permit them to file a, just because it is defective, give them another opportunity.
Chance was given.
Substantive idea behind the second appellate order was that they are entitled to file a B form.
Lordship.
And you will have to adjudicate that on
Lordship.
merits. This is not an adjudication on merits. You say defective B form.
But
Give them another opportunity.
Chance was given, my lord.
B form defective, that's why you just.
No, he did not submit it rectified. It is said the very first line, my lord, order number 7. So chance was given, kindly sees, my lord. Even kindly sees order number 6 till date. Kindly see order number 6 at page 40. Till date, the petition has not produced rectified B form. Kindly see the earlier orders.
So if this goes, everything goes. After that, the writ court Justice Banerjee's first order was after that.
After that, lordship.
Now what was that?
Kindly see page 42, my lord.
42.
That amicable submission is making, my lord. Kindly say amicable said. Page 42.
Amicably, it has not been settled. So let us forget that.
Page 42. I think this matter could be settled amicably.
What is the question?
Lordship. Then amicable exercise starts.
So where is the amicability in it?
Amicable exercise starts from page 44.
Great.
Lordship.
Now we'll make it mandatory exercise.
Lordship. So
they say B form was defective. What about this? They say the B form was defective.
They want to delete those plots which I want to, my lord, retain.
So till date, the position is second appellate court gave you the liberty to file B form. They have to consider that.
Right.
If they consider in accordance with law, then it's a different question. Till date, defective on the ground of defect, it has not been considered effectively at all.
They have not indicated what is the defect.
What is the defect, Mr. Gali?
Till date, in the order, kindly have a look.
B scheduled lands. My lord, kindly sees the second appellate decree at page 30. He was supposed to submit, my lord, the B form, my lord, in terms of B scheduled lands. No.
As regards agricultural lands, he will be allowed to file a fresh B form return.
Right.
No B schedule, A schedule, Z schedule. Whatever agricultural land he has, regarding that, he can file a B form. Fresh B form. Only that. No rider.
That I was filed in terms of the civil court's order.
What is the defect?
There was
according to you, let us complete. You said they did not point out the defect, so let them point out the defect.
My lord, may I refer to my lord, order number 1, page 38.
Mr. Galib, is there any that B form has been annexed by any chance?
No, lordship, no.
38, page 38.
Page 38, order number 1.
So these are the deficiencies, according to you.
Such communication is to be made within a period of fortnight
No,
after
asking to
being
produce
communicated.
following documents.
Letter to the petitioner asking to produce following documents which are required for the purpose of correction of
So
record of
they
right.
did not produce these
Yeah,
documents.
this is what they say. Kindly see order number 2 in reply to my letter dated next page 39. The petitioner sent a letter dated 29 wherein he informed that all the documents have already been submitted to this office in different times. He also informed that no further documents.
That is not the ground of defect in B form. In order number 5, you say petitioner is present and files Hajira. He has submitted a defective B form on this date.
It appears there. Kindly see, it appears
there. Read it
there.
out.
It appears there may be so many lands which he might have sold out, and the purchasers have not mutated their land on record.
What is this
It is
might
found,
and not and
it
all
is
these
found
things?
that, Your Lordship, it is
Yes.
found that plot number 68 of Mosa so and so, area 25 days, and plot number so many plots of so and so have been sold out, begrayed or by the legal heirs of the deceased begrayed, and the purchasers have mutated in their name, but that very land have not been shown in the retained portion of the B form. Hence, it seems that the B form is invariably defective. So it is very much necessary to know full accounts of land which was previously allowed to return. In my view, the instant proceedings ought to be disallowed on the basis of defective B form, but the instant proceeding for allowing retention of land within ceiling limit as per so and so cannot be disposed of at present. For ends of justice, petitioners given another chance for rectification of B form. So, well, these are the reasons, my lord, he has given.
So what are the lands? Then you have to specify what are the lands that
This plots number, my lord. These plots, my lord, they have stated. It is found order number 5.
And plot number such and such
have been sold out by begrayed or by the legal heirs of the deceased begrayed, and the purchasers have mutated.
They have sold out.
Yes, and the purchasers have sold. Yes, and the purchasers are mutated in their name.
The purpose of retention, Mr. Gali, by them.
Yes.
Now, if they have sold out, why should they show it in the B form? It has been sold out to some others.
I mean,
that is not included in their property.
No, it whether the post vesting party, if it is sold out prior to vesting or that has to
you inquired that's your job, not their job. They have filed the B form, you inquire.
But
that say it is defective. Suppose a plaint has been filed casing a state. If there is deficiency in that, in the plaint case, you decide the suit and say that these are the reasons they have not been able to establish. Where is the hearing? You say the plaint is defective because they have not stated about this supposedly. See, your ground is, BLLR ground is, it is found that plot number 68 containing 25 decimal and plot number XYZ, area about 1.77, has been sold out by Bigrath or by the legal heirs of the deceased Bigrath. That is him.
Lordship.
So they have sold out and their purchasers have mutated. So you know from whatever documents are before you that XYZ land have been sold out by them, which has been even mutated in the name of the purchasers. So those cannot be included within the hotspot of their land.
B form.
B form. So obviously they have left those. You say it seems B form is invariably defective because those have not been shown in the written portion of the form. They will show whatever they now have. It's your job to inquire as to whether they have anything else. You yourself say they have sold certain plots which have not been shown in the B form. They should not be shown in the B form because they have already sold those. They don't belong to him. And if your case is that yes, post-vesting, pre-vesting, it's you have to prove that. And Mr. They may also have to prove it if he's engaged after this.
I have not engaged.
Mr. They, the difficulty in your case is, in this case is, in this, not your case, this case is that nothing on that. It has been said these have been sold subsequently. If the ground was post-vesting or pre-vesting, we could have understood. That is a very good ground. Does not say, says those have been sold, not even said that those have been sold pre or post vesting. Those have been sold, therefore not shown in the B form, and therefore the B form is defective. How can you say that B form is defective? B form is correct, that is his perceived owned lands are to be shown in the B form. It's your job to inquire. During the inquiry, you could have directed, you have to have some information, you have to have an independent inquiry. BLRO has to do that also. You inquire from the records.
So, my lord, this exercise, Lordship meant to say it has to start afresh, my lord.
File B form, they have filed B form, they have shown.
Only one thing.
Yes,
my lord, in B form, he must shown that land. That was not shown.
What land was shown?
That which is
in B form, doesn't he have to show whatever lands he is owning on that date?
No, my lord. He must show all the lands on the date of listing. that is the date of vesting, that is 19.
There's a column,
Yes, my lord.
he has to show all the lands he
All the
owned on
lands.
that date.
Yes, my lord. But in this case, in the present case, my lord, that was not shown in the.
Why should it not be clearly mentioned that
That
post
is-
vesting,
that
pre
is the-
vesting, these
no,
things?
my lord, that is the problem. For that.
Yes, what do you have?
that is correct.
Very well. What do you have to say on this?
My lord, these lands has already given to my wife as the
But you have to show those. They are saying that
that was before my lord the cutoff date. 4th May that
produce those
1953
documents. Reflect,
was the
produce those
that
documents.
was
to show.
on record. In the record of rights, it was stated, and also under the Right to Information Act, he has stated. He has given the reply. If kindly have a look. All these plots were given to
You file your opposition to this. Within a week, you file it. Annex everything.
my.
An arguable question has been made out as to whether the learned tribunal erred in law in upholding the orders of the DLLRO, comma, as well as the BL and LRO, whereby it was held substantially that a defective B form has been filed by the respondents. Full stop. The short prelude to the case is that there was a second appellate decree whereby it was held that the non-agricultural and certain other lands belonging to the that the vesting in respect of the non-agricultural lands and tank fisheries belonging to the petitioners in favor of the state was bad. Full stop. Insofar as the agricultural lands are concerned, comma, the plaintiff, that is the predecessor interest of the present respondents, were permitted to file a fresh B form return. Full stop. Next para, it is the bone of contention between the parties as to whether a proper B form was filed. So whereas the state takes a stand that a defective B form was filed, and despite opportunity, no rectified B form was filed, comma, learned counsel for the respondents argues that a proper B form was filed and all relevant documents in support of the transfers, comma, pre-stroke post-vesting were before the BL and LRO. Full stop. Next para. To resolve the dispute, comma, the respondents are directed to file an affidavit in opposition to the present writ indicating all the relevant circumstances and, comma, if necessary, comma, annexing the relevant documents which were produced before the authorities by the respondents in respect of the transfers pre and post vestings with regard to the agricultural lands of the respondents. Full stop. Such affidavit shall be filed 2 weeks. Within a fortnight from date, full stop. Reply, if any, shall be filed within a week thereafter. The matter shall be listed under the same for hearing under the appropriate heading on November.
1, 2, 3.
On December 8, 2025.
My lord, so far as 161 is concerned, we are at gunpoint, my lord. Kindly excuse me, lord. If your lordship may kindly take a minute.
By gunpoint?
161, kindly see 161 file, my lord. At page, my lord. 67 straight away, lordship. In content proceeding, my lord.
On next date fixed August 2026. Contempt application.
Order August 2026.
60.
26
We are to produce the corrected ROR. We are to come with it.
On August 2026.
In the meantime, lordship. Update টা কবে?
No, নিন।
August 26.
এটা হয়ে গেল।
I am for the petitioner, Lordship.
I am for the state respondent.
And I appear on behalf of the respondent applicant number 1.
Yes, what is the matter?
Lordship, I am challenging the impugned order dated 12 September 2025 by the West Bengal Land Reform of a Tenancy Tribunal without consider of your petitioner merit or respondent number 7 to 12 of OA applicant, Lordship. Lordship, may I place the case, Lordship?
What your application? Where was their
No,
application?
My
This is
application.
myself.
Application was for what?
Your application
Lordship,
was
kindly come to page 70, Lordship.
without initiating any proceeding under section 41 51A4, the particular lands had been given to someone else. Now,
Land reform sector din.
yes, I'm having.
No, we have copy.
Kindly say 51A4 and 51A5. 51A5 is virtually a provision of appeal. 51A4, Miller, kindly see.
No, what was your grievance? An order was passed revising this, revising it.
Yes, revising it and without giving me an opportunity of hearing and without recording reasons. I was agreed with that, and then Millard, I prefer a statutory appeal. Then Millard,
70, Lordship.
Acha, let us hear him.
Yes,
Which of it is it?
I'm sorry.
Timely come to the West 70, Lordship.
Yes, 70.
The appeal being number 69 by A by 205 is directed against the judgment passed by Lanet RO or BLRO LR office Chakulia in process the numbering 36 by 96 under section 50 of WBLR Act 55. The matter having been heard on 22nd March 2007, 12 April of 2007, 24 April of 2007, 15 May of 2007, 31st May of 2007. Having stood for the consideration following judgment is delivered. Brief history of the case is as follows. Being dissatisfied with the order of the lower court, petitioner Sri Ramchandra Das, son of late Dhirendra Chandra Das, village Uttar Rampur, post office Chapur, PS Chakulia, district Uttar Dinajpur, filed the appeal being as such and such, challenged the order passed in proceeding being number 36 of 1996 under section 50 of WBLR Act 955. That appellant have stated that 20 decimal of land has been deleted from his Khotian, being number 222, Mouja, Uttar Dinajpur, JR number 01.
No, you have challenged this order before the tribunal.
Lordship, they challenge this order. They are getting several opportunities, Lordship. And it is doing by learned revenue officer after hearing your petition.
But what sort of order is this? There is no reason in this order. His point is also stated one. Let us see the tribunal's order, the impugned order.
Kindly come. Last page, Lordship. I am 202, Lordship. 204.
It has been remanded only, and the order is very unclear.
That was Miller. I am grateful to my lords, and that was Miller.
Mr. Dey, you could not produce a
He was
record.
also indicating that. Yes.
Your lordship, can I pray that your lordship can send remanded to the PLRO? As because my lord, if your lordship on perusal of the order of this order and scrutiny of the office record, we do not find the case records of 136 Sabato. State respondents failed to produce the case record before us, for which we are quite in doubt whether an inquiry was held by the RO or not. So, my lord, it was remanded back to the appellate authority. But
There might have been no inquiry at all.
Yes, my lord.
That's
My
the
lord,
reason.
If your lordship,
But you are the state, the BLR records could be produced before the DLR. Why didn't you produce?
but that
You might be hand in glove with them.
Whatever maybe that for that is, my lord, I pray, my lord, that were remanded back to the BLR.
No, but the state cannot say the state. Why didn't you produce the appeals, the records?
But he can't.
You had to produce the records. You did not produce it.
For this, he has come before the lordship, but.
But if you could not produce the records, then even if you send it back to the BLRO, I mean, if there's an order,
For a fresh act, because my lord, there is no need.
it was recorded in their name.
Lordship,
That is sought
my
to be
name,
rectified. What was the basis of recording in your name?
Lordship, learned RO revenue officer after hearing all party lordship, petitioner and Ramchandra Das, and by physical possession lordship.
Where is the BLLR order which was challenged before the DLLR? You place page 70. Where is the original order of the BLLR which was challenged before the DLLR?
That is not lordship. I'm find out lordship.
If that cannot be traced out, then how can it be said that
Lordship is the current record of right lordship.
it was passed in your favor? Record of right has been challenged. This has been challenged. Why should we look into the current? Why should you look into the current record? This has only been sought to be rectified by saying that without any basis it has been done.
Physical possession, physical verification lordship done by RO and BL.
How do you know that? DLLRO says the appellant has stated that such and such deleted. Respondents admitted. Respondents stated that respondents means you.
Yes.
Lordship.
No.
Ramchandra
No,
Das.
no,
Ramchandra Das.
Ramchandra Das.
Ramchandra Das.
No,
Affiliate is Ramchandra Das. Lordship.
1 minute. You are the who are you, Mr. Bhattacharya? You are the heirs of Ramchandra.
We are the
Ramchandra is their predecessor or your predecessor?
predecessor.
He is going to DLRO. Ramchandra Das.
Ramchandra
Their
Das,
bill,
my lord,
Ramchandra.
told.
DLRO they going.
My lord,
They are going to
he
DLRO.
is the appellant, my lord, before the appeal filed before the statutory authority. That is that page 50.
Who sought for correction? Ramchandra Das.
Ramchandra Das?
Yes.
Yes.
Lordship.
Yes.
So that was not allowed by the BLLR.
No. And Millard, not allowed, not Millard, I cannot say that. What I find, Millard, that there was a particular portion of the land was given to them.
Lordship.
Without recording any reasons, without giving us an opportunity of hearing. Then Millard, we wanted
But you
to
must have the order which you challenged before the DLLR.
Millard, with nothing we have, because we have not
Then what did you challenge before the DLLR?
Millard, we just, Millard, kindly see, that's the reason I want to show to my lords, Millard. Kindly see.
Let us hear them, yes.
Yes. That's the reason I want to show.
You don't have any papers.
No
Put your
papers.
Why was it recorded in your name?
I beg you pardon, Lordship. I am file supplementary. If
No question of supplement. Show us the records.
My lord, may I be
Why don't you annex to the writ petition itself?
Lordship, I am annexed, Lordship. I am annexed, Lordship.
We are asking you repeatedly. You are saying you.
I beg your pardon, Lordship.
My lord, may I be permitted to why I say that BLRO?
Why?
That your lordship, paragraph page 6, paragraph 8. What is the petitioner's case, my lord?
Actual possession of the party. That is the premise of the DLLR order.
Actual possession of private respondent, but we have mutual consent. How? My lord, next, my lord, if your lordship will see.
According
156 RO, Lordship.
Had
Page
recorded.
9, my lord. Another paragraph. Page 9, paragraph 14. See how BLRO can pass this order.
Page 9.
Oh, I am a state respondent, my lord. I can't support this.
Page
By
9.
mutual consent, they.
By mutual consent, they may be in possession of particular portion. That possession need not be legal.
How he knows that mutual consent is there?
Who knows?
That is the BLRO. BLRO passed this order that this and my lord paragraph.
We don't know whether anything was produced before him to show that.
Yes, my lord. Paragraph 14. Your petitioner have acquired title since long and possession.
Paragraph
Since
14.
long.
Yes.
Paragraph 14, page 9. And the possession of your petitioner not forceful and illegally. Your petitioner previous purchaser in possession at all.
Lordship.
You are still in possession. According to you, you are still.
I am still in possession, Lordship. There is a difference, Lordship. I beg. She Santosh Das, Sadananda Das, and late Guruchandra Das. He is the actual owner.
It's a they, but what is the law? If possession is, even if it is not legal, whoever is in physical possession, his name has to be recorded.
My lord,
I am
Wait, both of
last two lines.
Paragraph?
Paragraph 14, last two
So
lines.
whatever they may have, Mr. They, what is the law? Whatever who is in actual possession, that has to be reflected.
My lord, he filed an application for mutation. Mutation means, my lord, that is according to the provision, that is according to the deed, his land will be in his name, my lord.
But he's not able to produce any document before the dealer or here also.
No, my lord, as because now the deed is automatically when the registered deed is there, my lord.
Certified copy they could produce.
Yes, my lord. They can produce before the BLRO.
No, still they're not being able to produce anything.
Now, how BLRO can
Registered deed
record that?
registered sale deed lordship.
Where is that?
I'm annexed it lordship.
Which page?
I'm telling you lordship. Page 18 lordship.
18?
18 lordship.
18.
18.
এটা তো কাদের থেকে বিশ্বনাথের কাছ থেকে বিশ্বনাথ অরিজিনাল আমাদের কাছ থেকে বিশ্বনাথ নিয়েছে বিশ্বনাথ থেকে ওরা নিয়েছে আমরা
Who kindly come to 27 lordship page. Vishwanath Das.
on instructions from my client, may I say one thing? Vishwanath Ghosh told it to Santosh Das and also to my clients.
Lordship is a baseless allegation.
You could have produced those deeds before the DLLR.
Yes,
You have not produced anything.
Milo, there are three persons to whom this thing has been given.
This is being submitted from the bar. Why didn't you produce the documents before the DLLR? Then how can you say that?
I cannot. I close the brief. I cannot say, as I told you, Lordships, my lord, that
Mr. Bhattacharya, why should it be remanded? Here, the DLRO says that appellant has stated 20 decimals of land has been deleted. Now, he is producing a title deed. You have not produced anything.
no, we have before the particular land tribunal, my lord, this is the application they have filed, and before the land tribunal, my lord, whatever documents we had, including this deed, we have produced it, we have annexed it.
Document of your title.
My lord, kindly see.
No, did you produce? Just tell us.
Yes, my lord, I find, my lord.
You say you had no documents right now. You said
No,
we asked you.
Chandra Das, my lord, Rohita, and data is Santosh Chandra Das.
So we remand it to the PLLRO because there is no clear indication in either of the.
This is the northern side. Vishwanath
Cannot decide that in 226.
kindly, last I'm praying lordship. Kindly.
There is no irregularity in the remand order. What is the irregularity? See the DLLR order. There is no adjudication at all. None of the documents have been adverted to. None of the documents. No report was sought for. Learned counsel for the petitioner argues that despite the petitioner being equipped with title deeds in favor of the petitioners, the learned tribunal, by the impugned order, remanded the matter to the appellate authority, that is the district land and land reforms officer, for a fresh adjudication on the issue of recording of names of the petitioners in respect of the plots in dispute. So next para, learned senior counsel appearing for the private respondent submits that the private respondent produced their relevant documents before the tribunal, which prompted the remand order. Next para, learned additional government pleader submits that in all fairness, there is no clear adjudication by the appellate authority, nor were the records of the BLLRO traced out, as is evident from the orders in question. Thus, for a fresh adjudication, the matter ought to be sent to the BL and LRO. Next para, upon a perusal of the order dated June 25, 2007, passed by the appellate authority, in a challenge preferred at the behest of the private respondents, we find that the appellate authority, that is the DL and LRO, adjudicated the matter merely by recording that certain parties were in physical possession of the property, without adverting to any title deeds or supporting documents and or any report in favor of such findings. Next para, thus, in principle, the learned tribunal was justified in remanding the matter, although for the ends of propriety, the remand should have been comma, instead of the appellate authority, comma, to the BL and LRO, comma, the first authority, comma, since the DL and LRO order does not reflect any documents having been adverted to. For sub next para, since extensive documents are sought to be relied on by the petitioner as well as the private respondent, comma, the DL and LRO ought to have decided the matter on merits upon taking into consideration all the said documents. Full stop. Since the said exercise was not done by the appellate authority and the parties are not in a position even to produce the order of the revenue officer, that is the BL and LRO, whereby the names of the present petitioners were recorded in the records of rights, comma, the only plausible recourse would be as suggested by the learned AGP, that is to send the matter back to the first authority. Full stop. Accordingly, WPLRT number 176 of 2025 is disposed of by setting aside the impugned order dated September 12, 2025, by modifying the impugned order dated September 12, 2025, passed by the second bench West Bengal Land Reforms and Tenancy Tribunal in OA number 2154 of 2007 within bracket LRTT bracket closed, and by remanding the matter to the concerned block land and land reforms officer instead of the appellate authority for a fresh consideration on merits of the merits as to the justification of the recording of the petitioner's name in the records of right in respect of the plots in dispute. Full stop. Next para, it is made clear that the block land and land reforms officers shall grant adequate opportunity of hearing to the private parties, comma, the state, as well as all relevant other parties, and permit the parties to produce the documents in support of their respective contentions before coming to a final conclusion in the matter. Full stop. It is expected that such exercise shall be concluded within an outer limit of 6 months from the date of communication of this order to the concerned BL and LRO. Full stop. The parties as well as the BL and LRO shall act on the communication of the learned advocates for the parties coupled with a server copy of this order instead of insisting upon prior production of a certified copy thereof. Full stop. There will be no rest to cost urgent certified copies.
We have only one indulgence. The BLLRO may be directed to supply us copies of the orders, my lord, because we do not have nothing.
No, my lord, he can take the certified copy. That is the provision.
We have made it.
What copies? PLR, it's a fresh exercise now.
Now, fresh exercise. Now, Miller, while they will be adjudicating, as your lordship had indicated, because the lordship had remanded the matter before the
because the documents are not available, that's why we are remanding for a fresh consideration.
But Miller, whatever they do, Miller, they should at least supply us because this statute.
You produce your documents.
In terms of this particular statute, Miller, 51.
Why do you apprehend that will not be complied with? Whatever documents parties cite.
Now, but since a proceeding under section 51A4 had been initiated,
those records are not before us. So there has to be a fresh exercise, Mr. Waters.
then Miller, if they kindly indicate that if a proceeding has to be then initiated under section 51A4 in terms of the statute. Kindly say.
Why do you say that?
I kindly say. Miller, that's the reason I wanted to Miller place before you, my lord. 51A4.
This is that exercise, revision of entry.
Specially empowered by the state government may only
that exercise has been done, which is why against which you preferred an appeal.
Yes.
We are remanding the matter to the BLLR for a reconsideration of that same exercise.
Yes. Now,
that's why the matter has been remanded. We have not directed a fresh revision to be initiated. It has been remanded because there was an exercise by the BLLR under section 51A4.
Yes.
Now that has been remanded to the BLLR.
I was agree with this particular Miller, the initiation of a proceeding. Then Miller, I prefer an appeal.
So whatever you are agreed with, the BLLR will consider the matter.
To Miller, kindly say that they have to record the reasons. And Miller,
they will do that this time. They will do that this time. Next matter.
I will. Grateful, Lordship. This is the first immediate appearance, Lordship.
Yes, please. Who is for the petitioner? Move the matter. What about service?
Yes, yes.
Good service affected?
Only state. Melody, I'm drawing Lordship's attention. Page 60. Order passed by the block land. BL.
Section?
Page 60.
Page 60, yes. What is this?
This has been, my lord. Things petitioners were initially, my lord, the recorded owner. Subsequently, the record has been, my lord, deleted and the recorded as a parta holder. That's why made the application. When they made the
You are the Rayat originally.
Originally Rayat.
So that was changed. The category was made as patta holder.
Well, that time when they made the application, they come to know the land in question has been vested to the state. My client has not knowledge. No
So
notice.
patta holder, somebody else's name was recorded as patta holder.
No. These are the legal owners.
You are the owners of the property, you say. Whose name has been recorded as patta holder?
Our names. In place of Rayat.
Oh, patta holder.
Patta holder.
So you came to know that there has been a vesting.
When they made the application, they come to know the land has been vested.
They means you.
Then Lordship kindly appreciate.
They come to know means you come to know.
We come to know.
Yes.
When we come to know that the land has been vested to the state. But no proceeding or no notice has been served upon the. My client made the application for certified copy of the order of vesting so that my client can be come to know. Lord, that application was made before the LRTT. LRTT has given the liberty to make the application in a press. Page 60 kindly appreciate. Page 60. On that basis, a order has been passed by the block land officer. This order has not at all the spirit of the order, that challenging that an original application filed before the LRTT. Got it, Lordship?
So page 60, we don't understand this. What? Where is
60
the order before? There was an order by the tribunal before.
Yes, it's coming.
So
that's this order has been challenged before the tribunal.
So was the previous order of the tribunal direction?
That is the order passed, the last impugn order. What?
No, before 21st of January 2025, there was another previous direction of the tribunal.
Yes. That has been indicated in so kindly page 60.
Have you got a copy of that order of the tribunal?
Yes.
Show us that.
No. কোথায় আছে অর্ডারটা তো দেওয়া নেই না অর্ডারটা দেওয়া নেই প্রেজেন্টেশনে তো দেওয়া নেই এই তো রিপ্রেজেন্টেশন না কমিউনিকেশনটা না ওরা নেক্সট করেনি ওটা নেক্সট করেনি deed has not been wrongly annexed. But Lordship, this order itself indicated.
Let us see this order. Tribunal directed you to file a fresh representation before the appropriate authority, implementing all listed parties. Representation for what? For certified copy.
Certified copy. As because the proceeding, no notice has been served, my client has nothing knows.
You have applied for supplying certified copy and also to correct recorder right together. How can they go?
That maybe that is the formal application.
No reason at all. So what did the tribunal do? Let us see how to.
The tribunal held, kindly see. But annex করেনি তো রিপ্রেজেন্ট আগের অর্ডারটাকে অ্যানেক্স করে
এই এস্টেট অ্যাকুইজিশন একটা দিন ওয়েস্ট বেঙ্গল এস্টেট অ্যাকুইজিশন দেখি পুরো 5টা দিন আমি খুঁজে নিচ্ছি না আপনি একটু দেখুন না এখানেই থাকবে এগুলোর মধ্যে দেখি আমার বাঞ্চটা দিন না you asked for an order of vesting. The tribunal says that vesting was automatic under section 4 and 5. So even if that is so, then the notifications must be there. You ask for an order of vesting. There cannot be any order of vesting as such.
No proceed. They have stated, my lord, in the order, kindly see. Under section 4 and 5 of the WBA 1953. We prayed for the proceed. No notice has been served upon my client.
No. Upon due publication, section 5 says notice upon publication of a notification under section 4 on and from the date of vesting, these are the incidents. So section 4 is the vesting notification.
That should be.
So, but you asked for order of vesting. Tribunal says there cannot be any order of vesting.
No,
Rightly so.
My responsibility.
By notification, state government may declare you apply under the RTA Act for those notifications.
My client has made the application on the such.
Tribunal says we have carefully gone through whatever. The subject land was vested under conjoint operation of section 4 and section 5 of the Estate Acquisition Act. That is section 4 and notification effect is section 5.
That is come to know by the order.
Therefore, the question of supplying certified copy of order does not arise.
No, my lord, the only things for him. Therefore, the question of supplying before that, that apart. It is also admitted fact that the applicants have already been granted parta over the subject land.
It is not an admitted.
It is not that. The question, this portion is not correct.
We'll delete this portion because you have never admitted, and we'll grant you liberty to apply under the Right to Information Act for this notification of vesting.
Yes, that can be. That can be.
The petitioner's grievance, despite notice, none appears for the state. Affidavit of service filed to be kept on record. The petitioner's grievance is that the petitioner is a riot in respect of the plot in question. Full stop. However, the petitioners came to know that the land that it has been recorded in the concerned records of rights that the petitioner is a patta holder in respect of the said land. Full stop. Next para. Upon making appropriate application before the BL and LRO challenging the same, it came to the notice of the petitioners that there had apparently been a vesting under the West Bengal Estate Acquisition Act 1953 in respect of the land, regarding which no notice has ever been given to the petitioners. Full stop. Next para. Being so constrained, the petitioners applied for certified copy of the vesting order. Full stop. In the same breath, the petitioner also sought for a correction of the records of rights. Full stop. The BL and LRO, by an order dated January 21, 2025, rejected the same application without assigning any reason whatsoever. Full stop. Being aggrieved, the petitioners moved the Land Reforms and Tenancy Tribunal, which, by the impugned order dated July 29, 2025, recorded that the subject land was vested under conjoint operation of section 4 and 5 of the 1953 Act, and as such, the question of supplying certified copy of the order does not arise. Full stop. While so concluding, the learned tribunal also recorded that it is an admitted fact that the petitioners have already been granted patta over the subject land. So, however, it is rightly argued by the petitioners that the petitioners have, at no point of time, admitted the grant of patta or even the vesting of the said land in the state. So, rather, the petitioners' endeavor before the BL and LRO was to apply a certified copy of the vesting order. So, next para. While agreeing with the first part of the reasoning of the tribunal in the impugned order, that the vesting under the 1953 Act operates by virtue of sections 4 and 5 of the said Act, and no separate vesting order is required to be passed, comma, at the same time, comma, there has to be a notification within the contemplation of Section 4 of the 1953 Act for a vesting to occur and the incidents of Section 5 of the said Act to be attracted. Full stop. Thus, comma, in the event the petitioners are aggrieved with such vesting or have a doubt as to whether such vesting at all took place or not, comma, the appropriate remedy before the petitioners would be to apply before the concerned authority seeking the particulars and, if necessary, copies of the notification under Section 4 of the 1953 Act with regard to the plots in question. Full stop. Next para. Thus, comma, moreover, comma, the recording of the tribunal that it is an admitted fact that the petitioners have been granted patta over the subject land, comma, being not borne out by the pleadings of the petitioners, comma, is required to be deleted. Full stop. Accordingly, comma, WPLRT 177 of 2025 is partially allowed, comma, thereby striking off the observation of the learned tribunal to the effect that it is an admitted fact that the applicants within bracket petitioners bracket closed have already been granted patta over the subject land. Full stop. The impugned order dated July 29, 2025, passed by the learned third bench, comma, West Bengal Land Reforms and Tenancy Tribunal in OA 1779/2025 bracket LRTT is modified accordingly. Full stop. Furthermore, comma, liberty is granted to the petitioners to apply before the appropriate authority for particulars, for the details and particulars, including the date of the notification under Section 4 of the West Bengal Estates Acquisition Act 1953 with regard to the disputed plots and as well as seeking copies of the said notification. Full stop. Under the Right to Information Act. Full stop. If such an application is made, comma, the said authorities shall respond to the same in accordance with the said act at the earliest, comma, preferably within 2 months, within 1 month from the date of such application being made. Full stop. No address to cause or disagreement. Not shortlisted.
I am for the petition. I prepare for the statement. Today I am not in a position to file the affidavit of service fund because the file is not with me.
There are private respondents also?
No. Private respondents are there. Private respondents are there.
Then you have to.
They are my relatives. They are not opposing. They are supporting my prayer.
6, 7, 6 and 7.
They are
7, 8.
6, 7, 8 supported in the before the tribunal
Yes,
also.
yes. But they are my
So can we
relatives.
dispense with service on them?
Yes, that can. And what the point is, my lord.
You don't have the file?
No, but it is on the.
Oh, laptop.
But the issue is, my lord, it is for relating to dispute related to quantum in the 7AA proceeding. My lord, in appeal, it was in my favor. I accepted the quantum dismissed in the state and the vested in the state and the remaining. But my lord, when I made an application for record of right, correction of record of rights in terms of that order, that was not entered into. That was not taken into consider by saying that the third party interest had been created. Therefore, without eradicating the record of rights, cannot be prepared in my favor. As per the vesting order, land has been settled to some other person according to the order, according to the BLR. Therefore, my record of application for correction of record of rights cannot be decided.
No, you relied on what? The 7A case that procedure?
Yes, yes. My lord, subsequently, my lord, since the authorities were not taking any steps in terms of the application for correction of record of rights, I filed an application for contempt before the tribunal, as the tribunal directed them to dispose of within a time. But after filing of my contempt application, they initiated the proceeding and rejected my application for correction of record of rights on that ground. My lord, since the contempt application was filed, when that was taken up for disposal, my lord, the tribunal granted me leave to prefer appeal, challenging that order, because in the meantime it was time barred. I prefer leave was granted in my favor, my lord, in 2018. But my lord, I could not file the appeal because the petitioner at that point of time, the petitioner, he has died, the original right. He has died, his wife has died, there is a disturbance in family. My lord, I filed the appeal in 2023. That is after a lapse of 5 years, the delay of 5 years. My lord, I filed an application for condonation of delay. That was rejected. Challenging that order, I preferred the appeal before the tribunal. There also, my lord, delay of 60 days. My lord, when the matter was taken up for hearing, my lord, it is delaying. Next date is 31st of March. My lord, on the on 14th of July 2024, my lord, there is a direction upon the state to, as they prayed for, time to file the written objection to the Section 5 application of delay, condonation of delay of 60 days.
Opposition.
My lord, till date, my lord, they have not filed the opposition. My lord, next date is 31st March. Again, on that ground, the time will be extended.
31st March of 2026. So does it lie in your mouth, in your client's mouth, Mr. Mahathir, to ask for an expeditious disposal?
Well, let the
5 plus 60 days. 5 years. File your opposition within
there will be direction
within
30th March. Yes.
No, not before that, madam.
before the end of this month.
Yes, and I shall file the reply to that.
We'll prepone the date.
Yes, sir. They are here only for prepone the date, my lord.
We will prepone the date. Let them know their fate.
Yes.
File it within 30th November. We are on 20th November. We'll give you till 15th of December.
Can you give us more time, my lord?
15th December, 1 month.
Yes.
More than 1 month. Yes. The present application is for expeditious hearing of an original application filed by the petitioner before the West Bengal Land Reforms and Tenancy Tribunal. Push up next para. Learned counsel appearing for the petitioner submits that the petitioners filed the original application.
OA number 1399 of 2020.
Thank you. Bearing OA number 1399 of 2024.
Yes.
And thereafter, the state was directed to file affidavit in opposition. No, file OA number 1399 of 2024. Along with a condonation and along with an application for condonation of delay in filing the OA. Next para. The state was directed in the month of July 2025 to file an affidavit in opposition thereto.
10 July 2024, the order was passed.
10 July filed an order on July 10, 2024 to file an affidavit in opposition to the condonation application. However, till date, no such opposition has been filed. Next para, it is submitted that the next date before the tribunal has been fixed on March 30, 2026.
Yes.
Next para, it is evident that since the state was directed as long back as in the month of July 2024 to file an application, to file an affidavit in opposition to the condonation application, but no opposition has yet been filed, the matter is being unnecessarily protracted. Next para, accordingly, the respondent authorities are directed to file their affidavit in opposition to the condonation application filed by the petitioners in connection with OA number 1399 of 2024, which is now pending in the before the first bench of the West Bengal Land Reforms and Tenancy Tribunal within December 15, 2025. The tribunal shall thereafter, dispose of the said application by shifting back the next date fixed. Next para. It is expected that the tribunal shall dispose of the condonation application latest, now as expeditiously as possible, latest by January 15, 2026. Next para. In the event the application for condonation is allowed, the tribunal shall make endeavor to dispose of the main original application as expeditiously as possible, positively within 8 months thereafter. No address to cost.
The dispensing with the service upon the private respondents, that part.
Since the private respondents are sailing on the same boat as the petitioners before the tribunal, service on the said respondents is dispensed with. Since the respondent authorities are represented by counsel, further service on the said respondents is also dispensed with. The matter is taken up for hearing. আচ্ছা WPLRT such and such is disposed of
No, no, এটা তো বলা
বলুন
না।
WPLRT such and such is disposed of in the light of the above observations without an order. Thank you.
In this matter, I am appealing to the appellant.
Lordship, I am for the respondent. Your Lordship, I would like to stress upon the order dated 1st March 2022, passed by His Lordship Showmention Division Bench, the last paragraph of that order.
Yes.
Defects have not yet been removed.
The fact is that the defects were directed to be removed within 2 weeks from the date of the order. And the last line, failing which, the appeal stands dismissed without any further reference to the court.
Yes.
And the defects were rectified beyond 2 weeks. Your Lordship, for that, I would like to highlight the order dated 18th April 2022, passed by Register Administration. 18th April in FS 76 of 2022. Here also it is clearly written that no steps have been taken to rectify the defects, although it was supposed to be completed within March 2022. On 14th, 18th of April, it's still not complied with.
What are you trying to move now?
The injunction application was because subsequently this matter came out from consideration.
Appeal stands dismissed by virtue of the order dated March 1st, 2022. Your learned friend is right.
Subsequently, this matter came out on 30th September 2024.
What happened then?
The direction for filing of affidavits.
That is a nullity because it cannot be passed. March 2024.
Yes.
We directed.
No,
Whoever directed, I mean, that's a nullity. What was that date again? 14th May.
30th September 2024.
Yes, that order was a nullity. Because this was not pointed out to the court. Why didn't you point this out to the court? You did not appear even.
No, Your Lordship, we appeared, but at that
not recorded.
Not recorded.
30th of September 2024. You were not there. Affidavits were directed. Also on 14th of May 2024.
Your Lordship, what has happened on the from September 2024 when this direction for affidavit opposite passed? After that, this matter gone out of the list. It did not appear.
No, on that date you are not present. The previous date you was taken. You should have just pointed out to the court.
Your Lordship, it was my mistake.
But Mr. Rai, your learned friend has a point. If it stands dismissed, they have no business to look out for the affidavit. So we will give you liberty to file a proper
An application because logical because recalling in the this is passed in logical subject.
You already have to pass. That too, at that stage also there was a restoration application. Probably it was dismissed previously also due to your non-compliance.
Yes. This matter post.
No, it was dismissed for default. Previous to that, it was dismissed for default.
Default.
Not for non-compliance.
Thrice this matter was listed. Thrice they failed to appear and the matter was dismissed for default. Then the CAN 1 was filed and it was restored with that direction to rectify the defect within stipulated period. That was not also complied.
Don't be so passionate about it. We are recording.
So far the order passed in the on 1st March 2022.
Mr.
Subject to question, if your Lordship takes up that Supreme Court judgment, whether this direction can be, I can take advantage of the same manner. This is up to December. It is March 2022. There is a COVID extension period. Malad was there.
COVID extension was
when did it end?
21.
20th, 22nd, it's just up to April, my lord, 90
When
days.
did the extended period end?
Extended period end, my lord, after March.
March 2022.
Yes, after that 90 days. March 2022, after that 90 days.
All orders are extended automatically. 2 weeks were given to you on March 1st of March. 30th of March, extension ended. After that 2 weeks, where does it take us? 14th of April, 18th of April, Register Administration says.
But
Your Lordship has an authority on the extended times.
11th March, we have already deposited the same.
11th March, you have deposited.
Yes.
What?
By filing.
Tolobana you have put in.
Yes.
Please ask your learned juniors to keep shut when you are speaking and take their seats.
আমি বলছিলাম তোমার কি গেছে তুই আমাকে বলো না তোমার যদি কিছু দরকার থাকে
দেখি
বসো
Tolobana and written up notice form, there is the, we don't get it. 20 rupees has been put in. You just check up, Mr. Rai. Justice Division Bench directed you to remove the defects as pointed out by the additional stamp reporter on 9th June. Achha, let us see that report first. 9th June 2020.
26 তারপরে হয়েছে তো just filed at 20th 26th 23rd Subject to question, may I assist your lordship? So far, if your lordship takes up the records.
Wait.
It's a backdated entry. It is backdated entry. That is why. না যেটা আগে জমা দিয়েছে তখন আমাদের এখানে আপডেট হচ্ছিল না যেগুলো আগে যেগুলো জমা দেওয়া গেছে সেগুলো সেদিন আপডেট হচ্ছে কিন্তু কোন দিনে ফাইল হয়েছে সেগুলো আর আসছে না যে
আমারটা করা হচ্ছে ভোকালাত ফাইল করতে
হ্যাঁ সেটা তো আছে সেই ভোকালাত তো কোনো অসুবিধা নেই The backdated data received not known because
You are Mr. Gupta. What is your name?
Obijit Chakraborty. I am the advocate on record.
Mr. Chakraborty?
Yes, your lordship.
Justice, the division bench of complex of Justice Shen, presided over by Justice Shen, that had directed that the appellant is directed to remove the defects as pointed out by the additional stamp reporter on 9th of June 2020. Right? 9th of June 2020, that report is given in the reverse page of the memorandum. That speaks about 4 defects, 3 or 4. We are saying what those are. One is the deficit court fees there. Subsequently, there is an endorsement that on 22nd of March, deficit court fee was put in. Memo of appeal needs to be classified in words and all. That defect was removed on the same day. And the other defects were all as indicated in this. All classification and all defects were removed on 22nd March, which is during that COVID extension period. And also a few days. Now, the report you are pointing out to, 18th of April 2022, is a subsequent defect because non-deposit of Tolobana was not contemplated in Justice Shen's order. Justice Shen's order said the defects, 9th June defects. 9th June defects have all been removed. You have a point, but not acceptable.
Tolobana also deposited.
When?
Just 23rd, after
23rd of
June 2022. But that is not the, it is already deposited. At the
That
bottom,
is belated, but whatever.
at the bottom, my lord, you'll find the.
At the outset, we'll deal with this, then take up your injunction application. Are you prepared on the injunction application?
Your lordship, you can prefer.
Very good, very excellent attitude. Yes. At the outset, learned counsel for the respondent points out that due to non-compliance of an order of a coordinate bench of this court dated March 1, 2022, the appeal automatically stood dismissed without further reference to this court after a period of 2 weeks from that date, that is on or about March 15, 2022. Full stop. Learned counsel for the respondent draws the attention of the court to a report dated April 18, 2022, authored by the Registrar Administration within bracket L and OM, which records that Tolobana of ₹4 and written up notice forms for causing service of notice of appeal upon the sole respondent have not been filed till that date. Full stop. Next para. By the same order, the appellant was directed to file Tolobana of ₹4 and written up notice form within a further period of 2 weeks from that date. Full stop. Next para. You deposited when? June, even after that. Anyway.
Yes.
Next para. Learned counsel thus submits that due to non-compliance of the court's order by removing all the defects, the appeal stands dismissed and subsequent directions of filing affidavits are non-est in the eye of law. Full stop. Next para. Learned counsel for the appellant submits that on March 1, 2022, the date of the division bench's order, the pandemic relaxations.
I'm not interested. It is up to 2021. I beg to. I beg to get.
Then it stands abated. Mr. Rai, then it stands abated because 15 automatically abated. If not within 14 days, you have done it on 22nd of March.
22nd of June, not even March, my lord.
Those corrections.
Yes.
June is different. Then it stands abated. Anyway, we'll continue. কোন খানটা ছাড়লাম একটুখানি বলো জাস্ট লাস্ট লাইনটা বলো
Extended 90 days. ঠিক আছে ঠিক আছে
এটা কেটেই দাও এই সেন্টেন্সটা এটা নতুন করো এখান থেকে নতুন করো Learned counsel for the appellant submits that all the said defects were rectified subsequently, which of the Tolobana has also been deposited in the month of June 2021. June 2022.
2022.
June 2022. Full stop. Next para.
90 days তাহলে কথা হচ্ছে
Upon perusing the records, we find that non-deposit of Tolobana did not come within the purview of the order of the coordinate bench dated March 1, 2022, since the said order was specific as to the defects as pointed out by the additional stamp reporter on June 9, 2020. Full stop. Insofar as the Tolobana deposit, insofar as the deposit of Tolobana and written up notice forms is concerned, the same did not form a part of the defects which was pointed out in the additional stamp reporters report dated June 9, 2020, which of thus, the appeal could not be said to have abated by virtue of the late deposit of Tolobana and written up notice forms, which has subsequently been deposited. Which of next para, however, fact remains that the defects in the memorandum of appeal and deposit of deficit court fees, as pointed out in the additional stamp reporters report dated June 9, 2020, were all rectified by the appellant only on March 22, 2022, that is after the expiry of 2 weeks from March 1, 2022 on or about March 15, 2022. Full stop. Next para. There was no scope of relaxation.
Subject to question, my lord. And I know.
Guess what?
The date, the limitation was extended subsequently. My lord, that is why precisely, my lord, I want to.
Not to recalculate passport. Next, call on the next matter. Call on the next matter. Register the.
My lord, I am.
Yes, please. Yes, Mr. Shamul, what is it?
My lord, application for injunction in connection with an
All have been served.
this appeal, my lord.
Please চলে গেছে সঙ্গে ওটা দিতে বলো।
Lord, I am appearing, my lord.
ও কি করছে ওখানে দাঁড়িয়ে লিস্টে দিতে পারছেন? ট্যাগ দিয়ে রাখেন না একটা পাতাটায়, এটাও কি কোড করবে নাকি? ইয়েস, একটা ট্যাগ দিয়ে দিন, ট্যাগ দিয়ে দিন। কোনো নেই আপনার কাছে? সবসময় লাগিয়ে দেবেন। Yes, Mr. Shamul, service affected on all?
My lord, for my lord, the affidavit of service, I found that endorsement is delivered.
But?
Endorsement is delivered, but these days, my lord, lordship knows these.
Maybe the.
Earlier, addressee used to say delivered addressee. Now it is only the post.
You are appearing for which respect?
I am appearing for, my lord, the in appeal to item number 28, my lord, for Samuel Dotto and another, my lord. Appeal FMA number 852 of 2022.
What about the others?
3 applications were filed under order.
Mr. Shamul, without proper service.
My lord, because this is second attempt also, I will again, and I've tried to serve the learned advocate in the court below. He refused to.
Was there a specific direction to that effect?
There was no specific direction.
But our direction is meaningless because he must have lost touch with his client now, even if we serve him.
Because the my learned friend is appearing, the other 2 persons are tenant under him. So he must.
What is the matter about?
My lord, an application under order 21, rule 98, my lord, was allowed. My lord, position initially on basis.
Allowed means whose application?
My lord, I tell your lordship, we got in by virtue of a degree.
You are the decree holder.
I am the decree.
What
holder.
degree?
My lord, decree for recovery of possession. I got possession of a suit property. Subsequently, 3 applications were
You
filed.
got possession of the suit property.
Subsequently, 3 applications were filed under order 21 rule 98 for recovery of possession, restoration of possession. That was allowed. 3 applications. One by my learned friend's client. He says that he is one of the owner in having a title by virtue of a will. And other 2 applications, they are the.
It must be under 99 because.
99. Right. And other 2 are the tenants under my learned friend's client.
So he asked for a recovery of possession.
And possession was allowed. And
got a degree against whom? Him.
My learned friend.
You got a decree against him?
We got a decree against
How
him.
can he file an order under 2199?
I tell your lordship, he says that
only third party can file that.
I tell your lordship, his father was the original tenant. He was in occupation of the property. We got a decree.
His father was the.
His father.
Yes.
Decree was executed. He came.
So you got the decree not against him, against his father.
His father. He says that I got this property by virtue of a will, which was probated at that time.
Will executed by?
By his father's sister. That was a joint property. Our case is that the property belongs to father. He says that no, the property also belongs to sister.
You got an eviction decree on the ground that his father was a licensee or what?
His father, initially, his father was the owner. He sold the property to my predecessor in interest without possession. Subsequently, an eviction suit was filed, decreed. Thereafter, well, these applications were filed.
He says father's sister also had a share. His aunt has a share, had a share. She bequeathed the property to him.
will.
That has been allowed.
Probate,
2190.
21 allowed.
Against that, miscellaneous appeal should lie.
Yes, miscellaneous. This is miscellaneous appeal.
FA number?
No, it's FMAT.
The initial orders were FA. Probably it was converted subsequently or what?
This is FMAT 852, 851, and 850.
Oh. আশরাফকে বলে দিও তো আগের অর্ডারটা ভুলেছে এফএ এফএ these show good service. So what is the ground of challenge? These have been admitted previously.
My lord, your lordship was pleased to admit this.
This was admitted.
Admitted and passed an interim
What
order
question
in
involved?
injunction.
What is your ground?
My lord, grounds, my lord, several grounds. Firstly, my lord, the will, which by my learned friend is saying that he got the property by virtue of a will, that probate was subsequently, my lord, revoked. Subsequently revoked because we say at that point of time, we being the owners are entitled to citation. Secondly, limitation. They were not there. And if your lordship goes to the impugned order, your lordship will find that
They were not there means?
Malad, they at no point of time they were in the suit property. Therefore, question of their possession, their independent right does not and cannot arise. These are all subsequent, my lord. And if your lordship kindly comes to the impugned order, that is without any reasons.
There are arguable questions. We'll extend the injunction. What is the injunction granted?
My lord, injunction was, my lord,
not to create
any third party right.
Not to change the nature and character.
When was the original injunction passed?
Injunction
That date of that?
My lord, 16th July 2025. My lord, I am appearing, my lord, led by Mr. Moina Ghosh, my lord.
He's in court.
Court, my lord.
Do you know that?
Yes. But
You're sure? You can file an affidavit saying that?
But my lord, due to his personal difficulty, I have been instructed, my lord, to pay my adjournment, not this week, my lord.
You are disposing of the injunction application, directing them to file the. You are the respondent number one only in one of the appeals. Which one? FMA?
FMA, my
852.
852.
852. You are for Shamal Datta only.
Yes, Shamal Datta and another.
Affidavits of service filed today be kept on record. It transpires that substantial service has been effected. Although the respondent number one in FMA 852 of 2022 is only represented, whereas the appellant in all the matters is represented before us by counsel. For sub next para.
No, my lord, I am not a representative. Others appeal, my lord. My appellant.
Explain to him. Yes, I will explain to him. I will give you 2 minutes. Explain, then we will continue. Please explain to him.
Appellant.
Yes. Upon hearing learned counsel for the parties, we find that we have already admitted the appeal by an order dated July 16, 2025 on several grounds. First up, moreover, it transpires that arguable questions of fact and law have been raised by the appellant in all the appeals, which arise out of orders passed in connection with applications filed under Order 21, Rule 99 of the Code of Civil Procedure by judgment registers. For sub next para, apart from the ground of challenging the plinth of the judgment register's alleged title, that is a will executed by a sister of the judgment debtor, on the ground that the said will was subsequently revoked, learned counsel for the appellant also contends that the applications were time barred, as well as that the judgment registers were not in possession at the time when the decree was executed. For sub next para, hence a strong prima facie case for grant of injunction has been made out. For sub also, the balance of convenience and inconvenience, as well as irreparable injury factors lie in favor of grant of injunction. Accordingly, all the 3 applications bearing can 1 of 2022, respectively filed in connection with FA 850 of 2020, 850 of 2022, FMA হবে ওটা FMA 851 of 2022 and FMA 852 of 2022 are disposed of comma, thereby granting injunction restraining the respondents in each of the appeals and the main and agents from selling, transferring, alienating, and or creating any third-party interest and or changing the nature and character of the suit property, decretal property in any manner during pendency of the appeals. Full stop. They arise out of connected separate applications from the same decree.
Same degree.
Three
separate
different
application.
registers.
Three different.
So can
registers.
composite paper books be prepared?
Might.
In view of appearance of respondent number 1 in FMA 852 of 2022, namely Shamul Dotto, comma, service on the said respondent is dispensed with. Service of notice of appeal on the said respondent is dispensed with. Full stop. However, comma, the appellant shall put in due requisites and postal costs for service of notice of all the three appeals on the other respondents therein, comma, within a week from date. For sub next para, the trial court records shall be brought by special messenger at the cost of the appellant, also to be deposited within a week from date. For sub the appellant shall prepare and file the requisite number of composite paper books in respect of all the three appeals, comma, which shall be heard analogously, comma, within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Next para, liberty to the parties to mention the appeals for hearing as and when those are so ready, comma, for the purpose of analogous hearing. Thank you.
My lord, I am
Affidavit is certificate.
I am appearing respondent number 1 and 2 in that appeal.
যেখানে respondent number 1 in বলেছি শ্যামল দত্ত and what is 2? What is the name?
Shamol Datta and Chandan Datta.
Respondent 1 and 2, Shamul Datta and Chandan Datta. Thank you. ওদের উপরও ডিসপেন্স দিতে হবে সব জায়গা থেকে। যেখানে রেসপন্ডেন্ট নাম্বার 1 আছে ডিসপেন্স উইথ দা ওখানে অ্যাপিয়ারিং ফর ওখানে এক। Yes, none appears for the parties at the time of call.
Services still is not effective.
Learned counsel, why not complete? When did you send?
Then we complete, but the form still is not effective.
When did we direct to be served? September 16, 2025. We are in November 10th. 2 months it has not been said, it will never be served. Where is the affidavit of service?
It's not in my hand right now.
Let the matter go out of the list then. Are you enjoying an interim order? No, are you enjoying an interim order? This is a section 5 application.
Yes, Lord. Yes, Lord.
No, let it go out of the. Whenever you are ready with the affidavit of service, mention.
Lordship, kindly give me your next week, Lordship. Last chance, Lordship. Kindly, Lordship.
No, you don't even have the copy of the brief.
Lordship, I come from the.
How do you know? From your clerk's instruction. No, sorry. Learned counsel for the appellant submits that service has not yet been completed. So, however, comma, on query of court, comma, we do not find any affidavit of service having been prepared by the appellant, comma, nor is the learned counsel appearing for the appellant prepared with the papers. Full stop. Accordingly, let the matter go out of the list for the present, with liberty to the appellant to mention the matter for inclusion in the list as and when the matter is ready as regards service. Next. Whenever it is ready as regards service, mention will take. Yes, Mr. Dev.
I am for.
Oh, you are for the petition, right? You are for the respondent of the SCS. One respondent?
Yes, ma'am.
What is the matter? Why did you file an application? It has expired in the meantime. Vinayad is saying yes.
Irregular implement, my lord. I have paid, already paid for certain period. My lord,
The eviction suit.
Yes.
Pay of eviction.
And can you come to page 11? Order passed by law.
So they were irregular payments. Now you have regularized.
Yes. And my lord, the extent of my learned friend, lower court has passed an order
They are going to issue read in the execution.
Oh, then you have regularized.
No.
Yes, yes.
Obviously.
I tell you what has happened, my lord. If your lordship kindly comes to page number 9, that is my lord's order.
Yes.
Your lordship very specifically directed that your lordship has granted stay upon stipulation.
In default, automatically sends. Yes.
Now, those conditions were mandatory. That is to pay the mandatory occupational charges by 10th of each month and arrears. Now, from the very beginning, they have shown their recalcitrance towards the said order. They have not complied with the said order.
They have been paying late.
Yes, they have been paying late, much late.
It stands automatically vacated by
Yes.
paragraph 12 of our order.
Yes.
How can we extend it? Something which has been.
For certain time, my lord. due to
And when we move before the learned court below, they have come up and they have filed this application by way of an afterthought.
The difficulty is that we cannot extend an order which is not there in the eye of law. As per our paragraph 12 of our previous order, the stay order shall stand automatically vacated without further reference to the court in case of any default. You have made several defaults, made late deposits, and then in the interregnum you stopped depositing. When they moved in the appellate court, in the executing court, you have started. Whatever. Now this order stands automatically vacated. How can you extend a vacated order?
For reviving the order.
Kindly revive the order because of my lord. That was I have already.
What is the reason given here in your application? We have to be satisfied for that. You cannot at your whim tweak an order of the court. You can modify an order of the court. The order is very specific. In default, it will stand vacated, automatically vacated. What huge financial stringency? What do you do?
Financial problem, my lord.
Everybody has a financial problem. We also have financial problem. You also have.
My lord, the appellant is running a only tea stall, my lord, on footpath. And the
Tea stall footpath, do you know that tea stall footpath can take you up there?
my lord, it's very small. My lord,
Then you don't have any overhead expense and you are earning the entire income.
my lord, I have
Only
not-
the tea leaves and the kettle and those things. You don't have any, you don't pay any overhead expense as in a shop. The earning is more. Tea stalls are very, I mean, not rich, obviously, but not so much so that you cannot pay.
I have paid, my lord, already paid, my lord. Kindly consider this, my lord. Otherwise, my lord, I shall be vacated, my lord.
Yes, obviously, you shall be. That is the purpose.
I have paid, my lord, already paid, my lord. Kindly see when I have paid, my lord.
Now the entire dues you have cleared.
Yes. And the excess amount.
Yeah, they have paid the entire dues still.
They have paid, my lord, but they are from the very first day they have delayed it. If your lordship kindly comes to page 14, the first payment was made on 11/3, which was beyond the time. The second payment again beyond the time.
Excess
Each and
amount
every
has
payment
been
is beyond the time.
month of October, I have paid excess amount.
Excess amount because you did not pay previously. You have covered that.
Thereafter, my lord, for the month of November, I have also paid in the month of October. What was the amount I have available, my lord, I have paid, my lord.
Yes, we'll extension, there is no scope.
My lord, deliberately, I have not, my lord.
No, deliberately was not the purpose of the, even unintentionally, if you did not pay, then also it will stand. No, we cannot, we have to reimpose them.
Yeah, my lord.
When is it next due? 10th of each month?
10th of each month.
10th, you have paid for November?
Yes.
Already paid for November. When? Yesterday?
No. That is, my lord.
10th.
Yes, Mr. They will reimpose.
leave it to your lordship.
What about the appeal? The records have come.
Record has come.
You have prepared the paper books.
My lord. It is waiting for paper.
What is waiting for paper? You have to prepare the paper.
Yes,
Go to the department, take a notice and prepare the paper book.
At the earliest, my lord, I should.
What is required in a second appeal paper book?
First appeal.
Oh, this is first step. Then sometime. We are reviving, reimposing rather. Heard learned counsel for the parties. The application has been couched as one for extension of an interim order dated February 18, 2025. Push of learned counsel for the appellant, for the defendants stroke appellants submits that due to financial stringency, the appellants could not pay the occupation charges, which was imposed as a condition of grant of stay by this court, in time on certain occasions, but have subsequently made preemptive prior payments for future months as well. In any event, it is submitted that up-to-date payments have now been made in respect of all the months in question. Next para, learned counsel appearing for the plaintiff stroke respondent controverts the allegation and submits that the appellants have been recalcitrant in payment at every stage, having made payments mostly beyond the stipulated period of the 10th of each month. Full stop. Next para, that apart, for some months, the appellants defaulted altogether, upon which the respondent moved the executing court, which is the only stimulus for the appellants being prompted to move the present application and clear off the due payments. Full stop. Next para, as such, it is submitted that the application may be rejected. Full stop. It is further pointed out by learned counsel for the respondent that as per paragraph number 12 of the order of stay dated February 18, 2025, passed by this court, in default of any of the payments as directed, either current or arrears, the stay order was to stand automatically vacated without further reference to the court. Thus, it is submitted that there is no question of extension of any order which has already lapsed. Next para, upon hearing learned counsel, we find that definitely the appellants have occasioned delay in payment of some of the installments and even stopped payment for a period of time, thereby inviting the penal rigors of paragraph 12 of the order of stay dated February 18, 2025. Thus, technically speaking, there is no subsisting interim order of stay, since the appellants were in default, and in terms of clause 12, the stay order stood automatically vacated. Next para. However, considering the yardstick of proportionality, it would be a heavy penalty on the appellant in the event the stay order is not reimposed / revived, despite the appellant now seeking to pay all installments in time and having already made good the deficits in payment of the previous installments, which would entail the eviction decree being executed and the appellants being ousted from the suit property even during pendency of the appeal. Keeping in view such considerations as well as the financial stringency pleaded by the appellants, Can 3 of 2025 is disposed of by molding the relief sought therein and reimposing the order of stay dated February 18, 2025 till disposal of the appeal, subject, of course, to the riders as imposed while passing the initial order of stay dated February 18, 2025, the appellants shall, in terms of such directions, go on paying occupation charges at the rate of rupees 20,000 per month by the 10th of each month, starting next from December 2025 and thereafter by the 10th day of each succeeding month. It is further clarified that in case of one more default in making such payments, the stay order this order of reimposition of stay shall again stand automatically vacated without further reference to the court, and the appellant shall run the risk, in such event, of the stay order not being further revived or reimposed by the court. No orders to cost.
I'm grateful to your lordship. My lord, only one thing, my lord. May my learned friend hand over a communication to me showing that they have paid the occupational charge for the month of November, because we have not received it.
The learned advocate on record for the appellant shall furnish documentary evidence to the learned advocate on record for the respondent to show the payment of rent for the month of November 2025. For the succeeding months, your client will because they will be unnecessarily burdened with that. The advocates. Only for November, please provide them the whatever. কি বলছে তন্ময়? Yeah.
In item number 31, I am for the respondent. Lordship, my instruction is that my client has fully received this petition, Lordship. So I have not.
When did you send?
My third November.
3rd November.
My lord, it was
Right
14th
instruction.
date, 1 week.
File the affidavit.
The affidavit is not completed as the track is not.
They're
available.
appearing. File it whatever there is.
The track is not available, man.
Because
Due to
Lord,
the server.
Say that and affirm it. They're appearing. There was a direction for. Is it affirmed or not affirmed?
Not.
Learned counsel for the respondent submits that the copies all the applications you have received.
Yes, Lordship.
That copies of all the applications have
Except
been.
Lordship memo. Memorandum.
Memo was not directed. That copies of all the applications have been received by the respondent only yesterday and seeks an adjournment. Which of since, comma, on query of court, comma, learned counsel for the appellant submits that copies have been served only on when November 3rd. On November 3, 2025, comma, the matter is adjourned for a week and shall next be listed on November 17, 2025 under the same heading. Next.
At 32, I am for the appellant.
Yes, please. Section 5.
Yes, my lord, can you see last order?
No, section 5 was allowed.
No, section 5 is pending.
Section.
Oh, delay in filing opposition was called. This is a reply.
Yes. Sir.
What is the delay?
204 days.
204. Appeal is against?
Against the expertise decree of the board.
You have remarried, Mr. Shen?
No, my lord.
There is stay so far as the.
No.
There is a stay. No, stay could not be. Section 5 is not.
By way of.
We had. So can, who is that condonation application? What is the ground for delay?
Delay, my lord,
Came to know later.
My lord, I came to know in the month of November 2024, my lord. Thereafter, I took certified copy.
You had appeared in the suit initially?
Yes, my lord. I appeared.
Then
the suit, my lord, filed written statement. Written statement filed in the year 2013. And my lord, up to 2022, my lord, I appeared. But matter was transferred from first ADJ first court to ADJ second court. That was not knowledge of the LNA.
that was not their doing. It is the court's administrative transfer.
Initially, my advocate and also the advocate of the husband.
If you see the diary of the trial court, you would find that out. How could they find out? It's an administrative transfer.
It appears from the order, my lord. None appeared before the second judge.
But they subsequently appeared and got a decree.
Well, the expertise that I without the
Expertise, no. Expertise means your justification is that it was transferred from the second additional to first additional.
First additional to second additional.
This is Barasat.
Barasat, no, Barakpur.
Barakpur now, yes.
Barakpur.
Barakpur.
And second additional, my lord.
Second additional.
My advocate failed to appear.
Yes, Mr. Shen, what is your opposition?
They did not deliberately appear because other proceedings are going on. 125 proceedings are going on.
They're appearing there. No, there no second. First to second was not there in those.
No, first to second was not there. My lord will kindly see, my lord, suit was decree and the section 5.
She's the wife. Even if you impose cost, Mr. Shen, that will have to be paid by you.
This absolutely malafide application, my lord. Why I say so, my lord? 26th of June 20.
What are your respective ages? I mean, 2013 suit. What is the age of your client? Or 4750. 47 for the lady, you must be what? We don't know.
Around 50.
Your opposition will say that.
50. Yeah, about 50.
That must be about the same age. 52 years.
26th of June 2024, my lord, suit was decreed expert.
Is there any issue of the marriage?
No.
Marriage was solemnized in the year 2010.
But on the ground of nullity.
Oh, nullity. Nullity for what? Non-consummation.
That was not
expertise degree.
But fact remains, my lord, 26th of June 2024, my lord, suit was decreed ex parte. In the month of August, my lord, 6th August 2024, my lord, husband filed a, my lord, the affidavits of assets in the 125 proceedings. They are, my lord, we specifically mentioned, that the suit and the connected execution application pending in the connection with the pending suit has been dismissed, my lord.
Have you got a copy of that or annex that?
That I have, my lord.
Show me that. Show us that.
My lord, that is in the affidavit in opposition, my lord.
Yes, we are there. Which page?
Page 28 is the our affidavit, my lord. My lord will
Show us that disclosure.
my lord, page 29, my lord. Page 29, my lord. If so, provide particulars thereof along with the copy of the order is perused. Mat execution dismissed by the second learned second judge, second ADJ, Barakpur. Here, my lord, we have specifically mentioned the mat suit and the execution has been dismissed.
Dismissed, yes.
But they did not.
No, this is mat execution dismissed.
No, on the same day, my lord, mat.
That you have not disclosed here.
My lord, mat execution dismissed. Thereafter, my lord, they should have taken steps. My lord, that is my
Mat
point.
execution, what is mat execution?
Mat execution, my lord,
On payment of alimony.
24, my lord, alimony was granted.
That is
They
my
filed-
Mat execution dismissed does not mean mat suit has been dismissed.
On the same day, the mat suit was dismissed.
Maybe. So what?
They were not diligent, my lord. That is what I am trying to, my lord, submit, my lord. On 6th of this is on 6th of August 2024, my lord. They say they came to know on the last week of November 2024. Almost, my lord, 6 months. Thereafter, my lord, they have provided a medical certificate.
No, the decree was passed when? Date of decree?
Date of decree was passed 26th of June 2024.
26 June. So 6th of August, 6th of August, you this affidavit of assets was filed.
In the 125 proceedings.
In 125.
125 proceedings saying that the mat execution has
This, yes.
my lord.
Last week of this November, how did they come to know according to them?
That has not been stated. That is also our point. Where they came to know, how they came to know, that has not been
Where have they stated that?
My lord, in my paragraph.
Paragraph?
My lord, paragraph 6, my lord.
6. Oh, sorry. I was looking at the other one.
Can 2, my lord.
Yes, I was looking at the no. Paragraph 6. Yes. How did you come to know your
Before that, my paragraph 5.
paragraph 5? Yes. How did you got the information that it was dismissed for decreed ex parte?
From the learned advocate.
Don't understand. He did not have any information of the suit. But when your suit was not on the board of the first additional court, you must have inquired where the suit went.
About 1.5 years, my lord.
One thing, sir. One thing. From first additional court, it was transferred to second additional court. Very good. There must have been. It was in the first additional court.
Yes,
so you must have taken information about what happened to the suit when it is not on the board of the first additional court. It could not have disappeared.
It is.
So it's anybody's child's play to know which court it has been transferred to. Your own suit, you don't. Their suit, you don't know.
That is on the part of the learned advocate of the wife.
No. That is not.
Kindly see, my lord.
That is not.
My lord. Can 1, my lord. Can 1 injunction application. I annex the order. Page 17 onward.
What is the laches?
My lord, laches, my lord. Initially, my lord, case was transferred from first court to second ADJ. Second ADJ, my lord, initially learned advocate of the.
We don't understand how he came to know. How your advocate or you came to know. You have said you've come to know on November.
Come to know, my lord.
In the last week of November.
Last week of November.
So convenient to say that, but how did you come to know? That you have to know.
November, my lord, last week of November contacted his advocate. And
so you did not contact in between?
before that, my lord.
So if you did not contact, it was your lack of diligence. For 1 year, you did not contact.
Came to know that expertise judgment and decree was.
Yes, you did not contact your advocate for over a year.
Before that,
Yes. 204 days.
204 days.
You did not contact throughout this period. Your advocate was not contacted by you.
I contacted last week of November 2024, my lord.
Before that, what were you doing? Sleeping over your matter. Why didn't you contact that? Therefore, it's your lack of diligence. You did not contact your advocate. Your advocate obviously lost interest.
Advocate also did not appear, my lord.
Why should he appear if the client does not have any interest in the matter?
My lord, case was.
Don't blame advocates unnecessarily. Tomorrow your client will blame you.
It is latches on the part of.
Let
the
us dismiss your application. You just see what your client says about you.
It is latches on the part of the learned advocate of the wife, my lord.
No.
About one and
We are
a
not
half year,
talking.
That is also not stated, my lord.
Latches
My
because
lord,
you have not paid your advocate, not contacted your advocate. For obvious reasons, latches. You don't find the time to meet your advocate. Not a single averment of what you are doing throughout this period of 204 days. Not a single averment. You had taken information or contacted him or her, whatever. Nothing. Nothing. You cannot take it so casually now. The present jurisprudence is different on this, on section 5. Not previous as previously. Not so liberal now.
my lord will kindly consider, my lord, page 8 of that application, my lord, the certificate obtained. Certificate says, my lord, he has stated suffering from hepatitis, viral hepatitis, since 4/1/25, this 4th of January 2025. She was under my treatment. She was advised to take rest at home for 8 weeks, dated 6th of January 2025.
After receiving the certified court.
My lord, only to obtain, my lord, the order of from this court, my lord, this certified this.
Who does not do that?
Before that, my lord,
But
We will not will gloss over those things.
some authenticity must be there, my lord.
What authenticity?
But
Section 5 authenticity.
Fourth, and for 8 weeks it is.
and my lord, in the written statement, categorically, my lord, denied the allegation, my lord. Why?
Generally, in written statements, we deny allegations.
And but my lord,
You did not do a favor to your client.
Unfortunately, my lord, case was transferred from first ADJ to second ADJ.
Please don't mention that time and again. You won't know, your advocate won't know. Your advocate's clerk would know, your entire chamber should know. They won't know if you don't contact over a period of 1 year. If the client does not feel about contacting the advocate, why he must lose in. If your client did not contact you for 1 year, you would lose interest in this application. That we can assure. We are finding you here because your client is now contacting you.
Even my lawyer also did not inform you.
So easy to blame on an advocate. Serve a notice on that advocate. We'll hear that advocate. Sorry. You have been constantly blaming the advocate. We'll give a notice to the advocate in the trial court.
That is why
No, sorry. You have not named the advocate, but we'll direct you to serve a notice of a copy of this application on that advocate. Very well. Serve a copy of this application. The affidavit in reply filed today be kept on record. Full sub next para. The plinth of the allegations made in the application for condonation of delay is that the learned advocate appearing for the appellant in the trial court at the relevant juncture was negligent and did not take information that the suit of the divorce suit of the plaintiff stroke respondent had been transferred from the first additional court to the second additional court of district judge.
Additional district judge first court to additional district judge second.
This of additional second court of additional district judge at Barakpur. Full stop next para. Subsequently, as per the averments made in the condemnation application, the petitioner came to know about the dismissal of the suit. Full stop next para. Learned senior counsel appearing for the respondent submits that in the interregnum, on August 6, 2024, an affidavit of assets was filed by the respondent husband in the proceeding under section 125 of the Criminal Procedural Code, where it was disclosed that the matrimonial execution case filed by the appellant had been dismissed. Full stop, next para. However, comma, despite the same comma, the appellant did not take the trouble of inquiring into the matter. Full stop, if such inquiry was made even at that juncture, comma, the appellant would have easily come to know about the dismissal of the suit itself. Full stop, next para. It is further submitted that the medical certificate annexed to the application for condonation is an eyewash. Full stop, next para. Upon considering the averments made in the application under section 24, section 5 of the Limitation Act, comma, we find two serious flaws, FLAWS, flaws therein. For the first, comma, the entire blame has been sought to be cast on the learned advocate appearing for the appellant in the trial court, trial court, and secondly, comma, the source of knowledge of the dismissal of the suit all on a sudden in the last week of November 2024 has not been clarified. Full stop, next para. Insofar as the first flaw is concerned, comma, the said learned advocate is not represented before us, comma, nor has any notice of the serious allegations made against him. Full stop, it has become a convenient ploy in present times to cast the entire aspersion upon the learned erstwhile advocate who represented the litigant filing the appeal late, comma, taking advantage of the fact that such advocate is not represented before the court and cannot answer the blame leveled against him, stroke her. Full stop, next para. We are not sure as to what prevented the advocate from taking a basic information as to the administrative transfer of a case, comma, unless the petitioner herself was negligent in not contacting her advocate. Full stop, next para. Also, comma, not a single line has been expended in the application to indicate that the petitioner, comma, throughout the prolonged period of delay of 204 days ever tried to contact her advocate to take information about the suit pending against her. Full stop, this also indicates that the petitioner herself might have been negligent in conducting the litigation. Full stop, next para. As to the second ground, comma, unless the court is aware of how the petitioner learnt about the dismissal of the suit in November 2024, comma, it would not be possible for us to ascertain as to whether the petitioner could have got information of such dismissal even prior thereto from the same source, comma, which would have overwhelming effect on the outcome of the present application. Full stop, next para. In all fairness, comma, a copy of the application for condonation of delay is required to be served on the learned advocate who had appeared on behalf of the appellant in the trial court and against whom the aspersions as mentioned above have been cast. Full stop, accordingly, the petitioner shall serve a copy of the Can 2 of 2025 on the learned advocate who had appeared for the petitioner in the trial court during the relevant juncture, comma, against whom the allegations have been leveled in the said application. Full stop, such service shall be effected within a week from date, and an affidavit of service in that regard shall be filed on the returnable date. Full stop, the matter shall next be listed on November 25, 2025 under the heading applications. Thank you.
I'm for the appellant.
What is the matter about?
I have deposited the Tolobona and others.
This application for stay.
Can
What is the decree for?
Decree for divorce.
For divorce. So we had granted ad interim stay.
Ad interim injunction.
Injunction.
Yes, my lord.
Then we will
Already
dispose of.
passed.
I'm for the respondent husband and he has not contacted with any marriage till date. So, my lord,
So we'll extend the stay till disposal of the appeal. We have already passed directions for, we have put in the Tolobana and
Yes, my
they're appearing.
Yes.
Special messenger cost you have put in?
Yes, my lord.
Very well. Learned counsel for the appellant wife submits that the appellant has already put in Tolobana and written up notice form, as well as deposited the special messenger cost for bringing the trial court records pursuant to the previous directions of the court. For some next para, the respondent husband is also represented through counsel before us. Full stop. The present appeal has been preferred against a decree of divorce. Full stop. The learned advocate for the respondent husband submits that the respondent has not contracted any remarriage in the meantime.
May I interrupt, my lord? I have paid the Tolobana postal cost and written up notice. That is, I have
Tolobana postal cost and written up notice form.
Written notice.
Postal cost and
that was the previously your lordship passed order on 4th November.
not necessary. Next para. Since arguable questions of fact and law are involved in the appeal, the respondent husband shall remain restrained by an order of injunction from contracting any remarriage during pendency of the appeal. Can 1 of 2025 is disposed of in the light of the above observation without any order as to costs. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
I'm good.
Next. Yes, Mr. Das, what is the matter?
We are the legal heirs of the original defendant, in a suit for specific performance of contract. Now, there is a delay. There is a delay of 813 days. Now, my learned friend has filed an opposition. This is my reply. Last occasion, my lordship had granted us leave to file an application seeking special leave to appeal. And that has also been filed. No, my lord,
Initially, that application was not filed.
not filed, my lord. Thereafter, my lord, we have filed it.
We advise them without remuneration.
Lordship.
Yes.
Now, my lord, the facts are, my lord, it's in a suit for specific performance.
What facts? First, you have to overcome this hurdle.
No, my lord, that
Why the delay?
My lord, delay is, my lord.
No, facts are necessary. You're right.
My lord, facts are, my lord.
Say we won't know.
The suit was filed on 7th of December 2020.
Not the details. What was the suit for?
So it was a suit for specific performance of a contract.
They obtained a degree.
He obtained a degree.
Against that you have come up.
Yes.
You are third parties.
Third parties because, my lord,
You
the
purchased.
original defendant Gopal Chandra Ghosh, he died. My lord, we are the widow and daughters of Gopal
Died
Chandra.
after the decree.
After the decree. But, my lord, what had happened was,
what is your locus standi? You are the
my lord,
purchases from
the widow of Gopal and 2 married
His
daughters
heirs.
of Gopal. Now, my lord, the thing is, my lord, the suit was instituted on 7th of December 2020. My lord, 11 days prior to filing of that suit on 25th November 2020, my lord, Gopal Ghosh, my lord, he was a septuagenarian. My lord, he faced an accident and my lord, had an pelvic girdle fracture. So, my lord, he was completely bedridden. But, my lord, only one thing, my lord, through a learned advocate, my lord, he filed a vokalatnama, entered his appearance in the suit, but thereafter, my lord, the written statement was not filed. The legal heirs of Gopal did not know about the pendency of the suit because they were busy behind their father. My lord, Gopal died 1st of October 2024, which is much beyond the judgment and decree. We come to know about the suit, my lord, when my learned friend takes up, files an execution case, and the execution case summons us served upon us.
When was the decree passed?
Well, a decree was passed on 4th of May 2023. And, my lord, the execution case summons, I have categorically pleaded that, my lord, we have received it, my lord, sometimes in June 2025, and immediately we have taken steps to file this appeal.
What do you say?
But everything had happened during his lifetime. He appeared, he engaged a lawyer. Thereafter, he chose not to appear before the learned court below. On 4th of May 2023, decree was passed. The learned trial judge was compelled to pass ex parte degree.
Now we are only on the delay in filing the appeal. Had these heirs ever signed any document on behalf of Gopal Ghosh?
Deceased was
the only defense against this sort of plea is that one of them had filed some affidavit or filed some verification.
That is not
It is
there.
not
The
there.
entire order sheet, it's not there.
Probably he has executed one vokalatnama in favor of the learned advocate. He appeared.
That probably.
But that was by Gopal.
Yes,
Was by-
all about Gopal. He's
Right.
speaking about
And
Gopal.
we have annexed the entire medical treatment documents of Gopal. If your lordship takes up, my lord, the
What is
application,
which is the application for condonation of delay?
well,
Two.
condonation of delay is can 2.
And one is leave.
One is, my lord, the 3 is leave, and one is the application for stay, because, my lord, the execution case 1st of December is the date fixed.
It was the
Degree for
desire of
specific
the
performance.
The specific
it was
performance.
the desire of the coordinate bench when the matter was taken up
To take
by
out a market value of the property, lordship would find in a
relevant point.
earlier order.
On the
My
last
lord,
occasion only he produced the present market value before your lord.
because, my lord, this Harkel
Circle.
rate in the year 2020 in that registry is not available, because, my lord,
The purpose was to see whether you are ready and willing.
yes.
But if you had preferred that appeal, we would look into that. You have got a decree already. If you grant them stay, that is not necessary. If you allow these, that would not be. If your suit for specific offense was dismissed and you had preferred an appeal, definitely we would ask you to show your readiness. But here you have got a decree, we won't take you to that through that exercise at this stage at least. But this about this section 5 plausible ground, good story has been written, so that should be honored.
No, but we have documents in support of it. We have annexed documents.
No,
That kindly,
documents have been obtained. We
Documents
should
have
honor
been
them.
annexed, no detail.
rephrase
Actually, how
after.
he was suffering, nothing, no specific averment in the section 5 application.
70-year-old man, pelvic girdle broken.
Okay.
How?
But his
How
family
can you
members were
explain? I mean,
there.
how can you improve upon his
Now,
suffering?
now they are coming to this court. Now they are coming to this court. At the relevant point of time, they should have taken appropriate step in absence of the only member.
When did you file the execution case? Whenever they got the notice of the execution case,
then
they have
they-
come up.
then
Within
yes.
2 months, they have come up. So that is sufficient. Can 2 of 2025 is an application for condonation of delay in preferring the appeal. Full sub next para. The appellants argue that the original defendant, namely Gopal Chandra Ghosh, was aged about 70 years at the relevant point of time and had suffered several ailments. Full-stop, the said defendant was under treatment for such ailments, the genesis of which was a sudden fall, which had FLL fall, which had fractured his pelvic bone, rendering him completely bedridden on November 25, 2020. Next para. The suit was filed thereafter in December, on December 7, 2020. Although the original defendant, Gopal Chandra Ghosh, somehow managed to have a vakalatnama filed in the suit through his advocate, thereafter he could not contest the suit and ultimately died on October 1, 2024. Next para. The present appellants, who are the heirs and legal representatives within bracket family members, bracket close, of the said deceased original defendant, had no inkling of pendency of the suit or the ex parte decree at any point of time, nor had they any knowledge of the defendant having entered appearance in the said suit. Only upon getting notice of the execution case sometime in the month of May 2023, where did the appellants become aware of the ex parte decree for the first time. Immediately thereafter, they took steps and contacted advocates, upon which the appeal was preferred on August 4, 2025, as soon as this memorandum of the same was prepared and settled. Next para. Thus, it is submitted that there was no fault on the part of the appellants in preferring the appeal late. Learned counsel for the respondent,
that's sole respondent.
Sole respondent, by placing reliance on the affidavit in opposition of the respondent, categorically controverts the allegations made. It is submitted that the appellants are feigning ignorance, although they could not have been unaware of the pendency of the suit against them during the relevant point of time, even if the defendant was a septuagenarian and was suffering from ailments, comma, there could not be any credible reason for the present appellants not being aware of the pendency of the suit or the ex parte decree. Full stop. Next para, having not taken any information regarding the suit, comma, the appellants are, comma, it is submitted, comma, guilty of negligence. Full stop. Next para, upon a perusal of the averments made in the condonation application, comma, the affidavit in opposition and the reply, comma, we find sufficient convincing reasons for the delay in preferring the appeal having been made out. Full stop. There is nothing on record whatsoever to indicate that any of the appellants, comma, despite being the family members of the original defendant, comma, ever took any steps in the suit or took or made any application in the suit and or entered appearance or had any pleading filed on behalf of the defendant, comma, which might have created an apprehension of knowledge on the part of the present appellants regarding the pendency of the suit. Full stop. Next para. There could not be any conceivable reason for the appellants, comma, despite having knowledge of the decree, comma, to sit tight over the matter over a prolonged period if they had knowledge of the ex parte decree. Full stop. Next para. The first document which may indicate knowledge of the ex parte decree being attributed to the appellants is the notice of the execution case, which was served somewhere in the month, at some time in the month of May 2023. Full stop. Since the appeal was preferred within about 3 months thereafter, comma, which is a reasonable period, keeping in view the time taken for engaging an advocate and having an appeal prepared and filed, comma, we are of the opinion that convincing and sufficient reasons for the delay have been made out. Full stop. Accordingly, can 2 of 2025 is allowed, comma, thereby condoning the delay in preferring FAT 362 of 2025. Full stop. No order as to cost. Full stop. Can 3 of 2025 is an application for leave to prefer the present appeal. Full stop. The appeal arises out of an ex parte decree of specific performance in a suit instituted by the respondent against one Gopal Ghosh within bracket deceased, since deceased, bracket closed, comma, the predecessor in interest of the appellants. Full stop. Next para. The said during the lifetime of the said Gopal Ghosh, comma, the said suit was decreed, and as such, comma, the appellants were never parties to the suit or the decree. Full stop. However, comma, since the appellants are directly appellants are directly affected by the outcome of the impugned decree, comma, which would go adverse against them, comma, it is evident that the appellants have a strong right to prefer the present appeal. Full stop. Hence, comma, can 3 of 2025 is allowed, thereby granting leave to the appellants to prefer the present appeal. Full stop. Next para, in view of you have a stay application.
Yes, Madam, I have a stay application.
Can 1.
Can 1.
Yes, we are granting stay. Since questions of both fact and law are involved, comma, can 1 of 2025 is allowed, thereby granting stay of operation of the impugned decree till disposal of the appeal. Full stop. Next para, in view of the appearance of the sole respondent through her learned advocate, comma, service of notice of the appeal on the respondent is dispensed with. The trial court record shall be brought by special messenger at the cost of the appellants to be deposited within a week from date. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Full stop. Liberty to the parties to mention the appeal for hearing as and when the same is made ready for such hearing.
Great.
Thank you.
Number is
My lord, I am applying for the appellant, my lord.
Yes.
Filing this affidavit also.
Proper service effected?
Yes.
My lord, I am for the respondent.
No, only one, both respondents?
Both respondents.
Yes. What is the matter about?
This suit was appeal is against the final degree in the partition suit both
What is your ground?
ground is the
You did not prefer any challenge against the preliminary degree.
yes preliminary degree
You failed there.
yes preliminary degree challenge, but I at that time the final disposal of the appeal pointed out that the entire property should be partitioned because only the residential purpose
No, the first appeal preferred against the preliminary degree is still pending
no disposed of
on merits.
on merits.
So therefore, the shares of the shares of the parties are final.
Yes, in respect of the residential person.
So what is your ground of challenge against the final degree?
Final degree, the in respect of the schedule A, which was allotted to the plaintiff number 1,
Yes.
but there is lathe machines about value of 30 lakhs. So this point was not reflected in the report of the Learned Partition Commission.
Rent receipt of 30 lakhs.
Yes, my lord.
They received rent.
No, machines, there were also business, lathe machines.
Business was also joint.
Yes,
that was the subject matter of the decree of the suit. The business.
No, this was not implemented in the schedule.
You cannot take that point at the final degree stage because the preliminary degree has already attained finality and the right title interest has been declared.
Yes,
so that has attained finality. You cannot reopen that now.
Particular at page 66 of this honorable court, page 64, starting page, of the stay application,
Yes.
Paragraph 13.
Yes.
In the event the commissioner already appointed has submitted a report as regards the partibility of the suit property, the trial judge may proceed to decide upon the same after hearing any objection from the respective parties. If the report of the commissioner is acceptable to all parties, it may be proceed to pronounce final degree of partition. So the appellant was not agreed and filed objection before the final decree, and at page 74, page 73 starting point.
Yes, 74.
74, my lord.
Yes.
Paragraph 4. That it is pertinent to mention hearing that the plaintiff duly admitted in their plain case that the premises is a partly 3-storied and partly 2-storied building, and the predecessor in interest of the parties to the suit during his lifetime had been doing or carrying on business under the name and style of spare parts, covering the entire ground floor of the suit house, where there was and are still lying different tools, articles, machineries, and many raw materials for the said business. The predecessors in interest of the parties to the suit died, leaving behind him his wife. Later died 3 daughters. That is the parties to the suit. But so there are in the ground floor. So there is so many lathe machines.
So what?
So the
lathe machine might have been purchased by them.
No,
just because they're lying in the joint property doesn't mean it belongs to both of you.
No, parents, this is parents.
Evidence was never laid on that.
No, the property was related to the deceased parents, leaving behind the said properties.
But in the preliminary degree stage, at the preliminary degree stage,
that is residential power accommodation only.
Preliminary degree cannot be for a part of the suit property. Preliminary degree covers the entire suit property.
No,
there cannot be preliminary degree for a part.
Entire suit properties were not included in the pleading.
You should have taken that point. You might and ought to have taken that. Then you are barred by constructive res judicata for not raising that issue. Because when a suit is filed for partition, at that point of time, all the common joint properties have to be brought within the hodgepodge. Cannot take that once a preliminary degree is passed, the right title interest of the parties is declared there, and the shares are also declared. If the shares are declared after that, you cannot reopen that issue and say all properties were not brought in, all joint properties. At the final degree stage, your only scope is regarding the commissioner's report, if some part has not been allocated
Yes.
or extra part has been allocated to somebody, this is the only, but it has to be within the framework of the preliminary degree. If your first appeal against the preliminary degree failed, you cannot go beyond the preliminary degree. Whatever property was declared in the preliminary degree, within those shares, the commissioner has to make allocations only. So you cannot go beyond the preliminary degree by saying that other properties were there which are left out. Because you are barred by res judicata now. Since the final degree, preliminary degree-
Honorable Supreme Court, judgment.
There's nothing in the first appeal. Why should we admit
This,
it?
this property was not included in the plain. Particular paragraph
Give the citation to your learned friend also.
2009, 2009, 9 Supreme Court cases, case 52. Paragraph 21. Here defendant number 4 was the appellant. 21 onwards, my lord.
There the preliminary degree was challenged. Come to para 9.
Yes,
Precisely what we are saying.
but this
Preliminary degree challenge, there two issues were framed, whether the suit is bad for partial partition and whether judgment of degree. So partial partition has to be taken at the outset. There the preliminary degree was challenged, it was upset and sent back, saying that this question was not rightly decided. That is our point precisely. Here the preliminary degree has attained finality. If you have not taken the point of partial partition, you cannot reopen that in at the final hearing stage, final degree stage. Because it's res judicata as regards the issues decided in the final. And by virtue of constructive res judicata, you are now debarred from raising the objection of partial partition. At that point was not decided that it's bad for partial partition or not, because you did not take the point. Clearly barred by explanation 4 of section 11. Of
during the
CTC.
pendency of the appeal, my lord, the appellant my lord, also raised before the learned trial court, my lord, can you see at page 54?
Learned appellate court.
No, trial court. Only the
During pendency of the appeal, how can he raise? Oh, acha. In the final degree proceeding,
before the
you cannot raise that.
but the learned trial court directed, my lord,
Where?
for the present, my lord.
What are you saying? The
Page
judgment or your application?
No, the order of the learned trial court at page 51. Starting at page 51.
Partial partition was raised. This objection was raised in the in the suit. An issue was framed on that.
No, the before submission of
Before
the report
preliminary,
of the
before preliminary degree, it was not raised.
No.
Now you cannot raise. Partial partition.
At page 53, my lord, at the bottom.
53.
Yes, at page 53 at the bottom. This bottom two lines. This court.
Yes,
this court thinks that it would not be wise to interfere with the commission work in respect of allocation of ground floor of the suit property, but the defendant has option to give a suggestion in this regard to the appointed partition commissioner, and I think it will be proper to adjudicate this matter.
What was this petition for? This
But
was
in
your
this-
petition.
In respect of this,
What was the prayer made in the petition? Appointment of partition commissioner. No, you asked for that the partition commissioner may be directed not to allocate any share in respect of some portion. That spare part where those are lying. You cannot reopen these issues after the preliminary degree. Sorry.
but entire lathe machine will be.
Lathe machine, you are there throughout the period. Why didn't you raise the point before the final degree?
I
preliminary degree was-
appreciate, Mala. I appreciate.
Not your fault, but your client should have raised this before the court ruler. You cannot improve your case here.
Now,
But this point was never taken during pendency of the suit before passing the final preliminary degree. Even in the appeal against the preliminary degree, did you take this point? We don't think so.
No, before preliminary degree, this was not so.
Not no. The appeal against the preliminary degree also did not take this point. You could not have, in fact, because if you did not order for 27, you could have maybe or amendment of pleadings, but you never took this point throughout the preliminary degree proceedings. And now it has attained finality.
Now, my lord, decide, my lord, whether the further, my lord, the separate partition should maybe requirement of
Partition, we don't know.
in
It's a
respect of the residual properties would be
But this issue
feasible
has
or not. This is my lord.
You know the answer. We should not advise you. Isn't
Oh.
partition a continuing cause of action? But after it has, this issue was never raised by you. That is the difficulty. You have created your own complication. Anyway, we'll not dismiss your appeal right now, but we'll not grant to stay. We'll say no prima facie case.
As you lost.
At least you'll have some chance of going before a better court.
At the time of hearing, whatever.
Yes. So are you opposing what we are saying?
Yes, ma'am.
We are saying
No.
the present appeal arises out of in the present appeal, comma, the defendant in a partition suit has challenged the final degree of partition. For some next para, the primary ground taken in the appeal is that certain portions of the property and in certain portions of the property, comma, several machinery and other equipment were lying, comma, which were not within the purview of the partition suit, comma, although those are common ancestral properties of the parties. First up, it is argued by learned counsel for the appellant that as such, comma, the partition commissioner's report should have reflected those portions of the property. First up, it is further contended that the partition suit itself is bad for partial partition. For sub next para, learned counsel submits that admittedly certain business was run from the property. Full stop. Thus, comma, it is argued that the machinery involved in the said business ought to have been brought within the hotspot of the suit. Full stop. Next para, learned counsel appearing for the appellant places reliance on the judgment of R. Mahalakshmi versus A.V. Anantaraman and others, reported at 2009-9 SCC 52, in support of the proposition that if a suit is bad for partial partition, comma, the same, a partition suit is bad for partial partition, comma, the same should be formulated as an issue and the suit dismissed on such ground. For sub next para, learned counsel for the respondents controverts the said submissions and argues that the partition commissioner acted well within the four corners of the preliminary decree, comma, the appeal against which stood dismissed. For sub next para, আচ্ছা প্রথমেই করে দিই affidavit service file to be given. Next para. On a consideration of the submissions of the parties, comma, we find that in the preliminary decree, comma, the title of the parties and their respective shares in the suit property was clearly declared. Full stop. An appeal, a first appeal was preferred against the same by the present defendant stroke appellant, which met with dismissal on merits. Full stop. Next para, thus, comma, the final decree, the preliminary partition decree has attained, sorry, the preliminary decree has attained finality. Full stop. Next para, the issue of partial partition, comma, if taken by the defendant, comma, ought to have been raised at the initial stage of the suit, comma, to enable the court to frame an issue on the same and the plaintiffs to controvert such issue upon citing evidence if necessary. Full stop. Having not done so till passing of the preliminary decree, comma, the appellant, the defendant stroke appellant is barred by the principle of constructive res judicata from raising the same. Full stop. Next para, the concept of a preliminary decree in a partition suit is that although the suit remains pending for further formalities, comma, insofar as the issues involved at the preliminary decree stage are concerned, comma, including the respective title and shares of the parties in the suit property, comma, the said the decision on the same reach a terminus with the passing of the preliminary degree and cannot be reopened later. Full stop. Next para, since the trial court's preliminary degree has merged in the appellate court's decree, comma, the same cannot be reopened at the final degree stage. Full stop. Next para, as discussed above, comma, the issue of partial partition cannot now be raised by operation of the principle of res judicata, and comma, as such, comma, cannot be a valid ground for preferring an appeal against the final degree proceedings. For sub next para, insofar as the judgment cited by the learned counsel for the appellant is concerned, comma, the same was rendered in the context of a preliminary degree of partition, and comma, at that stage, comma, the issue of partial partition was given was taken into consideration by the court, and the decision passed thereupon. Full stop. As opposed to the same, comma, in the present case, the preliminary degree has attained finality and cannot now be reopened. Full stop. Next para. Hence, we do not find any prima facie case for grant of stay. Full stop. Accordingly, can 1 of 2025 is dismissed on contest without any order as to cost. Full stop. The final degree proceedings shall accordingly continue. Full stop. Oh, sorry, that has also been over. Stays very well. No further. You will bring the trial court records by special messenger. In view of the appearance of the respondents to the learned advocate, comma, service of notice of the appeal on the respondents is dispensed with. Full stop. The trial court records shall be brought by special messenger at the cost of the appellant, comma, also to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Post up liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Thank you.
Very
Sorry.
much grateful.
Sorry. Yes. You argued very well, but can't help you.